I declare open this meeting of the Senate Economics Legislation Committee. The Senators referred to the committee the particulars of proposed expenditure for 2021 to 22 and related documents for the Treasury Portfolio and Industry, Science, Energy and Resources Portfolio. The committee may also examine the annual reports of the departments and agencies appearing before it. Questions on notice. The committee has set 4 November 2021 as the date by which Senators are to submit written questions on notice, and 9 December 2021 as the date for the return of answers to questions taken on notice. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. Officers and Senators are familiar with the rules of the Senate, which govern estimates hearings. If you need assistance, the Secretariat has copies. In particular, I draw the attention of witnesses to an order of the Senate of 13 May 2009 specifying the process by which a claim of public interest immunity should be raised, and which I now incorporate in Hansard. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. An officer called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphone. Please make sure all mobile phones are switched off or turned to silent. I remind Senators and witnesses in the hearing room that microphones remain live unless I instruct otherwise, for example at suspension or adjournment. For witnesses participating via video conference, please mute your microphone as the default and unmute your microphone when speaking. I ask members of the media to follow the established media guidelines and the instructions of the committee secretariat. As set out in the guidelines, Senators and witnesses' laptops, mobile phones, other devices and personal papers are not to be filmed or photographed. I remind everyone in the gallery that they are not permitted to speak or interfere with the proceedings or with witnesses at any point in time during the hearing. Security is present and they will be asked to remove anyone who does not follow these instructions. Witnesses and Senators who are seeking to table documents during the committee's hearing were requested to provide an electronic copy of those documents the day prior to the hearing so that the documents could be circulated electronically during the hearing. Please liaise with the Secretariat if you need assistance. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure the Supplementary Budget Estimates 2021-22 hearings are conducted in a safe environment. This guidance is also available from the Secretariat. I draw your attention to the QR codes available at all wait rooms. Witnesses, observers and staff are encouraged to use the codes before entering rooms to allow a full record of attendance to be kept. The committee appreciates the cooperation of all attendees in adhering to these arrangements. The committee's proceedings today will commence with the Treasury Portfolio, beginning with the Australian Securities and Investments Commission and the Australian Prudential Regulation Authority. The hearing will then follow the order as set out in the circulated program. I now welcome the Senator, the Honourable Jane Hume, Minister for Superannuation, Financial Services and the Digital Economy. I also welcome the Chair of the Australian Securities and Investments Commission, Mr Joe Longo. Hello, Chair. Minister, Chair or officers, would you like to make an opening statement?
No, thank you, Chair.
Okay. Mr Longo, do you have an opening statement to make? Or would you like to go to questions?
Good morning, Chair. I won't be making an opening statement. Happy to go straight to questions and be of whatever assistance we can to them.
Okay. Thank you very much, Chair. Senator McAllister, you have the call.
Thanks very much, Chair. We've got obviously a lot of information that scans via phone and email and social media are increasingly a problem. Is it your assessment that this is getting worse and worse every month?
I think that question, Senator, I'll ask Commissioner Armour to take that question in more detail. You'll be aware of some recent initiatives ASIC has taken in that connection. But just one broad observation, the question of scams has been with us for years. It's an ongoing and very difficult problem. But I'll hand over to Commissioner Armour, who's been doing some work on pump and dump schemes in particular.
Actually, Senator, you're raising an interesting question. When we
when we actually look at the reports that we receive of misconduct from various members of the community, there was a significant increase in reports of misconduct in the 2021 financial year. But interestingly, since about April this year, we've seen a steadying of the numbers of reports of misconduct. So that is quite interesting. And so, if you like, the trajectory of increasing reports of misconduct has slowed down. Though we have observed increases in particular types of scam behaviour, and obviously one of the areas that the Chair just mentioned that we're particularly concerned about is activities on social media platforms which are looking at things like what we call pump and dump scheme.
Ms Armour, it would be useful to understand ASIC's role in this. I understand that other regulators and policy agencies have a role, but could you just describe for me the way that this interacts with ASIC's remit?
Yes, so ASIC's role is essentially following up scams that affect the laws that it administers, and that, as you'd appreciate, actually, is it possible for whoever's turning their pages over just to move away from the microphone? It's quite hard to hear.
Sorry, Commissioner, I'll out myself.
Okay, thank you very much. I'm sorry, it's always a bit awkward.
It's all right. The chair is the chief rustler, but I didn't hear that last.
Okay, no.
Inter alia.
I just didn't hear that last answer, Commissioner Armour. Would you mind just telling me again what ASIC's remit is, like what particular part of this puzzle you are responsible for?
Yes, so the particular part of the puzzle that we're responsible for is largely scams in the financial sector.
Right.
Scams that affect financial sector. Will be other scams that come within the laws that we administer, but that is largely the main area. And we work closely with the Australian Consumer and Competition Commission, who actually also have a remit to look at scams, and they have a more whole of economy focus, but we do work closely with them.
Right, so when you say financial sector, you are talking essentially about investment scams. Is that an accurate characterisation?
Yes, that is an accurate characterisation.
And so when you were talking earlier about the trajectory of growth in terms of these kinds of scams, is it correct to understand that it is investment scams that you are talking about, and that has been on the increase for the last 2 years, notwithstanding a recent levelling off on the rate of growth?
Yes, I think that is a good way of characterising it.
Right. Is it correct to understand, you mentioned pump and dump, but is crypto the other area where we see scam activity from ASIC's perspective?
Yes, we have had reports of a significant number of reports in the last 2 years on crypto asset scams, yes.
And in short, what is the nature of that activity? I'm not asking for a detailed description of the case study, but in the broad, what do we see? Where are the vulnerabilities in terms of crypto?
It really is, one of the issues is platforms that are operating, particularly from other locations outside of Australia, purporting to make available crypto investments to Australians, and often those investments not materialising or not being made available, or offering investments that actually relate to crypto assets but fall within our regulatory remit. So, derivatives over crypto assets for which there's a requirement that there be licence.
Right. And does ASIC have the powers and resources that you need to address this emerging area of vulnerability?
To some degree. One of the issues, and I know the recent Select Committee on Technology and Australia as a Financial Centre looked at this. One of the issues for us is that not all crypto assets fall within the laws, the descriptors, if you like, of the laws that we administer. So that creates an issue because we can't take action against all types of crypto asset scams, which a consumer may think of as an investment product, but actually the way the way they actually work is that they're not within the legislation.
Right. And has the Minister, the Assistant Treasurer, Mr Sukkar, requested any briefing or information from ASIC on investment scams?
I would actually have to take that on notice, Senator. I know we have provided some briefings on scams to various ministers, but I really would have to take it on notice. I don't have that in front of me.
Yeah, I'd be interested to understand whether or not Minister Sukkar has requested a briefing and separately whether or not you have provided any briefings. You understand the distinction?
Yes.
Yes. How often, and perhaps let's say over the last 12 months,
Okay.
to make that an easier question to answer.
Okay. Thank you.
If I report a new investment scam via your website, will you share that information with other agencies? For example, the ACCC Scam Watch team, the AFP or their enforcement agencies, ACMA. Who gets the information if a scam is reported to you?
Yes, I do believe we will share when we see the issue as one that's relevant to another agency. And I'd just ask Warren Day just if there's anything additional there that we need to add to answer the Senator's question.
Thanks, Commissioner Armour. Senator, Warren Day, for the sake of Hansard, Warren Day, Chief Operating Officer at ASIC. In our process of receiving those reports of scams, the assessment will always include what other regulators, what other government agencies, both domestic and overseas, may need to know about that scam, given the issues that are raised. So we do refer matters, obviously, to AUSTRAC, we refer matters to the ATO, we refer matters to the ACCC, we share information with ACMA, but as I said, we also share information with our international peers, certainly where the information provided to ASIC might indicate that they are operating outside of Australia.
And in terms of that collaborative relationship, how often does ASIC meet with the ACCC in relation to scam activity?
We have ongoing liaison with the ACCC and, if you like, more formal liaison meetings probably every couple of months about these things. But our teams are sharing information, weekly, I would say, about a number of these matters.
And have you had any meetings with Treasury about these issues?
Look, not to my knowledge, but I'll have to take that on. Well, actually, there's been some discussions with scams at Treasury, but I have to take on notice the details of that, Senator.
Could you please provide information about the number of occasions that you've met with Treasury to discuss these issues in the last 12 months?
Certainly.
And can I just ask whether you have met, whether this has been considered by the Council of Financial Regulators?
So, Senator, perhaps I can help. It's Cathy Armour again. So at the Council of Financial Regulators, we actually have a working group that is specifically looking at crypto assets and stablecoin matters, and that working group is looking across the whole financial system at the issues that are posed in relation to these particular new technologies and new methods of facilitating business.
Okay, so there's a specific focus on crypto across the different regulators. Can I ask, though, about scam activity, which is obviously somewhat broader?
Yes, so specific when there isn't a broad looking at scam activity, if you like, that the looking at it in relation to crypto assets is incorporated into the particular work stream there, but it's more looking from a holistic financial system perspective.
Right, so a focus on crypto, but at this point the Council of Financial Regulators is not looking at scams.
That's my. There's not a specific working group.
Understood.
If you like.
Understood. Look, just finally, given the increase in scam activity, has ASIC been provided with any increase in funding or resources to deal with increased investment scam?
We have not applied for discrete funding for investment scams. We have, as you'll be aware, over the last period since 2019, early 2019, had significant increases to our funding, and particularly to our funding for enforcement matters. But we haven't made a particular application, as far as I'm aware, and I'm not sure if any of my colleagues have better understanding, but I don't believe we've made a particular application for increase for funding for scams.
And if I might assist, Senator, I mean, what Commissioner Armour says is correct, but internally within ASIC, obviously, our enforcement teams are starting to work on more scam matters that have been raised where we see an opportunity, and they're not, as Commissioner Armour covered previously, there's a number of scams that we just can't access because they're overseas, and they're very difficult to effectively engage with because they're highly mobile and they move on. But where we have opportunities domestically, we've got our enforcement teams now starting to move towards taking on more investigations in that space. We're also issuing more warnings than in recent years to the public about offshore scams, and all of those are available through our MoneySmart website and our ASIC website. So the things that we can do, we are starting to do more of those things.
Okay, thanks very much, Chair.
Thank you. I have... Oh, sorry, you're right. Yep. Chair Longo, I've got just a few questions. There's quite a few senators who are seeking the call, but I just have two areas I'd like to touch upon. The first is in relation to the ASX outage, which occurred in November 2020, and you've given previous evidence to committees in the Parliament with respect to the significance of that outage. A summary of an independent report into the outage has been released by ASIC, and I commend ASIC for doing that. As I understand it, there is a review being undertaken, or an investigation, whatever term you want to give it, in relation to ASX's compliance with its licence conditions in relation to that outage. And I'd like an update from you, if I could, just in relation to the progress of that investigation.
Thank you, Chair. That investigation is ongoing, but I can tell the committee we are expecting to bring it to a conclusion fairly imminently. We are getting cooperation from the ASX, which has helped us get through the issues we have to look at more quickly. But I can reassure the committee it remains a matter that's getting urgent attention, priority attention. We're expecting to get to reach a result in that matter imminently. There's a process we have to follow, and as soon as I'm able, or the Commission's able to make an announcement on the result, we will.
Okay, thank you. So I don't want to preempt the findings of ASIC in this regard, but if I could, and tell me if I'm overstepping the mark here, but if I could ask whether or not any of the investigations or considerations of ASIC with respect to its findings will have any implications potentially with respect to the CHESS replacement project. And I raise that on the basis that the the analysis of the results of the independent report into the ASX outage did have some implications with respect to the CHESS replacement project, and you appreciate that the CHESS replacement project is a project of great significance for the Australian financial market infrastructure. So if you could just advise whether or not there might be any implications arising for the CHESS replacement project and how that's governed or progressed arising from the report which will be imminently released.
Thanks, Chair. Clearly the CHESS project is probably the most fundamental project the ASX has in the next 2 years. And I think it is a reasonable expectation that what will come out of this matter will include some expectations on ASIC's part about the governance around CHESS. But at this stage, how it's actually going to look, how that's actually going to work, remains a work in progress. But I can reassure the committee that CHESS is very much part of our concern in concluding our investigation. And as I said earlier, ASX has been cooperative in that respect.
Right. And just my final question in relation to this area before I move on to my second topic. You will also be aware that there's been some public debate with respect to what level of public reporting there should be, or public release of information in relation to these matters in terms of the ASX outage last November, and also with respect to the CHESS replacement project. In particular, questions have been raised with respect to whether or not the independent report that was undertaken with respect to the ASX outage should have been released to the public in totality, and there's interest with respect to the release of any information to market participants with respect to the progress of the CHESS report. So my general question is ASIC considering the legitimate expectations of market participants who will be impacted by the CHESS replacement project and the information requirements they should reasonably expect with respect to the progress of the project and any issues with respect to the project?
Yeah, thanks, Chair. I'll ask Commissioner Armour to supplement my response, but I think a key feature of where we land will be transparency. And so we will be ensuring that whatever arrangements or governance changes that are put in place coming out of ASIC's investigation will give the market and the general community transparency into what ASIC is doing and the issues facing. I think that answers your question, but I don't know whether Commissioner Armour you'd like to supplement.
Yeah, perhaps just to supplement, Chair, by mentioning that in relation to the CHESS project, there is already a governance process which includes a number of committees, including a business committee, which does have representations of the various stakeholders in the equities market, so that they can get the information they need in relation to the CHESS project. We've been attending those meetings to ensure that there is the degree of transparency and information sharing that has been required. The feedback we have at the moment is that we haven't always had feedback that the information sharing has been the way all the participants would like, but the feedback we have at the moment is that seems to be working quite well, but it is a matter that we are following and will continue to follow. Okay,
thank you, Commissioner Armour, and I congratulate ASIC in relation to the steps it's taking in relation to this matter. My second area of questions, and Chair, I'm going to be very impressed. I'm sure you're up to date with the latest developments in terms of corporations law and proposals with respect to different sorts of organisations. And no doubt you're aware of what is becoming known as the Bragg report, the outstanding report, which has been prepared by the FinTech RegTech Select Committee out of the Senate, which is an outstanding piece of work, and I compliment Senator Bragg on it, and also the Secretariat, who did wonderful work in relation to it. The concept of decentralised autonomous organisations has been raised as a proposal, recommendation coming out of that report, and it's been identified by a number of stakeholders that Australia has a real opportunity here to recognise or legislate for decentralised autonomous organisations. And I just want to quote from the FinTech RegTech report. There's lots to quote from it, but Herbert Smith Freehills in relation to this matter said, and I quote from paragraph 3.162, HSF suggested that the introduction of a DAO limited entity in the Corporations Act would provide, appropriate corporate oversight and guidance for a new business model manifesting in the digital economy and provide clarity and recognition as to the crossover between digital assets and DAOs and how their integration into existing regulatory regimes should be facilitated with an eye to both functions, end quote. Chair Longo, I'm just wondering if ASIC has done any work in terms of considering that sort of model and any general observations you might have in relation to the outstanding work that committee undertook.
Well, thanks for that question, Chair. Sharing your view that report is groundbreaking and a significant contribution to the policy debate and dialogue that now has to happen. And I think that's my first point. Decentralised autonomous organisations are a unique, curious entity. And as far as I know, I think only the state of Wyoming has actually put them into law. So we have a lot to learn about how DAOs work. And so there are some very significant issues to think through. And so, from a regulatory perspective, we have had many challenges over many hundreds of years dealing with corporations and how we make corporations accountable and how we think about corporate misconduct and how we regulate corporations. So we welcome the debate and the discussion about DAOs, but I think there are some very significant challenges ahead of us to figure out how to regulate. And it's with corporations, at least, we think that there are people behind the entity. We call them boards. But boards don't exist with DAOs. They're a combination of smart contracts and artificial intelligence, and how we think about regulating them is really ahead of us. Certainly an issue that ASIC has been starting to think about, and we look forward to working with Treasury and other government as a whole and other regulators to see how this new form or grouping can be part of the future in dealing with crypto. I think they're the main points. I might just pause there. I know Commissioner Armour has done some work in this area, but she might want to supplement.
No, I really don't have anything to add. I think it's an area that we really need to think about in the future, and it does pose some really interesting philosophical questions for the way in Australia we regulate organisations like companies and other organisations, because it's a sort of it is a very different focus from an individual accountability, as the Chair mentioned.
Okay.
Yes, for example, Chair, how the FAR regime might apply to a DAO is an interesting question. So if something goes wrong with the DAO, who do we talk to?
Yeah.
So I think there's a lot of potential there, but also a lot of work ahead of us to engage with this idea, which is clearly getting traction among the international academic community and in Australia. So we look forward to being part of that.
Excellent. Thanks very much, Chair. I might, just because I've been talking about the Bragg report, I might just give the call to Senator Bragg at this moment to ask some questions, if I could. Senator Bragg.
Okay, thanks very much, Chair. I just have two lines of inquiry for ASIC. The first is in relation to misleading and deceptive conduct. I note that ASIC has a regulatory guide, RG 234, which deals with advertising financial products and services. And as part of those guidances and as part of the corporation's obligations not to mislead or deceive consumers, I just wanted to ask about a couple of current cases. there is a super fund called EISS, which has had quite a lot of media and publicity around some of its governance issues. I'm not going to ask you about that. But this organisation has been saying that if you're with this fund, your super is in safe hands. I'm just wondering if that is a turn of phrase that ASIC thinks is consistent with that regulatory guidance.
Thank you, Senator. I don't know whether Senator Press might have a view on.
Senator.
Chair, I think we have problems with
Looking
the sound.
at EISS across a number of different matters as
Oh, excuse me. So sorry, we're just having trouble with the audio. So if I can ask everyone to just make sure they're muted. We've had feedback problems over the last day or so. So can you? I'm not sure what that means, but
Possibly turning off the camera is the other thing that's worked in the past.
oh, if they turn off their camera.
If the,
Yeah.
yes, a poor
Okay.
connection perhaps.
All right. Could the witness hear us now? Can you hear us?
It's Commissioner Press.
I can.
Commissioner Press? Thank you.
It's Danielle Press. Senator Bragg, we are
That's better.
looking at a number of issues in relation to EISS, as is APRA. I would have to take away on notice those exact words as to whether or not
Okay.
we
Okay.
at those.
Okay, well, I can supply that to you.
Will
Wanda.
they- Please, and then we can have a look.
Yeah.
And I think it will be a question of whether or not it would meet a legal standard of misleading and deceptive. I'm not sure.
Okay. Well, I want to ask you about, there's another umbrella organisation called Industry Super Australia, which is being advertising to consumers that if you invest with these funds, you're in, they're saying, good hands. And they have been using money to widely publicise a comparative tool for some years, which is called Compared the Pair. And as part of this comparison, which I imagine would be subject to your legislative obligations to ensure that consumers are not misled or deceived, they have, as far as I can see, included in this comparison two funds, one fund called Lucroof and one fund called Maritime Super, which were the two of the three worst ranked funds out of the almost 100 funds in APRA's performance tests. So given that these are widely publicised adverts, have you made any inquiries as to whether or not these particular funds are part of that comparison?
Senator Bragg, we have not looked directly at whether those two funds are indeed part of that comparison. The work that we've done on the Industry Fund Super advertised more around general comments that they're making, and the general comments and the general data that they are using are indeed accurate.
Okay, and so you have made inquiries as to the quality of the data?
I need to take on notice exactly what exactly the details that we've made, but we have looked at those advertisements historically.
Okay, because if these funds are being held out as being in good hands when they're the worst performing funds, I would have thought that would be misleading and deceptive.
Again, Senator Bragg, I'd need to take on notice exactly what that question, if you wouldn't mind me coming back with a more detailed answer after speaking to our enforcement people.
Okay, well, we'll provide you that on notice. We'll give you a lot of information on that. Finally, if you don't mind, if I just finish my line?
If you could, I do need to share the call around, but please.
Yeah, I just wanted to ask you about this insider trading business that you put out a release about yesterday. So, is ASIC saying that? I'm wondering whether or not I'm saying
Who
things
are you
that
addressing?
annoying you.
Maybe to the chair. This question.
It's hard to know
Senator
with
Bragg?
all the cameras. I mean, usually this is sort of
Senator, please pose your question, Senator Bragg, and between
Okay.
Danielle Press and I will answer it. But
Thanks.
I will be directing that question to Danielle Press.
Thank you, Chair.
Sorry about that.
I mean, usually it's like the Brady Bunch when you can see everyone. It's sort of a bit of a diminished episode. I
Totally
think, today.
understood.
But look,
Totally
I just wanted to. I'll just ask a simple question. I'm just wondering if you can update the committee on the statement you put out yesterday about the super funds engaging in insider trading. Please explain to us what on earth is going on and what you're going to do to stop this.
Senator Bragg, thank you for the question. We have looked at a number of trades and switches that super fund executives and board members have made. There is a technical matter here that this prohibition only applies if there's an acquisition or disposal of a unit, and a switch generally in a superannuation fund is not actually an acquisition or a disposal of a financial product. So under the Courts Act. So therefore, the insider trading laws, if you like, don't actually apply in general to a switch. What we are doing and what we have looked at is the conflicts policies, and we believe that conflict policies are lacking in many cases, and we are working with the funds, with APRA, who also have a role in conflict policies, to ensure that they are improved. And finally, there are a number of cases where we are looking to see if there is any law that they may have breached, including improper use of information, but we are still investigating that, and there's not much more I can say about it.
All right.
Okay. Thank you, Senator Bragg. If I could give the call then to Senator O'Neill.
No, I think Senator had questions. Thank you. First of all, could I just note that the government came back to the PJC committee requesting an extension on the OPD, which was motion 1249, with regard to Sterling, the Sterling collapse. ASIC has been ordered by the Senate to produce documents regarding these inquiries made by and actions taken by ASIC in regard to the Sterling Group. There are 4 documents that have been identified as relevant. At this point of time, we're 2 days past the due date for the documents to be produced. Could we possibly have an update on the timeline for these documents being handed to the Senate?
Thanks for that question, Senator. My understanding is we wrote to Senator Hume asking for more time. There were a number of issues that we needed to work through before we could hand the documents over. I don't have a specific day in mind that we'll be doing that, but I don't know whether our General Counsel, Mr. Savandra, can give us any more. I think we were needing about a week to complete our processes.
Sorry, I just missed what you said then, Mr. Longo. Your meeting when, did you say?
I think we will need a week or so to complete our processes, because as the letter points out, we've referred aspects of the matter to the Commonwealth Director of Public Prosecutions. There are named individuals in the material, and we're just working through a process to ensure that the integrity of our ongoing investigation and that referral isn't undermined. We're certainly going to produce the documents, that we just need some time to work through any need for very specific redactions. But I might hand over to Mr. Savandra in case I've got any of that.
Thank you.
Thank you, Senator. I think we're working as quickly as we can, given the issues that Mr. Longo referred to. I would observe that the documents that have been requested cut across a current ongoing investigation, and as Mr. Longo says, we have referred a brief to the Commonwealth Director for assessment. That investigation is ongoing. So ASIC is likely, through the Minister, to make public interest immunity claims over the document through redactions. This will take some time, and it's necessary for us to therefore consult with people who we assess will be materially adversely affected. We're hoping that we'll be able to complete that within the next week, but we're working as quickly as we can. So, Senator, without making any commitments, I would hope that we would be able to produce the document during the course of next week, at the latest the week after.
Sorry to interrupt you, Senator O'Neill. I've just got a logistical issue. I've just been advised by Broadcasting, Commissioner Preece, it's your camera which apparently is the gremlin in the system. So if I can just ask you to turn your camera off and please stay with us, but that's what I'm advised by our technological assistants. Senator O'Neill.
Thank you, a critical intervention. So, Mr Savundra, thank you for your response. But can I point out that the Senate has already ordered that these documents be provided. I mean, that is the will of the Senate. You have indicated that you are in the process of constructing a public interest immunity claim, but we have not received that. On what grounds are you likely to seek a public interest immunity from releasing these documents to the Senate?
Senator, a number of grounds, but and I don't unfortunately have the relevant parliamentary rules in front of me, but one is that it may impact or prejudice an ongoing investigation. It may affect or interfere with a future enforcement action, and thirdly, it may interfere with, if there is any prosecution, fair trial of individuals. So we have in our letter to Minister Hume, which Minister Hume has written to the President of the Senate, set out why we require more time. And it does say, if I read from the letter, it says that the documents contain information disclosing the identity or information enabling a person to ascertain the identity of a number of third parties, including persons of interest, reporters of misconduct, whistleblowers, witnesses, and other persons assisting ASIC. ASIC has not had the opportunity to consult with third parties referred to in the documents that may be materially adversely affected by the disclosure of information that may damage the personal reputation and privacy of those persons. And the second is that they may prejudice, one, ASIC's investigation, two, any future prosecution of breach of the law, and three, the fair trial and impartial adjudication of a future prosecution. In the letter, we articulate and reference the relevant parliamentary rules. Most of that language that I've just described to you is really repeating back grounds within the rules making public interest immunity claims, Senator.
Chair, I have both of those documents.
So
the letter from ASIC
I actually
in
have
front
them
of
as
me.
well, thank you.
Oh, you don't need me to table them?
If you want to table them for people for ease
Would you
of
like me
access,
to table them,
it's not a
Chair?
I think that'd be useful,
Yes.
Minister.
However, I do want to point out that the senators here that I'm in good company with receive confidential information all of the time. And we receive information that we deal with in a confidential way. There is really no reason why, in the interim, while you consider whether these documents should be publicly made available to the entire Senate, that they could not be made available to this committee or the PJC in confidence for us to be across the matters?
Senator, would be happy to consider that request, but certainly that's a very different proposition, providing documents in confidence to a committee rather than having the documents tabled publicly in the Senate.
And can I point out that the reason that so much of this public pushing for documents is because there is just a culture of secrecy and containment where we can't get our hands on documents that we need to do our job. So can I encourage you to continue to meet the order of the Senate, noting that it's already passed 2 days past the due date for those documents to be produced. I personally believe that the claims of public interest immunity are somewhat spurious, but that's up to a further point down the track for the Senate to determine its response to that. But in the interim, given the large number of inquiries around Stirling and for senators to be aware of what's happening, can I encourage you in the interim to provide the PJC certainly, and this committee, if it's of interest to the committee, of those documents in confidence?
Yep.
Senator, happy to consider that. What I would say is ASIC wishes to be as transparent and open as possible with the committee, but as I noted, we are a law enforcement agency, we're a criminal law enforcement agency, and all we're wanting to do is ensure that public disclosure doesn't interfere with that important work.
Yeah, and it's up to the committee to determine whether that claim is valid or not, so we need that documentation. Thank you.
And Senator O'Neill, just one quick follow-up question on that, and I'll direct this to Chair Longo. Chair, are you aware that there has been a referral to a reference committee in relation to the Stirling matter, and that a request is being made of ASIC to make a submission in relation to that important references committee matter?
Senator, I think you can be assured I'm very aware of that inquiry, and will be obviously fully cooperate with that inquiry when the time comes in a few weeks. I have heard your question correctly. The Senate inquiry into Stirling.
Correct.
So can I just indicate 2 lines of questions I'll have to put on notice? The first one is with regard to the much claimed enormous amounts that financial institutions have declared that they have put aside to repay to the Australian people who were ripped off in the way that was documented well by the Hayne Royal Commission. So my questions, and I'd be appreciative of a prompt response to this, go to the financial compensation that's actually been paid to the Australian public by those financial institutions since announcements from 2017. So who's got how much money, and what are the gaps essentially? And the other line of questions on notice really are with regard to Nuix. I'm very keen to know how much money has gone to persons of interest who have been identified by ASIC, and any action that you've taken to extend the ban on the former Nuix CFO Stephen Doyle's passport, because I understand that's coming up for renewal right now. So that's kind of a timely one. If you could give me anything on that, I'd appreciate it.
That last one, Senator, I think is that's been extended till early next year, but I will I'll be able to get back to you fairly quickly on that last point.
Thank you.
Senator McKim, can you hear me?
I can, Chair.
You have some questions, I understand. You have the call.
Thanks very much. Can folks hear me okay?
Yes.
Thank you. I just wanted to ask about the widespread cheating at KPMG Australia on their independence exams. So KPMG Australia was fined $450,000 by the US Audit Watchdog, Public Company Accounting Oversight Board. What action, if any, has ASIC taken against KPMG Australia?
Senator, it's Sean Hughes, and for the record, Commissioner at ASIC. We have followed with interest the PCAOB review of KPMG. Our sense at this stage is that we do not have a regulatory hook or mandate to take action against KPMG in relation to the matters that were looked at by the PCAOB, because the rules that establish the PCAOB's jurisdiction over those matters is entirely different to ASIC's mandate. We register individuals to conduct audits, and the particular matter that was reviewed by the PCAOB related to internal training, and that does not give rise to a breach of the Corporations Act, which would enliven our jurisdiction. So at this stage, we do not see any opportunity for us to take action. We are, however, closely engaging with the relevant accounting bodies, with CANZ and with CPA as well.
All right, thank you. So an Australian company has been fined by an overseas watchdog for cheating in Australia, and yet because we don't have an adequate regulatory mandate in Australia, the Australian watchdog, appears to be unable to take action. Can I ask, is this an issue with an act of Parliament, or is it an issue with something which sits at a lower level than legislation?
So, Senator, whether the Corporations Act is adequate or not to deal with this particular issue is a policy matter for government. What I would say is that the particular matters that were looked at by the PCAOB related to internal training and the conduct of that training and the performance by certain individuals within a firm. They did not relate to the performance of an audit, and it is that matter which ASIC has jurisdiction over, amongst others. Now, of course, the professional bodies themselves, CAANZ or CPA Australia, could of course choose to take their own action, but we can only enforce the laws that we have.
No, I understand that, but if you've got an Australian company, like this involved over 1,000 partners and staff at KPMG Australia, the cheating happened in Australia by over 1,000 partners and staff of an Australian company. If the legislation is inadequate, why has ASIC not gone to government and asked government to improve the legislation to provide ASIC with a regulatory mandate in these areas? Or is it just going to be just let it go and it's fine for one of the big four accounting firms in Australia to blatantly cheat in the way that over 1,000 of them did?
Well, Senator McKim, I don't think anything in my answers would suggest that it was okay. In fact, we view the conduct with, I think, the same disappointment that you've expressed, but that it would be unfair or inaccurate to say there's been no response. The PCAOB is the appropriate body that has exercised its jurisdiction to take action against the individuals involved, and KPMG itself has responded to that in terms of its own internal staff disciplinary action. It did not, I can only repeat, it did not relate to the conduct of an audit or other matters over which ASIC has jurisdiction. We don't have the power. Whether we should have the power is a question for the government and ultimately the Parliament.
I appreciate that. Thank you. Has ASIC asked the government to create that power for ASIC by legislative amendment?
I'm not aware, but I'd like to take that on notice and confirm back to you so that I can give you an accurate answer, Senator.
Senator McKim, sorry to interrupt you. We are over time now for this session. Do you have one final question you could maybe ask?
Yeah, just on a different matter, Chair, if I might, and it goes to the ASIC announcement that it's not going to pursue criminal action against AMP for charging clients for doing nothing, in other words, fees for no service. Can I basically ask why ASIC is not pursuing criminal charges against against AMP, and if you've had, whether you sought advice from the DPP on this, and any other any other information that you are able to provide. And I guess I'd put a corollary in if the laws are inadequate. I asked the same question I did in regards to the previous matter. Has ASIC asked the government to tighten up the laws so that action can be taken against AMP for charging fees for no service as found by Commissioner Hayne?
Yeah, thanks for that question, Senator. I'm going to ask Deputy Chair Court, who chairs our Enforcement Committee, to answer your question. Thank you.
Thanks for the question, Senator McKim. I'm going to give you my best answer, and any of my colleagues can jump in if I'm getting my matters confused, but my recollection on the AMP fee for no service matter that arose out of the Royal Commission is that we did a detailed investigation of that matter. We investigated the potential for criminal charges. That investigation was referred to the Director of Public Prosecution, so the answer to that part of your question is yes, but that ultimately the Director elected not to lay charges. Now that would have been dependent obviously on the particular facts and circumstances of that case, but certainly it was investigated fully for the potential for criminal charges to be laid.
Okay, thank you. Thank you, Senator.
Yeah, thanks,
McKim.
Chair. I'll just indicate I'll put some further questions on that matter in on notice.
Okay, thank you very much. Now, Senator Roberts, I know you have some questions. We are running over time, unfortunately.
Yeah, I can be pretty quick.
You can be pretty quick and put the balance on notice?
Yes.
Thank you.
Yes,
Thank
I
you.
can. Stirling First victims paid hundreds of thousands. First of all, thank you for attending today. Stirling First victims paid hundreds of thousands of dollars up front, believing they would essentially receive a 40-year lease in return. This would appear to be a long-term lease where the victims are better classified as tenants instead of investors. Can you explain why someone in this situation would be classified as an investor instead of a tenant?
Senator, I will try to answer that question right now, but can I just go back to the exchange I had with the Chair? There is an inquiry into these matters before the Senate in a few weeks, and ASIC will certainly be addressing all these questions very comprehensively then. For today's purposes, it's certainly true that they were tenants, but many of them invested in order to pay for their rental, if I can use that word, in their capacity as tenants. They made investments in preference shares or managed investment schemes of one form or another. And so for today's purposes, if I could just answer your question in that general way, they probably wore two hats. They were a tenant, but in order to pay for their rent, they made investments which was intended to create a cash flow to pay for the rent. Now, we know that all ended very, very awfully for those people, and we will definitely be exploring this in much more detail during the inquiry. So I hope that suffices for today.
That I can understand your position, and that does suffice for today. So they're wearing two hats. So the investor hat, aren't they required to be provided with a product disclosure statement?
Yes.
Okay.
Yeah. If it's a managed investment scheme that's been registered in accordance with the Act, they ought to have been provided with product disclosure statements. And as the inquiry...
Thank you.
As we work through the inquiry, we will be making submissions about PDSs and what we found and what we did in connection with stop orders. It'll all be part of the submission we make in order for a comprehensive story.
Thank you. So you're aware that the Stirling First victim did not get a PDS. And what's the current status of your investigation? If you could just tell me in detail.
Yeah. Can I just go back to your earlier question? I'm not saying today whether they did or didn't get PDSs. This is very fact sensitive. I do acknowledge they should have got PDSs, but I'm not sure what the position was with individual investors. If you don't mind me.
Senator Roberts, sorry to interrupt, but we are over time.
Could I just ask one question to the Minister?
Okay, sure.
Yeah. Minister, did the government conduct an internal review of the way ASIC handled the Sterling First case?
No, Senator, because that review is on, that investigation is ongoing.
Thank you, Mr Longo. I appreciate your answers.
Okay.
Thank you,
Senator. Senator Chisholm, you want the call?
Thanks, Commissioner Longo. Will ASIC become more business friendly under your leadership?
Well, the implication is that business is going to get a free pass to do the wrong thing, not be followed up. The answer is absolutely no. What business can expect from ASIC is essentially what the government has set up in its statement of expectations and in our statement of intent. We are a business regulator. Part of our job is to encourage business, is to encourage consumers. And so there is a facilitation aspect to our mandate. But we remain absolutely committed to the enforcement part of our mandate, which has come up a couple of times this morning. But I think you can expect ASIC to remain very active in making corporate Australia accountable for misconduct.
ASIC has several key governance documents: a corporate plan, a statement of intent issued by the Commissioner, and a statement of expectations issued by the Treasurer to ASIC. Given that ASIC is an independent statutory body, does the Treasurer's statement of expectations bind ASIC in any way?
Well, the government's entitled to express its expectations within the broader regulatory framework we operate under. ASIC is an independent regulator. We're accountable to Parliament. We're accountable in all sorts of ways, parliamentary hearings like this one. And so I think it's absolutely the expectation of government that we remain independent, and that in fact is in the letter of expectations itself. It is the prerogative of government to express its views on policy to us, and indeed under the PGPA Act, myself and my fellow commissioners are required to discharge our duties in a manner that doesn't contradict to the policy of the day. So it's a nuanced operating environment, if I can put it.
It's notable that the Treasurer's new statement of expectations has no reference to the Banking Royal Commission. The previous statement indicated that ASIC should use its full regulatory toolkit and directs a substantial portion of its resources to surveillance and enforcement. The new statement of expectations says ASIC should minimise the costs of regulatory requirements for regulated entities and consumers, and doesn't mention enhancing consumer trust or responding to misconduct. What do these change expectations mean for ASIC?
Yeah. To be the document the way you do, there are several aspects of this document. It's actually the shortest.
Sorry, Chair, you're just breaking up
I think
again.
it makes the virtue. Yeah.
You're just breaking up again.
Sorry,
if you could
shall I go off video? Do you think that?
Yeah, why don't you go off video? That'll probably assist, please.
I was just trying to say, Senator, that the statement of expectations, as you'll see, is a very short document. It's very high level, and it's the Treasurer's document, and he chose to cast it in that way. And our statement of intent was similarly brief and high level. I and the Commission do not take from it, I think, the premise of your question. So in other words, I don't see any part of that statement of expectations as sending a message to be less active. I see ASIC's enforcement mandate is absolutely fundamental. It's in our statutory objectives, and we do not read what's in the statements of expectations as sort of diminishing or diluting any of that. As I said earlier, I think the message is a bit more subtle and nuanced. We have a very complex range of objectives, statutory objectives, and they range from being business facilitative and encouraging confident participation of consumers to taking enforcement action when that is warranted and necessary. So I hope that answers your question. I'm not trying to avoid it.
Chair, just to clear and to put it on the record, the statement of expectations actually says at paragraph 3.8 that in achieving its objectives and carrying out its functions and exercising its powers, the government also expects ASIC to identify and reduce misconduct risk through well-targeted and proportionate supervision, surveillance and enforcement activities. So it is in fact included in the statement of expectations.
Thank you, Minister. Senator Chisholm.
Thanks. ASIC's new corporate plan has no mention of the previous Commissioner's why not litigate approach to enforcement activity. Why is that?
That concept came out of the Royal Commission. It is our view, and I'm going to ask Sarah, getting a lot of interference, I'm sorry. I'm going to ask Deputy Chair Court to have a go at answering that question, but essentially we see it as an incomplete statement of ASIC's approach to enforcement. Of course, we're going to keep litigating, and indeed we may very well see more litigation rather than less. But what matters is that it's the right litigation, is that it's targeted, that it's proportionate, that it has impact, so our commitment to enforcement and litigation is not going to change. We just see the why not litigate is just being an incomplete way of thinking about enforcement and the various issues we need to take into account. But if it's okay, I'll ask Deputy Chair Court, who chairs our Enforcement Committee, to complete that response.
Thanks for the question, Senator Chisholm. All I will do is echo the words of Chair Longo. I mean, we very much acknowledge the significant attention that has been given to this issue, the moving away from the why not litigate phrase. And, we are acutely conscious that it seems to be being interpreted as potentially sending a signal that ASIC's going to have a softer, if I can use that description, enforcement regime. That's not the case. And both Chair Longo and I have been at pains to make clear at every opportunity that litigation and court enforcement outcomes and pecuniary penalties are going to remain a critical and significant part of the regime. The main point that we are trying to make, though, is that we do have a range of effective tools to address misconduct, and we need to make sure that we use that full regulatory toolkit that the Parliament's given us. Now, that includes litigation, it includes referrals to the DPP for criminal matters, but it also can include, in appropriate cases, enforceable undertakings and infringement notices. And since the Royal Commission, ASIC's use of those other tools has become very small. So we just simply cannot litigate all matters, nor should we. We need to keep litigating and litigating in a robust, strong way those cases that demonstrate significant misconduct, and we need to be getting penalties that make executives and boards sit up and take notice so that the matters we take have a significant deterrent effect. But there will be occasions where use of undertakings, infringement notices and our other tools may be appropriate as well, and that is really all of the signal of the why not litigate removal is to make sure that that full suite of tools is recognised.
Has ASIC's funding and resourcing of enforcement activities changed?
I can jump in there, Senator, but Mr Day may be able to give you more details. At a broad level, certainly following the Royal Commission, our funding for enforcement activity was increased. And if I sort of look at the activity that we're able to undertake in the enforcement area, go back to the 2018-19 financial year, we would have about 270 investigations on at any one time. That capacity has now been increased, that we've got sort of 330, 340 investigations on at any particular time, and the level of our court activity actions initiated in the court and penalties recovered has increased over the course of that funding period. But if you want any more precise details, I suspect Mr Day may be better placed.
Senator Chisholm, the amount of money that ASIC is utilising out of its funding in relation to our enforcement group specifically has actually remained stable from last year compared to this year. So that money is stable. In fact, in relation to our enforcement, supervision and surveillance funding, about 85% of ASIC's budget is really devoted to those functions, and that's similar to what it was the year before. So in relation to that, it's quite stable.
How many civil penalty proceedings has ASIC commenced since June 2021?
Senator, it's interesting you asked that question because I asked for that very list just overnight. There has been, and I'm trying to find the list that I was given, there have been 7 or 8, if I can say, significant civil penalty proceedings filed in the federal court, and there have been a significant number of other sort of lower level matters, so matters filed in, criminal matters filed in various magistrates' courts, and some interlocutory proceedings, for example, seizing freezing orders and injunctions, but at a high level it's around 7 or 8 since 1st of June. And I'll let anyone jump in if I've got that figure incorrect.
What about in the previous 4 months to that?
That one I would have to take on notice, Senator. My apologies, unless anyone's got that number at their disposal.
Do you think it would be more or less than the 7 or 8?
In the 4 months prior to 1 June, Senator?
Yes.
I imagine it may be slightly less, but I have to confess I am guessing.
Okay.
I could also foreshadow, Senator, if it is of interest, that as often happens as you draw to the end of a calendar year, it would be my anticipation that there will be a number more civil penalty proceedings filed between now and the end of this calendar year.
When considering enforcement action, does ASIC take as its starting point the question of whether a court should determine the consequences of a contravention?
When we consider an enforcement action, we look at the nature of the conduct. We look at whether it has had a significant impact on market integrity or on consumers or investors. We look at the number of those consumers or investors that may have been harmed and the amount of money that may have been received by the financial institution improperly and unlawfully. We look at the period of time over which the conduct has extended. We look at the remediation that may have already been paid and the actions taken by the company to remedy the conduct. And we then make a decision as to what the appropriate enforcement outcome should be, taking all of those things into consideration. We always consider whether or not a matter should be filed and whether or not a court outcome is the appropriate enforcement outcome, the appropriate public outcome in the circumstances. So the Enforcement Committee makes that assessment, Senator, in relation to every matter that comes before it.
Do you think that that could have been made more clear in ASIC's statement of intent in the corporate plan?
Well, given the questions that are being asked of us, perhaps we could have made that more clear, Senator. As I say, though, the removal of that, the reference to the why not litigate, was certainly not intended to send any signal that ASIC is going soft on enforcement. And as we have been talking about that publicly, and the outcome of our activity and our enforcement approach will be demonstrated by the matters that we file in courts and the outcomes that we receive.
Thanks, Chair. We've got further questions we'll put on notice.
Okay, thanks, Senator Chisholm. Senator McDonald, I think you have a brief series of questions you might want to ask.
Absolutely. Try and keep them brief, Chair. Mr Longo, with the transfer of responsibility for the financial advisor exam from FOSIA to ASIC, can you provide me with an overview of the discussions over recent months that ASIC have had with the government and FASEA on this handover? And when will the full transition take place, and what might that look like?
That's a short but big question, Senator. There's been a lot of work been done with Treasury to prepare for the single disciplinary body reforms that will take effect from the beginning of January. And we're working very closely with Treasury to ensure that we can run the exam efficiently and to meet all the requirements of the Better Advice Bill. I know that's a very high-level response. I don't know whether that's sufficient for today. Happy to give you more detail at the question on notice. That's one of my, whether Commissioner Press would like to supplement my response. But
in the interests of time, because I will have limited time, I just wonder, when will you be in a position to announce the more fulsome plans for the financial advisor exam in 2022, including the dates?
I couldn't tell you right now when we'll be making the regulations in connection with that bill have only recently been released. We are putting a lot of work into getting ready to assume our new role or expanded role beginning of January. I don't know whether Commissioner Press can help me on when we plan to publish more information about that, but I suspect it's imminent.
It is imminent, but we are working with ASA to get a new contract in place, and until that contract is in place, we won't be able to tell you what the dates are going to be. But we do know that it's important for advisors to have those dates, and we will be putting them out as soon as we can.
Thank you. Following the June 2021 Senate estimates hearings, a question on notice, BT 177 from Senator Brockman, about how much of ASIC's High Court case against Westpac relating to their superannuation funds operating a general advice-based call centre to encourage members to consolidate their super fund accounts, where the High Court found that it was personal advice. Now, this seems to be alarming because these were super funds owned by a big bank that were, through a call centre, providing services that they claim were general advice, and yet ASIC has chosen to charge 60% of the cost of this action to the predominantly small business financial advisor sector. This was illegal conduct by a super fund. Why don't the super funds pay 100% for this? How can you argue that the majority of this action should be paid for by small business financial advisors? And are you aware of any other similar cases where there's been an unfair allocation of costs to financial advisors?
Senator, that question is really a question about how the industry funding model works. And again, we can take aspects of that under notice, but I'm wondering whether Warren, the COO, or Commissioner Press wants to give you a more detailed response. But essentially, the allocation of costs is driven by the industry funding model, by law. And so I think that's essentially the answer. But I don't know whether Warren or Commissioner Press would elaborate on that.
I apologise, Senator, you broke up halfway through that question, but in relation to the allocation within the matter, my understanding was those matters did relate to financial advice aspects from the superannuation funds, but I'm happy to take that on further notice if you like, but unless Commissioner Press has something to add.
Thank you. Well, I will provide that question on notice for further advice. And finally, since the commencement of the Protect Your Super and Putting Members' Interests First reforms, can I ask for some visibility on consumer complaints in relation to super fund members who've lost their life, TPD, and possibly their income protection insurance? Who are they lodging complaints against, and are these complaints being lodged with APRA or ASIC?
Thank you, Senator. In terms of complaints about superannuation in relation to those types of matters, obviously with the formation of the Australian Financial Complaints Authority, complaints about superannuation are generally now going to AFCA. It may be that there are some complaints that have also been made to ASIC, and I'm quite happy to take on notice us looking for those. In relation to the complaints that might relate to that to APRA, I guess we'd have to have that question asked of APRA. And I understand they're following us in this hearing, so you get the opportunity to ask them there. In relation to the complaints about superannuation funds in the way that you've asked in relation to AFCA, I mean, I don't have that data available to me at this time. And I suspect AFCA might be able to better provide that information. But as I said, I'm more than happy to take on notice and look at the complaints we've received in relation to super funds in relation to the matters you've raised.
Yes, Chair, I will follow up on both of those last few questions on notice, because I haven't received an answer and I would like to better understand particularly the allocation of costs and now this issue of superannuation of insurance. And finally, I'm just trying to get an understanding of how the current arrangements for the oversight of unlicensed operators work. Financial advisors are subject to careful oversight of their licences by ASIC. What oversights are accountants, and I'm referring to Mr Papalia in WA, subject to that might have helped to reveal this kind of alleged misconduct that's seemingly been going on for nearly 20 years?
I'm not sure that I fully understand the question, Senator, but in relation to issues relating to unlicensed financial advice provided by accountants, again, I'm happy to go away and look at a more detailed question about that, provide you information about ASIC's activities in relation to unlicensed financial advice, particularly as it relates to accountants.
Thank you. It's following on because the ABC ran a series of stories on this case and kept referring to the gentleman as an accountant and a financial advisor, despite him not being a financial advisor. And given the oversights that are on licensed financial advisors, I'm wondering what oversight there is for ASIC to protect the industry. Given the strict regime that financial advisors are held under. So would you be going back to ABC and asking them to rectify their stories?
That's a matter for the ABC in terms of that. I mean, I don't think there's a limit, as you know, on the people calling the financial advisors, but, there's a lot of people out there, as we know, who call themselves financial advisors but aren't, don't hold licences. But in relation to the way the ABC refers to a particular person, I don't know that there's anything we could add to that.
Well, but then you shouldn't be regulating anybody if you're not going to protect there's a significant cost to regulating financial advisors. If you're not going to provide any protections to that industry, then, what's...
I'm not saying for a minute, Senator, that we're not saying that we won't look at and not take action against someone who is providing unlicensed financial advice. What I'm saying is how the ABC, in one of its own journalistic stories, might refer to a person is not something that I think that we could necessarily do anything other than educate what the rules are to the ABC, and I don't know how that would make any difference.
Oh, I think it would be a starting point if you've communicated with them that their story is incorrect, because it is incorrect, it's misleading, and if you don't provide advice to the ABC, I'm not sure who else is going to. Thank you, Chair.
Thank you.
Just, Chair, before we move on, can
Minister?
I just clarify
Minister.
for the Senator that on the issue of the industry funding model, Senator McDonald would know that the government's providing temporary and targeted relief for financial advisors in recognition of the transition of the industry funding model during the Hayne Royal Commission recommendation implementation. So this will see ASIC levies charged for personal financial advice to retail clients restored to their 2018 and 19 levels of $1,142 per advisor for the next 2 years. And the flat per licensee charge will remain at $1,500. So that's a 63% reduction relative to the level estimated in ASIC's 2020 and 2021 cost recovery implementation statement, which said that the levy was going to be imposed at $3,138 per advisor. And while this temporary relief is in place, the ASIC industry funding model will be reviewed by Treasury to ensure that it remains fit for purpose for the long term.
Excellent. Thank you, Minister. I think we've now exhausted all of our questions for ASIC. There will be questions put on notice, an opportunity for further questions to be put on notice. If I could thank you, Chair Longo, and your team for providing. There was a lot of topics covered during that session. It was incredibly useful. Thank you very much.
Thank you, Chair. That's very generous.
And we'll now move to the Australian Prudential Regulation Authority.
Tells me to.
Oh, okay. I was wondering what you're trying to communicate to me. I've got an old style watch. It just tells the time. Oh. After APRA, correct. We won't be having any breaks. We're just going to run through now. Okay. Yeah. Yeah, it'll be half an hour.
Jerry's got a few questions for APRA.
Yeah, I know.
Just get a quick show of hands about who's got questions for APRA and how much.
Is it just me?
Okay.
Sustain. Yeah. Good idea.
Deputy Chair, how much time do you think you're going to need with APRA? Just so
we've got just two questions for APRA. Which Jenny's going to do.
I'll do it, and I suspect it's
I'll just let you run through all of your questions. Okay. No problem.
Senator McKim has indicated he'll put them on notice.
I'll send McKim on notice.
His head won't fit through the door after that.
Okay.
ASIC.
Wow.
It's a great report. It really is. So, Senator McAllister, I'll go to you, then I'll go to Senator Bragg.
Senator McDonald.
And then Senator McDonald. Well,
so patient.
see if there's Okay. Can I welcome the representatives of APRA to this hearing, and if I could give the call to Senator McAllister.
Thanks very much, Chair. And I realise we may have slightly misled you because Senator Walsh has a short block of questions too, but Labor questioning should be pretty limited. Yeah, great. Okay. I wanted to ask a couple of quick questions, and they're probably best directed to, well, actually, I'm not sure. I'm interested in understanding what work APRA is doing in climate change, and in particular, any work that APRA is doing to ensure that Australian insurers are meeting prudential standards in relation to homeowners insurance.
Sorry, I think you just might be on mute. We can't hear you. Do you want to try again?
Can you hear me now?
Yes, I can. We can.
Chair, very sorry about that, Chair. Thanks for the question, Senator. And I might hand over to Mrs. Rao to answer that one.
Thank you. Helen Rao, Deputy Chair, APRA. So as you would appreciate, APRA has a wide range of work that is being undertaken in relation to climate change more broadly, including release of guidance, the climate vulnerability assessment, some pilot survey work, specifically in relation to insurance and the meeting of prudential standards by insurers in relation to homeowners' policies. We do not have any specific prudential requirements in relation to homeowners insurance in particular. What we are doing, of course, is engaging with insurers, a wide range of stakeholders around the potential impacts and flow-on effects of the financial risks of climate change and how insurers more broadly are adapting their underwriting and claims processing and assessment and pricing activities to be able to balance the need for sustainable insurance from an insurer perspective with appropriate outcomes for consumers and addressing some of the affordability and accessibility concerns. There are a number of ways in which, as you would appreciate, climate risks may play out and impact the affordability and availability of insurance. The solution to those issues, there's no single sort of solution to that, and there are a number of policy measures, as I said, sort of product design and underwriting measures, and also mitigation measures that the industry, government and at all levels and stakeholders are working on to address those.
Yeah, thanks very much for that, Ms. Rowell, because it is complex, isn't it? That tension here, as in other parts of the areas that you work, other domains you work in, that tension between affordability and availability with prudential certainty, it is a tension. What do you expect in terms of pricing as extreme weather events increase?
Well, I think absent any mitigating actions, then it seems likely that, insurance costs will increase as the nature and frequency and impact of events increase. But it's important also to recognise that the impacts are varied across Australia in different ways. There's, different impacts for different geographic regions, different types of home ownership, homes and construction and the like. So again, how those impacts play out will vary quite widely across the community as well.
Yeah, okay, thank you. So in the insurance sector, the main set of issues you're thinking about are the physical risks of climate change and the way they flow through to the business model for the insurers that you regulate.
Well, that is one angle, but also, of course, we are looking at the way insurers are responding in terms of potential impacts on them and how they run their business, with other APRA-regulated institutions as well. The reputation and other risks and impacts that might flow if APRA-regulated institutions don't respond appropriately. And then, of course, there's the wider sort of financial system impacts that we're looking at as well beyond insurers at all APRA-regulated institutions and how they are considering and responding to climate financial risk.
Thanks. Can I ask, in terms of the wider the broader environment, has APRA considered any potential impacts on mortgage rates or availability of lending? Is there any consideration of whether or not lending opportunities or borrowing opportunities might be constrained as a consequence of the physical risks of climate change, in areas that are more flood prone or bushfire prone?
I might take that one, Senator. I think the short answer to your question is those risks are real, and it ties to the insurability question that you raised before, because for many banks, part of the assessment of creditworthiness is whether the collateral for the loan is insurable, and the ready availability of insurance, affordable insurance, is important in that respect. We have been, I think, as you know, doing what we've termed a climate vulnerability assessment with the banking industry, the 5 largest banks, which obviously make up a very large portion of the banking sector. That looks at how they would adapt and evolve their business in response to a changing climate under a couple of different scenarios, and looks in part, but not entirely, at the risks that will emerge from their mortgage portfolios, which are obviously a very big part of their balance sheet.
Thanks. And is there any indication that those risks are feeding into pricing, or have the potential to feed into pricing in terms of home mortgages?
I don't think there's any hard evidence at this point. Certainly, I'm not aware of any. But is the risk there? Yes, I think the risk is there. A large part of the Australian banking system is funded from offshore, from offshore finance, and increasingly investors around the world are paying attention to and giving much greater priority to considerations of climate risk when they are looking at creditworthiness of those they're lending to. And then, of course, there's those who are investing in the capital banking system. So, we have seen an increasing focus on climate. In some extreme cases, we've seen investors who say that they're not willing to invest in certain counterparties because of a concern about climate risks. So I'd say the risk at this stage is a potential concern rather than a current concern, but it is a real concern.
And the transmission pathway is really the cost of finance for those lending institutions rather than differential pricing for individual borrowers.
Well, I think it's probably both of those things. I mean, we may see banks, and I'm just speculating, but we may see banks, for example, charging a higher premium, particularly if properties are at risk of being uninsurable at some point in the future.
Right.
Or the value of the collateral is likely to be more at risk from a changing climate. If you're lending for a 30-year mortgage, you need to obviously have a long-term time horizon as you think about the value of the collateral that you've got. So that could be differential pricing, but then there's a broader concern, I think, is just about making sure that the Australian financial system as a whole continues to have good access, as it does today, to debt and equity finance.
Does APRA know how many Australian banks or lenders have committed to a net zero emissions target?
I don't know that we've got a precise number there. I certainly don't have it in front of me, so I'd take that question on notice.
Okay. Senator Canavan has publicly said that Australians should tell banks to bugger off if they accept a net zero emissions target, and that Australians should pay more on their mortgages to support continued emissions. Has APRA provided Senator Canavan, or indeed any other Nationals MPs, with any information or modelling about the impacts of climate action or the lack thereof on mortgage costs specifically?
No, we haven't.
Okay. All right, thanks very much.
Have you got modelling?
Sorry.
Sorry, Senator Rennick, I'll come to you after the...
Yeah, look, and just a final couple of quick ones. There is some, and this is quite a separate subject, some evidence that scams, and particularly online scams, have dramatically increased, particularly in light of the government's failed response to the COVID-19 pandemic, and banks and prudentially regulated institutions are in the firing line. Does APRA have any visibility on how much scams and cybercrime are costing banks and ADIs?
It's not something that we directly collect information on. I mean, we do see information through peer regulators, but it's not something that we collect directly from banks.
Okay, and have you provided any guidance to prudentially regulated institutions about how to deal with scams or fraud?
Not specifically, no. We have a prudential standard on information security more broadly, which deals with, as you would expect, cybersecurity for the broader operations of a financial institution, but it doesn't go to that specific level of detail.
Okay, understood. Thanks. That's all for me, but as indicated, Senator Walsh has some additional questions.
I've noted that. Thank you, Senator McAllister. Senator Bragg.
Thanks, Chair. I wanted to take you through some questions that I asked you last time you were here on the 2nd of June, when I was inquiring about an organisation called the New Daily, which is owned by the Industry Super Holdings organisation. And I was inquiring whether or not that was going to be covered by your review of expenditure on marketing by super trustees, and you said that you would take that on notice. So can you give the committee an update on where you're up to with your inquiries into the New Daily / Industry Super Holdings?
Well, I might hand those questions over to Margaret Cole and Suzanne Smith, who are with us today. But I should just note for the record, Chair, this is Margaret's first appearance before the committee, and I did want to acknowledge that since becoming an APRA member on the 1st of July. So I might hand over to Margaret.
So, Senator, good morning. It is my first appearance. I wasn't around for the last hearing. You've seen, I think, the material we published earlier this week, a paper on what we've found out from our thematic reviews, 3 thematic reviews, one of which covered expenditure. And that was a sample of 12 superannuation trustees, so did not include ISA or the New Daily.
Okay. So the ISH is owned by the super funds, is it not?
That's right. That's right, I believe so.
Okay. So it's owned by the super funds as an investment, is that correct?
That's right.
Okay. And it's a marketing vehicle, amongst other things, right?
ISH itself has three subsidiaries, one being IFM Investors, one being ISA, and one being the New Daily. So as to whether ISH itself is a marketing vehicle, it's a company that has 3 subsidiaries.
Okay. And so that wasn't covered in your marketing review?
So what was covered, perhaps, Margaret, if you're happy for me to pick that up. Yes, I am. You were around and I wasn't when that was instigated. So just for the record, Suzanne Smith, Executive Director of Superannuation for APRA. So what we did in that expenditure review was look at expenditure for 12 different entities, of which some of that expenditure included, payments to ISA, which is part of what, they use ISA for marketing activities. So ISA was captured from expenditure by individual funds, yes.
Okay. So if the super funds put tens of millions of dollars into ISH, and that's used for marketing, that's outside of your scope or inside of your scope?
So the funds contribute to ISA under contractual arrangement for services. They're not putting funds directly into ISH. ISH is an investment that they hold. I think when we spoke last time, Senator Bragg, we talked about that as being part of the investment decision that they would make as part of their investment strategy. The payments to ISA will be a contract that they have, and those arrangements will cover advertising, different collective advertising and campaigns that will be run.
Okay, so what is the money that goes into the New Daily classified as?
Well, the funds don't contribute to the New Daily directly.
But they
funds
do.
Contribute.
But they do. They put money into the ISH, which is members' money, workers' capital, and that then goes into the New Daily. So they do indirectly fund it.
Well, so they made a contribution so they're shareholders in ISH. Our understanding is no money flows from funds directly to ISH. ISH will receive profits from the
Sorry, Ms. Smith, but just to interrupt you here, you wrote to me on the 20th of August saying that currently there are 20 super funds who are shareholders in ISH, all of which treat their holding as an investment. So you can invest into ISH, you can put millions of dollars into it, that can be funneled through into the New Daily, which is, as far as we can see from the public records, a failing media company.
So I think the shareholders of ISH, the founding shareholders, they contributed to that a long time ago. They now have an investment in ISH. ISH generates revenue from IFM, which is the investment arm, one of the subsidiaries, which is the most profitable part of that. So profits will flow from IFM to ISH. We don't have any record of funds paying further money into ISH.
Okay, so on that basis, you can have a profitable arm with your left arm and your right arm can be a complete failure, but as long as you're levelling it out, it's okay.
I think there are many examples of companies that hold a diverse range of assets and...
Okay, sorry. So I'm just trying to ascertain. So you've conducted this review. We've had extensive discussions about this before. You are giving a green light for the super funds to put capital into this media outfit at this time.
So the expenditure review was undertaking expenditure for marketing, sponsorships and advertising. Putting capital into an investment is we didn't look at investments as part of this review. We looked at expenditure on marketing, advertising and sponsorships, of which there are contracts with ISA. They were captured. What we will be doing is there's a new test as of 1 July, which is the best financial interest duty that funds now need to be held to account to. And we need to look at how the expenditure that they're using on marketing and advertising will be in the best financial interests of members. That expenditure is under contracts with ISA for services.
Okay, and so is your view that the New Daily will pass or fail the best financial interest test?
Senator Bragg, our understanding is from the information we have that no funds are contributing any money directly to the New Daily. The New Daily is a subsidiary of ISH.
So, correct. So on that basis, if I was a super trustee and I was putting money into an investment called Industry Super Holdings or something else, and that was funding then something else through a subsidiary, then I could do anything. Because your argument here is an argument about subsidiary companies and the use of corporate structures.
I think when you look at ISH, and we don't regulate ISH, we don't regulate ISA, we regulate the super funds and we look at the way that they make decisions around the investments, and that's part of their investment strategy. ISH generates profits from IFM, which is a very profitable part of their investment strategy.
Okay, you have made it very clear in your testimony today that this particular organisation, this media organisation, which is owned by ISH, can be successful or unsuccessful, but as long as it is owned by an organisation which has some semblance of commercial success, then that's okay. So on that basis, you could invest in anything.
I don't think that's what I was making. I don't think I made that clear. I think, Senator Bragg, what I said was we don't regulate ISH, we regulate the super funds that hold an investment. ISH has 3 subsidiaries. From time to time, subsidiaries will, perform differently. And on the whole, ISH is a profitable venture for the super funds.
Can I just just remind you that the Parliament has passed a law which enacts a best financial interest test for the super funds.
Yes.
And doesn't allow super funds to put in place opaque corporate structures to avoid that test. So APRA, as a potential regulator, needs to satisfy itself that the investments the super funds are making through any sort of corporate structure are in the best financial interest in the best financial interest of the members. Like that is a statutory duty.
That's right. Okay. Absolutely. We accept that. Okay. And I think I understand where you're coming from, Senator Bragg, and I appreciate that you're focusing on the best interests of members, the best financial interests of members, and that's absolutely, we're focusing on that as well. We look at the investments that super funds are making. They're investing in ISH, and ISH has been a profitable entity. There is no money going directly from the super funds. I understand what you're saying in that they're the shareholders of ISH and the New Daily.
You've written to me saying that the 20 super funds who are shareholders of ISH treat their holding as an investment. It's an investment. So therefore, the investment in ISH, which then passes through capital into the New Daily, is an investment. So therefore, you have to assess that on the new test, best financial interest.
Yeah. I don't know that I can add any more at this point, Senator Bragg, on this issue, but if we're happy to talk to you about this separately, if that would be...
Well, I'd like you to take on notice the exact formula you're using to give a green light to this particular subsidiary company. Secondly, I just wanted to ask you about the issue of some of the media in the past few days, particularly today around, there's a fund called Q Super, which I think is looking at a regulatory fine, I think, and is flagging the idea that it might use members' money to pay this fine. I just want to ask you a broad question about this because I think it's important that members of super funds aren't paying for fines. What are you doing to protect these members?
So, Senator, could I take that question, please? QSuper has had an application to the Queensland Court to amend its trust deed in order to allow it to charge fees to build capital or build a reserve to meet liabilities, which could include regulatory penalties in the light of the changes to Section 56 and 57. We, APRA, have looked at this extremely carefully. We, in fact, were notified of that application to the court. We decided that we had to go along, intervene, and make the court aware of the relevant issues around that application. So fundamentally, we have kept very close to this. We are aware that there is some issue between QSuper and the ATO regarding the matter that I think I've noted in the press this morning, but that's not something between us and QSuper, it's between QSuper and the ATO. But we have carefully explained to the court the balance that has to be had in order to protect members' best financial interests in deciding whether QSuper can be enabled to charge a fee for these purposes. That judgment is in fact still confidential until later today, although the import of the judgment is that the court are allowing the amendment of the trust deed to enable the charging of such a fee.
Okay.
Okay. Thank you, Senator Bragg. I'll give the call now to Senator Walsh.
Thank you, Chair. Just a few questions about your work in relation to the MySuper performance test. And I'm looking at your opening statement, which notes that the trustees of the 13 products that failed the benchmark test are providing important information to APRA, including weekly information relating to the movement of members and the outflow of members from funds, and that all funds have been losing members since the test results were published. Are you able to give us some early numbers on what you're seeing there?
What I am able to say is that that's correct. There are member movements in those 13 funds and probably in some other funds as well. Some of those are fairly marginal, some are more significant. There's been a bit of a tick up recently, timing-wise. I think that's around the timing of the receipt of the letters, letting them know of the outcome of the test. We do have some very detailed information, Senator, so we could take that point on notice and provide you with greater detail. Do have regular updates and schedules on that weekly at the moment.
That would be great. Do you have a headline figure on how many members have left the 13 underperforming funds?
Not right at my fingertips, but we'll take that on notice as well, please.
Okay. So I think on notice we would appreciate the numbers of people who have left the underperforming funds since the benchmark test, or since they had to communicate that to their members.
Yes.
Yeah. Thank you. You also say in your opening statement that it's now up to these 13 funds to start planning to transfer their members to a fund that can deliver better outcomes, or make improvements, and that you are carefully scrutinising the actions of those funds in that regard. Can you tell us what that scrutiny broadly looks like, but also what actions APRA can actually take if we're finding that the underperformance is continuing and people are still sitting in those funds?
Sure. The actions we are taking are intensified supervisory activity, so a great deal of contact with those trustees of the failed funds. We're having regular interactions with them. We'll call for and expect to have very shortly, if we haven't got them already, contingency plans.
We would expect them to be able to demonstrate to us how they're going to improve their performance and whether they stand a chance of passing next year's test. It's fair to say, because of the design of the test for year 2, probably the biggest lever they can pull to change the outcome is to drop fees, which would be a desirable outcome in its own right. Where it appears that there's going to be difficulty in passing next year's test, or we already have concerns about the sustainability of the entity, we are very much leaning in and pushing them to find appropriate merger partners. Now, in this area, we don't have a power to compel a merger, so we're basing this on, conversations, leaning into it, moral suasion, if you like, using whatever tools we have, can put some directions on, as I understand it, to require entities to scan the market and have discussions around mergers. And we know that there are active merger conversations, I think, in 5 of the 13 cases of trustees that failed the test. So you can expect us, I think, to be more muscular in those conversations and to try to get these mergers done, because it's inevitably in the best financial interests of members that the funds that have failed and are not sustainable longer term and don't have the economies of scale transfer members to entities that can have, a stronger future and much better performance for members. And we have no tolerance for members remaining with underperforming funds throughout this process. So we do want to see that happen, and you can expect us really pushing into that area.
Okay, great. So just to clarify that, you can encourage merger conversations, but you don't have the power to force mergers. Right. What other sort of toolkit? What other tools are in your toolkit to do what you just said, which is to be forceful in relation to people being moved or moving from those underperforming funds?
Well, not direct tools, Senator, but, powers of direction, licence, conditions that we would have to design, if you like, to drive towards that end. I don't know if Ms Smith has anything to add to that. Have you got that right, Suzanne?
Yeah, that's right. And I think...
Okay, so I think...
So directing funds, sorry, Senator Walsh, directing funds to take all reasonable steps to look at how, this would be in their best financial interest really now of members actually remaining in the fund. So where we see that it wouldn't be necessarily in the best financial interests of members remaining, what Mrs Cole said is directing funds to undertake a market scan, which came up with a list of funds that were potential merger partners, and how that would then demonstrate that members would be better off by being moved to another fund.
Okay.
And could I add, another thing we're looking at, Senator, relevant to this is whether there's any possibility of simplifying merger or transfer processes, because there are considerable complexities here, thresholds that have to be passed, rules like equivalent rights of members in the funds that join together or merge. Clearly, trustees take detailed legal advice on their rights in these situations, and that tends to slow things down or make for greater complexity. So we have an active programme at the moment of looking about whether any of these procedures can be simplified, and we're talking to Treasury about that as well.
Thank you. And in terms of the data that you're collecting on what's happening to members in the underperforming funds, we have the stapling coming into effect, I think, very soon in November. Will
Yes.
you also be monitoring how many members are stapled to those underperforming funds?
I think we will be covering that in our supervisory interactions as well, yes.
Okay. And what of this sort of information are you intending to make public at this stage? So in terms of members moving out of underperforming funds or members being stapled to underperforming funds?
I'm not sure that I specifically know the answer to that question, but I do think it's an important general point you're making, Senator, about transparency and what we can show to members is happening across this market, because anything that would help members to engage and understand that they need to take action themselves to move from non-performing funds into better performing funds would be a good thing. So I'm all in favour of greater transparency and creating digestible information on this for consumers and members.
Would you be able to take on notice how many members are stapled to those underperforming funds during November?
I'd have to ask teams how easy or difficult it is to obtain that information.
Okay.
I'm not sure that we would. I'm not sure that we do actually have that information, but Senator Walsh will take on notice whether we're able to. So whether we can actually give you the number or actually our capacity to do that, we'll come back to you on that point.
Okay.
And Chair, sorry if I may interject too. I think it's worth pointing out that stapling doesn't necessarily mean that somebody is stuck in a fund for life. They always have the choice to move on and to move out of a particular fund. It simply means that when they change jobs, their next employer will use that fund as their default fund rather than opening up a new fund for them and creating duplicate funds.
Thank you, Minister. Senator Walsh.
And just finally from me, Mrs. Cole, you mentioned administration fees and the impetus for the 13 underperforming funds to reduce their administration fees. Is APRA able to tell us anything about what the general trends have been in relation to administration fees in super funds? Have they generally been going up or stable or declining?
I think Ms Smith can add more information here, because I'm so new to the organisation, but I understand that since the publication, that APRA has been publishing heat maps for a couple of years now. There's some quite granular information that is published, and I believe that has helped drive fees in a downward direction, but Suzanne can probably give you a bit more.
I think I'll just reinforce what Margaret said. Since 2009, December 2019, we started publishing the My Super Heat Map, and I think there's been in excess of $400 or more million of savings for members due to a reduction in fees. We're due to publish the next My Super Heat Map in December this year, and I'm expecting that to confirm an even greater number than that. So I think the transparency that has been provided has certainly had downward pressure on fees, and the performance test has also been another lever for that downward pressure.
Okay.
Chair, if I can just interject
thank you
again
both
on
very
that one.
much.
If I can
Thank you,
just
Chair.
clarify that since October 2020, which is when we announced the Your Super, Your Future, Your Super changes, forgive me, about 37 of the 81 My Super products have cut their fees, and around 750,000 people have already looked at the comparison, the online comparison tool, the Your Super comparison tool on the ATO website, which compares fees and performance of all My Super products.
Excellent. Thank you very much, Minister. Before I go to Senator McDonald, Chair, if I can just note that you did give us the benefit of an opening statement, and that has been circulated. So we'll certainly take that as tabled, and thank you for that.
Thank you, Chair.
Senator McDonald.
Thank you very much, Chair. I just want to follow up on some questions I asked of ASIC earlier, and I'm hoping that you may have heard them, but if not, no matter, I'll repeat them. Specifically, since the commencement of the Protect Your Super and Putting Members' Interests First reform, I was asking about some visibility on consumer complaints in relation to super fund members who've lost their life, TPD and possibly their income protection insurance. I want to know who they're lodging their complaints against, and are the complaints being lodged with APRA?
Thank you, Senator. I did hear that question earlier. So, initial regulator, we don't typically receive a large number of consumer complaints. It's not being directly consumer facing. But of course, we receive some. We direct those complaints, as I understand it, to AFCA.
To AFCA, right, okay. All right, thank you. I'm following on from some questions that Senator Small had. He has advised new business volumes for the retail advised life insurance channel has declined by 50% over the last 5 years as a result of less financial advisors, lower commissions and a reduction in those advisors who are providing advice on life insurance products. He understands that new business is very important for life insurance as it serves to add younger lives to the life insurance pool and it covers some of the fixed costs of these companies. Such a significant decline in new business is presumably very concerning for APRA. Can you please tell us what has been driving this decline in new business and what are the consequences for the retail advised life insurance market?
Thank you, Senator, for your question. I think there are a number of drivers of changes in life insurance, whether advised or retail, and it goes to affordability and the choices that consumers have. There have been a number of pressures on claims cost in insurance over a number of years. Those that has driven poor profitability across a number of classes of business, which the insurers respond to with increasing premiums. And so when you add an uncertain economic environment and financial impacts on consumers with rising life insurance premiums, then you would tend to get a reduction in the flow of life insurance new business to insurers. So there's complex dynamics at play here, but one of the things that we are concerned about is the future sustainability and profitability of insurers and how they're responding to that so that they can meet their commitments to policyholders.
In your response to Senator Small's question on notice from June, you justified life insurers giving large discounts to new clients on the basis that having them underwritten again reduces the risk they pose. Given that some insurers are offering a 25% discount in year one, supposedly as a result of the underwriting process which the insurer needs to pay for, how can this be a good thing for the other policyholders in the insurance pool? Aren't these discounts a further indicator of the life insurance market that is in difficulty? And what guidance has APRA provided on these discounting practices?
So, Senator, we have not provided any specific guidance to insurers on discounting practices across a range of businesses. Discounting to attract new consumers is common practice. Our expectations of insurers is that they monitor their overall portfolio and profitability and how that's being managed, that they appropriately analyse and price the risks that they're underwriting. And there is evidence that because of the initial selection of new policyholders, the claims in the early years of insurance are lower and that can support a reduced premium relative to an existing life insurance policyholder. But overall, insurers need to manage the fair treatment of their customers with being able to sustainably write and price the business at a portfolio level.
Thank you. In response to questions that Senator Small raised in June about the extent of premium increases for existing clients, APRA has confirmed that you will start collecting data on premium increases for the individual disability income insurance market. This is a market that's lost $5 billion over the last 5 years, and APRA chose to intervene in the market in 2019. Why has it taken you so long to realise there will be consequences as a result of your intervention and to assess the impact on existing clients? What are you actually doing to ensure that these life insurance companies are being fair, these life companies are being fair to their existing policyholders?
So APRA's intervention in relation to individual disability income insurance is focused on ensuring that the new business that is written going forward is sustainable and able to meet the reasonable expectations of policyholders. And so that required a change to the settings, the design and the pricing of those products to enable that to occur. We intervened because we were not happy with the response of the insurance industry to those issues that were emerging and the poor profitability of that product class. Insurers, because of the poor profitability of that product, have reviewed their pricing, and that has led to increases for existing policyholders. That reflects the poor claims experience that's been occurring across that portfolio. We have not made any set any specific expectations for insurers in how they deal with their existing policyholders, other than to say they need to appropriately manage the balance between their sustainability and being able to offer life insurance into the future and the fair and reasonable treatment of all of their policyholders. But ultimately, how the insurers deal with existing policyholders is a matter for the insurer and its board.
Senator McDonald, are we...
One last question.
Oh, perfect timing.
Thank you, Senator Scarr. You've previously confirmed that you've not collected any data on premium increases for existing clients and that you've only recently commenced collecting more granular data on the IDII product. What has this extra data revealed so far?
I'll need to take that question on notice, Senator McDonald.
Thank you.
I don't have that information.
Thank you, Senator McDonald. Senator Roberts.
Thank you, Chair. Thank you all for attending today. Referencing this document,
Can you...
stress testing banks during COVID-19, dated 15th of December 2020. I have a question about one of the criteria APRA uses to stress test a bank, and that is a fall in real estate prices, or to use a simple explanation, the ability of a bank to maintain liquidity during a real estate meltdown. Can I say it like that?
Well, I think, Senator, it's more a question of whether they can sustain their solvency, which for us is more of an issue of capital, but liquidity is an important consideration as well.
Thank you. From the report, the figure APRA used as a proxy for a real estate meltdown was the loss of $49 billion in residential mortgages over 3 years. Is that correct?
That sounds about right, I think, Senator. I don't have the document in front of me, but
that's what I'm reading. Right. Thank you. With that loss being 30% of the total bank loss in the period of the stress test, as a loss rate, this would translate into 2% of Australian banks' residential mortgage loan book. Is this correct? And please confirm your figure for the value of residential mortgages held by Australian banks. What is it?
Oh, well, I think if we publish that number, Senator, I'm quite comfortable it's correct. Total mortgages, the banking system would be...
No, total residential mortgages.
Yeah, sorry, total residential mortgages, so housing loans we're talking about here, owner-occupiers and investors, would be, it's in the order of $1 trillion, but...
Well, I think, Senator, that's something that we can come back to you on.
Thank you for that.
Clear on the number. Very happy to take it on notice.
Okay, thank you. Final question on this, this topic before moving on to a simple topic. Can I confirm that APRA is projecting a real estate meltdown would only cost our banks $49 billion in losses on mortgages, and that loss would accrue over 3 years? That seems to be a very favourable assumption for the banks.
Well, that's the impact that we expect to have on the banks, given they have collateral against their loans. Many loans have very low loan-to-value ratios, so in many cases, banks would have loans that, even with a substantial fall in real estate values, the banks would incur no losses. That's not to say the borrowers would be unaffected by any.
Well, I think that's the concern.
Could I just add, Senator?
Sorry, go ahead.
Senator, I was going to add, I mean, it's just to your question of projection or forecast. This is a stress test, so it is a set of assumptions that we use to look at the resilience of the sector and the entities involved. So it's not a forecast or projection.
Okay, thank you. It's just that our constituents are concerned that we've had 20 years of the banks putting a lot of money into real estate and taking it away from small businesses and funneling it into real estate. And we've seen real estate prices increase a lot recently. Some people are calling it a bubble. So basically the question amounts to, are you letting the banks do as they please and then sweeten the impact for the banks?
Well, Senator, we don't allow the banks to do what they please. We've got a raft of prudential standards that ask the banks, as they're making commercial decisions, to take risk into account. And where we see risks, and I think an example of that would be the recent increase in the buffer, APRA acts and takes action.
Okay, thank you.
So, Senator Roberts, are we getting
a very short question.
The end. And if I can just note for the record that Mr. John Lonsdale was the one who provided that answer, just leading into your next question.
Apologies, Chair.
That's okay.
Does APRA embed staff in financial institutions like, say, the Big Four banks?
No.
Okay, thank you.
Thank you, Senator Roberts. Thank you very much. Senator Bragg, you've got a few follow-up questions, do you? Thank you.
Look, I have to say, I'm concerned with your evidence. I'm worried about the way that you're looking to implement these new laws on best financial interests. I mean, what are you doing to protect workers' super? I mean, you've got this EISS super fund where they're spending 100 grand on BMWs and 75k for Harvard courses and whatnot. What are you doing to clamp down on this extreme waste in this system?
So, Senator Bragg, is that question directed to the Chair?
Preferably, yes.
Well,
thank you,
Chair.
Well, I'll start, Senator, but then my colleagues who are closer to that specific example can answer. So we're looking at the best financial interest duty in particular that come in from the Your Future, Your Super reforms and the associated reversal of the onus of proof, which is now on trustees to demonstrate they're acting in the best financial interests of members. As an opportunity to significantly raise the bar on expectations for trustees. As we pointed out in the expenditure review that we published this week, we observed there are a number of practices that were past practices under the previous regime that we think would not be sufficient to pass the new test. In many cases, that expenditure has stopped under the new regime, but where it is continuing, we have challenged trustees now to demonstrate how they are meeting the new legislative requirements.
Okay,
With respect to EISS, and your specific example, I'll ask Margaret or Suzanne who are closer.
Sorry, Senator Bragg, if we can just make sure the witnesses have a chance to fully complete their answers before we move on to the next question. Yes, please continue.
So I'll hand over to Margaret or Suzanne on EISS.
On EISS, an investigation had been commenced in May this year, and that investigation is ongoing. I can say it's focused on expenditure, governance and oversight matters at EISS. We already have documentation that's come in pursuant to notices that we served, and we're considering that, and we would expect to examine key individuals here. And we will focus on the past events that gave rise to concerns, as well as actions to prevent such things happening in the future. And with other, leaving aside EISS for the moment, with other entities which were caught up or covered, I should say, in the expenditure review. What's really important, Senator Bragg, is that, as you would surely, I know, agree, is that we see that those practices cease. In many cases, expenditure has stopped. And that is right and appropriate. Where it has continued, we are looking into that properly, and we will see what action we can take on it. But having been given a new test and new powers and a new burden of proof for the future, I would expect us again to be more muscular and bold in how we push into these issues.
Okay, well that's reassuring. Can I ask you about these adverts which have been used with Mr. Greg Combay's face on them? And they're quite political ads from the Industry Super Australia group.
Sorry, Ms. Cole, could you see what Senator Bragg was referring to there?
We'll table these.
Okay.
I mean, they're basically political adverts funded by the Industry Super Australia Group, and I'm just wondering whether or not they would fall foul of your enforcement action.
Well, I think as I go back to the answers that Ms. Smith gave earlier, I mean, marketing advertising is an area that we will look closely at. Not all is necessarily wrong. We will require a great deal more analysis of, how it is in members' best financial interests. We will not accept the sort of quantitative-based justifications we've seen in some of these past cases. So that issues that we'll be looking into. The Industry Super Australia dynamic, the answer goes back to what Ms. Smith said earlier.
Okay. My final question, Chair, and thank you for allowing me to have this line, is just in relation again to the discussion we had earlier about how you're proposing to handle this this investment called the New Daily. So if the super funds are invested in this organisation, and there's 20 funds according to your correspondence that have investments into this organisation, and they incur a huge liability, for example. I mean, they may want to establish a legal case against someone, let's say. Where does that liability fall?
Is that question directed to Ms. Cole?
Ms. Cole, Mr. Burrs.
Ms. Cole?
I'm not in. I wonder if I could ask the Senator to just put it again.
Okay, so I guess. Well, it's not a hypothetical. It's happening right now.
I just don't understand what you had, Andrew, so you have to explain
Okay.
it more clearly.
All right.
Okay.
Senator Bragg.
Okay. I'm sorry if I'm being unclear. So the question is, if the super funds are investing in an organisation, in this case the New Daily, and that incurs enormous legal liabilities or some other huge expense, where does the liability fall? Does it come back to the super funds who own it, or where does it sit?
Well, I assume it would fall on the New Daily if the New Daily is the party, the legal entity involved in the proceedings, and there would be issues like whether it had insurance costs, I assume, Senator.
Okay. And so what risks do you think that poses to workers in this case that you're green lighting this as an investment inside the best financial interest test? This is a highly unusual media outfit which has already got itself into a range of legal messes. So, I mean, how are you going to protect Australian workers from the risk of liability that this organisation is already creating, given that you've said it's okay, it's part of the best financial interest test?
I don't think that's a correct representation of what we've said, Senator.
Well, the evidence you gave the committee today is that because this organisation is part of a broader organisation, it is all good and it's okay to be an investment.
Actually, Senator Bragg, I think that evidence was given by Mrs. Smith. So maybe if I could ask Mrs. Smith to address Senator Bragg's question, if you could.
Thank you, Chair. So what I was trying to explain was that the super funds are investors in ISH. ISH is the parent company that has 3 subsidiaries, one of which is the New Daily, one of which is ISA, and one of which is IFM Investors. So the super funds are shareholders in ISH. I think, as Mrs. Cole said, if there was the scenario that played out as Senator Bragg explained, that would be captured at the New Daily. That would then flow back up to ISH. My understanding would be that the exposure of those super funds would be capped at their investment into ISH. What I didn't say earlier, Senator Bragg, was that, the part of the profit that flowed to ISH from IFM is generated by those funds that use IFM as an investment manager. There are many funds, global funds outside of Australia who aren't Australian super funds who are investors who use IFM, and so profits are generated from a multitude of pension funds, insurers from IFM, those profits flow back to ISH. And so the ISH investment by funds is part of a broader investment portfolio. Super funds hold an investment strategy, and they need to look at those investments on their merits as part of their fiduciary requirements of a super fund. They have a prudential standard on investment management, and the investments in ISH will get captured there. That needs to be part of what super funds.
Oh, sorry, Senator Bragg. Sorry, Senator Bragg. Let Mrs. Smith finish her answer.
It is to the super fund boards, it is to the executives of super funds to make sure that those investments are in the best financial interests of their members, and that they have, now we have this new financial interest duty, we have the reverse onus of proof, and that needs to flow through, but we don't analyse every single investment that super funds make.
Okay, I think I've exhausted this line. I thank you for your indulgence.
Well, Senator Bragg, I've got one follow-up question. Mrs. Smith, and I'm asking this as an old company secretary and general counsel who used to set up corporate structures, etc. To what extent do you just look through a convoluted or complicated corporate structure and analyse what's practically happening in terms of the financial impact on the ultimate members for whom the superannuation fund is there to serve? To what extent do you look past the complicated corporate structure to really take a helicopter view as to what's happening practically with respect to the members' funds?
So thank you, Chair, for that question. We, in this case, we have done a lot of looking. We've dug into this deeply. I think Senator Bragg's raised this issue and this line of questioning with us for probably more than a year now. So it has been something that we've been focused on. To the extent we can have access to information, that's good, but we don't always have access to that information. But we do our best through ASIC and other channels to find out as much as we can.
Okay, thank you.
I'd like to add there that, we are a regulator bound by the limits of our jurisdiction. If we don't regulate an entity, we are not in a position to take action against it.
Thank you, Mrs. Cole, and congratulations on successfully finishing your first estimate session. I trust you enjoyed the experience. And if I can thank all of the witnesses from APRA and all the wonderful work you do, thank you very much. We're now going to suspend until 11:30 to provide an opportunity for the Minister to depart, and then we'll be recommencing at 11:30 with the Reserve Bank of Australia. Thank you very much. I've got 3 minutes to go to gents. I think I can do that. The committee welcomes the Reserve Bank of Australia, represented by Dr Guy Debelle and Ms Michelle Bullock. In welcoming the RBA, the committee recognises the central bank's independence under the Reserve Bank Act 1959, particularly in regard for its setting of monetary policy. The committee is cognisant that while the RBA does not receive annual appropriations, it does provide the Parliament with opportunities to discuss its insight and performance, which the committee greatly welcomes. As such, no government minister will be in attendance with the committee while representatives of the RBA are present. Dr Debelle or Ms Bullock, would you like to make an opening statement?
No, thanks, Chair.
Okay, so I'll pass the call to Senator McAllister.
Thanks very much. Dr Debelle, I just wanted to ask you a couple of questions about climate change. The RBA's latest financial stability review in October, there was a section on the Australian financial regulators' actions on climate change-related risk. Can I just ask whether the RBA has undertaken any modelling on the cost to the economy of not acting on climate change?
Not directly, though that's something we're thinking about. We're more thinking about what are the scenarios we can see. Let me back up. When the exercise that we're doing with APRA, the climate vulnerability assessment envisages a number of scenarios in terms of global outcome. And some of them involve policy actions at different periods of time. So but we don't explicitly model, that model doesn't explicitly take account of particular policies. It just says, okay, if things continue on the trajectory they're going for the next while, and then in 15 years there's a sudden decision to do something, what does that look like versus a net zero commitment outworld. So the world envisaged different climate scenarios without directly linking them to policies. I suppose is maybe a different way of putting it. But that's the exercise we're doing jointly, that we're assisting APRA with. But to your question precisely, no, we don't. We look at, okay, what are the impact of some of the announced policies of our trading partners, which we talked about in our most recent bulletin and referencing that financial stability.
Right. Can I just get some clarity around the exercise you just described? And I apologise, the audio is not entirely clear, so I wasn't quite sure about the terms of your answer. I'm not convinced it's a problem at your end, Dr. DeBell. But can I just say, so you are contemplating whether or not to commission modelling to examine different climate scenarios. Is that the advice you just provided?
Well, no, but more than that, the exercise we do has different climate scenarios in it.
Right.
And yes, there is modelling which supports those. Yes, macro modelling which supports those. That aspect is still, we haven't quite landed that. We hope to have that landed by early next year.
Early next year. And are the scenarios that you're contemplating different policy scenarios or different scenarios in relation to physical warming, or both?
More the latter than the former. So they envisage different physical outcomes occurring at different time horizons. They're aligned with the same sort of scenarios that others are looking at doing similar exercises all around the world, in part to, in large part to ensure that there's sort of comparability in terms of the outcomes that people are coming up with in these exercises.
And is the purpose, what is the RBA's goal in terms of your scope and mandate in undertaking such an exercise?
So as it's the same as APRA's, it's very much looking at the risks to the financial stability, and they're risks, they're not outcomes. And so we're looking at what is the exposure, I suppose, of the Australian financial system to different climate scenarios, and trying to get it, enhance our understanding of that. That's
right. And do you have any early advice about parts of the Australian financial system or the Australian economy that may be more or less exposed to the physical impacts of warming?
No, we're not quite at that point yet from the exercise we're doing with APRA. As I said, hopefully we land that not too far into next year. We did a couple of, what we did do though, from our side, from the Reserve Bank side, is look at a couple of areas. So one, we did an exercise which we talked about in our most recent bulletin which we put out a few weeks back, which looked at the one way of looking at the exposure of the mortgage books to different climate outcomes and what that might look like. It was a very preliminary top-down estimate, and the answer is not all that much. If you look at the lending books of the banks, then because of the time horizon of most bank loans mature under 5 years. So the length of the loan is no more than 5 years. So you don't get much of an exposure from that because, it's not so much can necessarily happen in 5 years. I suppose the one thing which I would highlight though, which is what we've seen in the insurance sector, where they've actually had a lot of events take place, and to some extent I'd say they are more advanced in their thinking about this than other parts of the financial sector. And we've obviously seen actual outcomes where that's had very material impacts on the insurance sector, given the nature of what they're providing versus what a bank is lending against collateral. The bank to lose a lot on that loan, the value of that collateral really has to fall a long way. So it's, yes, you can get damage to a building, but it's not necessarily going to reduce the value of the overall property materially enough to affect make the bank lose on that loan.
Sea level rise presumably presents an exception to that dynamic.
Yeah, so that's one of that's where we're probably going to turn to next and have a look at that. So that's potentially the case. It also, looking at the overall books of the banks, because they're so geographically diverse across the whole country. So yes, you're right, there are particular regions where that will have an impact, but it's not, given the size of the banks and mortgage books and the diversity across the whole country, that mitigates the impact of those sort of outcomes.
I understand. In terms of the thinking about the pricing structure for both mortgage lending and for home insurance, do you see scenarios where those products change their pricing structure in response to the physical risks of climate change?
Well, in insurance, we have seen it. It's not a forecast. That's and I think your committee has talked a bit about that potentially with APRA at times. But so that's happened in insurance and it is happening. To the best of my knowledge, and Michelle can correct me if I get this wrong, we haven't seen that in terms of mortgage pricing.
Okay. Just a final question on these. Pardon me. A final question on these climate issues. Our discussion so far has been about physical risk. Obviously, climate action and the regulatory frameworks around that also present risks and opportunities to the Australian economy. Is the RBA making any assessment of those dynamics?
So I talked about this a couple of weeks back. Did talk about both the risks and the opportunities, and we are seeing opportunities being realised in a number of parts of the country now. Well, not just now, have done for a few years now. And so, that is something we are paying attention to as well. So just one, and then to some extent, that's the challenge in running the sort of exercises that we were talking about, because they're over a multi-year horizon, looking a long way into the future, is taking account of what those opportunities might be, as well as what the challenges are. And we're well aware of the limitations of the exercise, but I think it's better to be doing it, being aware of those limitations, and not to be doing it at all.
Indeed. Look, just one more question on that. You did say in your speech on climate risks and the Australian financial system that the likelihood of more significant divestment is increasing. Do you have a sense of how much foreign investment Australia might lose if we do not act on climate change in a way that's consistent with international expectations?
No, not really. I think it's a risk which I think is almost impossible to articulate. But beyond that, and I think we'll see more of this over the next week. Actually, you'll see more announcements by people elsewhere around the world, not specifically targeted to Australia, but just in terms of their general investment strategies. We are seeing that, and I suppose one example to point to is the Europeans have a taxonomy in terms of sustainable finance, and how they choose to apply that may have an impact on us, just to give one material example.
I just have a couple of quick questions about the payment system. Should I direct those to you, Dr. Debelle, or to someone else?
Michelle is absolutely the right person to answer those questions.
Hello, Ms. Bullock. How are you?
Hi.
Great. Look, just quickly, I'm aware that there is a technology working group that's been set up with a number of the banks, large retailers, convened by the Department of Social Services to work on implementation arrangements for the cashless debit card. Is the RBA aware of this working group?
I personally wasn't aware of that working group. We haven't had anything really to do with the cashless card issue.
Right, interesting. The payment system's quite central to the mechanism that's being proposed. As background, Ms Bullock, it's essentially product level blocking, and it seeks to prevent users from buying certain products. It would mean require utilising FPOS, merchant category codes. It engages improved financial institutions. Are you telling me that the RBA doesn't have any visibility on this initiative?
We're aware that it's going on, but it's not part of our regulatory remit. This particular issue. This is an arrangement between governments, and it's true, it is a particular type of stored value card, but within our regulatory remit, which is about competition and efficiency in the payment system as a whole, it's not part of our remit.
Okay, thanks, Ms Bullock. Chair, that's all I have, but other senators, I think, have questions.
No, I've noted that. Senator Patrick, you've just got one or two questions, so I might go to you quickly so you can...
Thank you very much.
Okay.
I appreciate your sympathy for the crossbench.
I'm not sure sympathy is the right word.
Okay, thank you.
Respect certainly is.
Thank you. This could be one question, or it could be several, depending on the answer. There was an article or a bulletin that the RBA put out, Climate Change Risks to Australian Banks, that mentioned the effects on property values, which of course led to risks to banks. In there you cited, or there was a mention of 254 suburbs that can be defined as climate sensitive by 2050. Can you please provide a list of those 254 suburbs, please?
I suspect we probably can, Senator. I can't provide one off the top of my head, but yes.
Yes, no, just on notice. I'd be grateful if you could do that, and that's the end of my questions.
Excellent. Thank you, Senator Patrick. Senator Rennick.
Hi guys, how are you going? And just to confirm, I am speaking with bankers and not meteorologists and scientists.
Yes.
Academics. Okay, thank you. Is the RBA aware that the Deutsche Bank had to settle a price-fixing litigation, and basically it had to be settled because the plaintiffs accused both Deutsche Bank, the Bank of Nova Scotia, Barclays, HSBC and Societe Generale of manipulating prices of gold, gold futures and options and gold derivatives through twice-a-day meetings to set the so-called London gold fixing.
Yes, I'm aware of that, Senator.
Yep, and you're also aware that JP Morgan had to pay a $920 million fine over misconduct of market manipulation in regards to trading metals and Treasury securities?
Yes, I am, Senator.
With that in mind, I noticed that in the report that you sent me, and I appreciate you sending that through report, that you mentioned that there is the existence of fake gold bars had been detected at the Bank of England in the past and by the presence of duplicate refiner serial numbers. Has this issue ever been raised with the Treasurer? And given the serious nature of this statement, why are we still keeping gold with the Bank of England, who have clearly failed in their custodianship of our gold?
To answer your question, no, we haven't raised it with the Treasurer.
You haven't raised it with the Treasurer?
No.
Okay, thank you. I note also that those some of those bars, a lot of those bars have been refined since 2015. Given that we haven't bought or sold any gold in 20 years, how is it that this gold's only been refined in the last 5 years, and where exactly were our gold bars prior to 2015?
So they were at the Bank of England prior to 2015, Senator. I mean, gave you the information earlier to an earlier question of yours about how they, when bars got where. I don't quite understand your question. Sorry.
Well, why would they be refined? I mean, once a gold bar's a gold bar, why would you refine it again?
Because I think, and I'm happy to provide this a more detailed answer subsequent. My understanding is that over time, bars don't maintain their full value. Gold dust sort of flakes off and whatever, and every once in a while the bars are refined.
Okay. Who audits the Bank of England and their reserves? And does the RBA get a copy of the audit report? And does the audit report cross-check balances and serial numbers of gold bars with other counterparties to ensure that there is no double counting of gold bars?
do we get a copy of the Bank of England's audit?
Yeah,
You know,
so-
the general audit, you mean?
Yeah, do you get a copy of the Bank of England's audit of its gold reserves? And a statement from their auditors saying that they've actually checked all their parties and counter statements with their serial numbers to ensure that the same serial numbers aren't being given to different counterparties, hence the duplicate counting of gold.
I'll have to come back to you on the exact answer to this, but in terms of do we get a report of their audit of their custodial services to which we provide versus the Bank of England's holding of their own reserves, I'm not so sure on the latter. On the former, I'll come back to you. Sorry, I don't think we get the latter. On the former, I'll come back to you.
Yeah, I guess the reason why the latter is so important is that we need to see that the Bank of England themselves are being audited, not just our gold bars in the Bank of England, but the entire...
Are the Bank of England's audited? Yes, they're required. Just as we're audited, they're also audited. Do I get a copy of their audit report? No.
Yeah, sure. Given the information that I've revealed today, do you think that maybe we should think about bringing our gold home?
As I said to you, Senator, I'm comfortable with the arrangements as they have, as they currently stand in terms of service to us.
Okay, and are you aware...
I'm not concerned that the Bank of England has stolen our gold, Senator, if that's what you're getting at.
Well, I mean, you know, the presence of duplicate gold serial bar numbers, I'll be the judge of that. Given that you yourself haven't actually been over there to count it, all of it, 100% of it any time in the last 20 years, I don't think you can say that. So I'll be the judge of that. Are you aware of the value of Australia's gold exports in the 2021 financial year?
Not off the top of my head, but we have that information.
Yeah, it's $28 billion. It's our third biggest mineral export, and it basically employs, you know, between 70 to 100,000 people. Now, you know, given that there has been, you know, proven gold manipulation of the gold market, you know, it's worth pondering the fact that if prices are being constrained, let's say, for example, by 50%, that could be at $14 billion in lost revenue exports. And if you assume that profit went to the bottom line, that's another $4 billion just in company tax. So it is very important to ensure that the gold market is properly accounted for. Wouldn't you agree?
I would agree.
Okay, thanks very much.
Okay, thank you, Senator Rennick. Senator Roberts.
Thank you, and thank you, Dr. DeBell and Ms. Bullock. I refer to your media release 2021, number 21, dated 5th of October, which announces the Reserve Bank will continue to purchase government securities at the rate of $4 billion a week until at least mid-February 2022. Is this being funded by creating money through electronic ledger entries?
So when we buy a bond, then, the value of the balances that the banking system holds with us goes up by a commensurate amount.
Okay, so yes. By February 2022, what is the aggregate value of the securities purchased by the Reserve Bank and funded by an electronic ledger entry?
Hang on, I'll just see if I've got that. I can either provide that to you shortly, but I think I might have that to hand, Senator. Can I come back to you with that in a second? I do have that information, but not right at my fingertips.
Okay, thank you. Is it fair to say that increasing inflation may signal that electronic ledger entries as a means of financing government deficits is becoming problematic?
So inflation is increasing, has increased, although actually yesterday inflation actually stepped down a little from where it had been previously. But, you know, the monetary policies settings we have in place, as do other central banks around the world, are, you know, we were looking to generate a little higher inflation than we have had over the last 5-6 years. So that, as well as generate more jobs for Australians. So those are the objectives of the setting of monetary policy, Senator. So some inflation, a little bit more inflation is welcome, a lot more inflation is not welcome.
Okay, so what's the latest figure for inflation, and where does the Reserve Bank expect inflation to go over the next 12 months?
Senator, can I take in mind, we have got a policy board meeting on Tuesday. We are publishing revised forecasts on Tuesday. I'd rather not update them in the middle of a Senate estimates hearing. We haven't actually landed on that, the forecast aspect yesterday. I can tell you what the number was yesterday, which was consumer price inflation over the year to the September quarter was 3%, 3.0%.
Thank you. We'll look for those figures then. I understand why you can't do it today. The draft Digital Identity Bill 2021 includes a provision that every payment must be made by electronic currency and tied to the person's digital identity, so that every transaction can be tracked and traced. This bill once again tries to outlaw all cash transactions. So we had this debate last year when One Nation led the defeat of the cash ban bill. Does the RBA support the government's attempts to once again ban cash transactions?
I mean, we print cash as well as electronic, as you mentioned earlier, Senator. So we are, we continue to and will intend to, print notes for the people of Australia to use for the foreseeable future. So it's we are still very much in the note printing business.
Okay, so you don't support the government's attempt to ban cash. Then let's move on to the new payment platform. And I appreciate your answers. It'd be so much easier in Senator Estimate's chair if everyone gave answers so quickly, directly. The new payment platform's first transaction was 3.5 years ago. Around about that. Can I ask firstly, what is the uptake of the new payment platform, expressed using any criteria or KPI that the Reserve Bank considers appropriate?
Well, I'm going to hand to Michelle on that one, if you don't mind, Senator.
Sure,
Yep,
thank you.
Thanks, Senator. I would say we don't have any specific KPIs, but I think on measures of how quickly fast payment services around the world have picked up, we've certainly picked up as quickly as any. There's now around about $92 billion a month passes through the new payments platform in terms of payments. And I think as a measure of success, I would note that COVID disaster payments during this recent period, 17 million of them to the value of around about 11.5 billion to people into their accounts on the weekends, no delays. I think all those KPIs suggest to me that it's doing very well.
But Senator, further to your question, we can also provide you the sort of share of transactions which go through the various payments mechanism, including the NPP, and show how that's changed over recent times. To your question.
Thank you. Yes, that would be helpful. I was about to infer from Ms. Bullock's answer that very thing, so that'd be great. Is there
just sorry to come back to your earlier question, the answer to your previous question is by February 22, we will have bought 360 billion of government bonds.
Thank you very much. As a follow-up, Ms. Bullock, is there a review plan to see how the NPP or the new payment platform is working? If the architecture is right, has the security on all that data held up, etc.?
No review by the bank on that, Senator. We review things. We will be reviewing in the near future things like access to the NPP to make sure that is meeting the requirements. In terms of the auditability and the operations, that's a matter for NPP and its shareholders to address.
Who are the shareholders in NPP?
The major banks and a number of smaller institutions, some aggregators as well. There's around about 13 of them, I believe.
Excuse me, Senator Roberts, I'm just managing the call.
Yeah.
How much further do you...
It won't take much longer. They're
Okay.
fairly short answers, yeah.
Thank you.
Is the platform generating operational revenue or even a profit? And if so, where is that money going? Is the Reserve Bank still a shareholder?
The Reserve Bank, I might take the second question first, if I may. Yep. Since the approval from the ACCC for the NPP and BPay and FPOS to amalgamate to Australian Payments Plus, the Reserve Bank announced its intention to step back as a shareholder and its position on the board. I don't know if that's actually gone through yet, but that's the intention if it hasn't. In terms of its revenue, and I'd have to come back to you on that, but that would be in its annual reports, and I can take that on notice and get back to you.
Thank you, Ms. Bullock. I note from your press release 2021 number 18 of the 2nd of September 2021, it announces that the Reserve Bank has signed onto Project Dunbar, an international agreement to provide a common platform to allow foreign transactions to be paid in digital currency. Is that correct?
It's not an agreement to create a platform. It's basically we've signed on with the Bank for International Settlements Innovation Hub and 3 other central banks to explore what sort of design considerations you would need for a multi-currency CBDC settlement service.
Thank you. And it'd be paid in digital currency. Whose digital currency?
What it is exploring is the design elements for individual central banks to issue their own central bank digital currencies, and those currencies would be used.
Thank you. The Reserve Bank of Australia corporate plan on page 8 includes a section entitled, I quote, "Harnessing the Power of Data." And that includes this comment: data are, and I'll quote again, "Data are a strategic asset for a central bank. This involves extracting maximum information from the data available." And that's the end of the quote. Will the Reserve Bank data acquisition include harvesting data from the sources the Reserve Bank now controls? For example, the new payment platform and the upcoming central bank digital currency?
No, I mean, we don't. What we're talking about there, Senator, is looking at the data that we get from people like the Australian Bureau of Statistics, whatever, and just ensuring that we're using that as effectively as we can, which also, you know, the ABS over recent years has provided much more disaggregated data that we're able to utilise. So it's ensuring that we have the capacity to handle those much bigger data sets effectively. So that's what we're talking about there.
So what would that look like? The data.
We have a data platform which allows us to handle these big data sets much more efficiently than a bunch of spreadsheets, which is the more traditional, you know, the way we've been doing it for a number of years, and to do, you know, use more, use some more up-to-date data, current data analysis tools more efficiently on that sort of platform than we can currently, given where we historically have stored data, which has primarily been in spreadsheet form.
Thank you. Last question, Chair. Ms. Bullock or Dr. DeBell, if every transaction will be made using the individual's digital identity, which will complete the transaction using the Reserve Bank's digital currency on the Reserve Bank's new payment platform, is this tantamount to a government takeover of all commercial and international financial transactions in Australia, or at least complete oversight, complete control?
So, Senator Roberts, the vast bulk of payments go through our platform as it is. Any non-cash payment goes across us as it has today, and has done so for years. The MPP is a more real-time form, but currently historically all other payments still go across our books through either the RTGS system or whatever. But NPP is a newer version of that, but those transactions still go across us, always have, and will continue to go across our books.
Yeah, I'd make a distinction, Senator, between the NPP is not. That's a commercial payment system, as is a card payment system, as is the direct entry system, as is the cheque system. All of those systems have transactions with the banks. What Dr. DeBell is referring to is the fact that in order to make the transactions between the banks, all those payments have and have for decades passed across the books of the Reserve Bank. So there's a separation between the commercial payment systems that you're thinking of in terms of NPP and all those other ones, and the settlement systems which are across our books.
Okay, Senator Roberts.
Thank you, and I want to note my appreciation of the directness of the answers and the promptness of the answers.
You're very polite, Senator Roberts, as always. Now, I'm going to go to Senator Walsh. And Senator McKim, are you on the phone?
Yes, I am, Chair.
Well, thank you also for being very polite and patient. I'm going to go to Senator Walsh and then I'm going to go to you, Senator McKim. Okay?
Thank you.
Senator Walsh.
Thank you, Chair. Thank you, Dr. DeBell and Ms. Bullock, for being there for us. I've got a few questions about your thoughts about where we're at with economic recovery. We had some discussions in this committee yesterday with Treasury, who said that they thought the indications were that the recovery coming out of the third wave lockdowns would be similar to the recovery coming out of the previous wave. And I note in your October board meeting minutes, that the members observed that the economic recovery was likely to be slower than in late 2020, early 2021. So I just wanted to get your sort of general views about the pace of recovery and whether you're seeing something in particular there about the pace.
I don't want to again preempt too much what we might discuss on next Tuesday, but I suppose, our outlook for the economy is very similar to that of Treasury's. We'll provide that, as I said, to one of the other senators earlier. We'll provide an update on that next Friday in our next statement on monetary policy. But we are, the signs we're seeing of the economy as at least as the New South Wales and Victoria come out of their lockdowns, is that things are, there's a strong underlying momentum there. We just have to see how it unfolds really over, we've only just emerged obviously here in the last week or two. So, but most of what we see is positive, really. Much of what we see actually is positive.
Okay.
So I don't think our outlook is any materially different from that of the Treasury's.
Okay, thank you. And I've clocked what you've said about your next statement coming out and how much you can say about inflation projections. But given that the September figures did come out yesterday, I'm just wondering if you can give us a generalised sort of analysis of whether that reflects any heating in the economy, or whether it's more limited specific factors that have led to that.
That's probably a question I don't want to go too far down, because I think it bears directly on monetary policy considerations. I suppose I could talk factually. The outcome in the quarter had the two main drivers were higher fuel prices, which I don't think was a surprise to anyone, and higher housing construction costs. So they comprised about, between the two of them, I think about 2/3 or so of the increase in the quarter. Okay.
And you have repeatedly over the this sort of extraordinary pandemic period pointed to the importance of the government's fiscal response and support to households and businesses. We know that as we get to 80% double vaccination, those supports are ending within weeks. We spoke here yesterday about what the effective unemployment rate is, which is around 9.5%. What impacts are you going to be watching in relation to the withdrawal of that support to household and businesses?
One thing we're looking at is going to be employment growth and how people come back into jobs. So you're right that your sort of effective unemployment rate is somewhere around the number you just said. Our sense is that a lot of those people still have retained some attachment to their previous employer, and so to the extent that gets validated as things start to open up again, or are opening up again now, and those people go back to their jobs, that's one thing we're very going to keep a close eye on. I suppose the other thing I'd note, and we see this is that in aggregate at least, the household sector has saved a lot of that income, including the government support over the last 3 months, in part because they couldn't spend it. You couldn't go out and, at least here, you couldn't go out and spend it. And so there is a reasonable buffer that the household sector in aggregate at least is bringing into this, and that's also true of the corporate sector in aggregate. That's going to vary, obviously, but how those buffers of saving get deployed is going to be another thing that we're going to be keeping a pretty close eye on. But I'd say that the one thing I would, probably look at is just really how the employment picture unfolds over the coming months. What we do see is a very high level of job vacancies still, so those employment opportunities are out there, and there's a question of how they're filled over the period ahead. That's probably one thing I would focus on.
Yep. And just finally from me, there's been a lot of discussion on this committee and in general about wages, flat wages, declining real wages, the relationship of that to the unemployment rate, and I guess, notwithstanding the discussions that you're about to have next week, I guess I just wonder if you could give us some general reflections on what you are looking at around wages. I think there's been some sort of pickup in wages in other economies that are recovering, yet we seem to have this persistent problem in Australia where declining unemployment has not had the effect that you are seeking, which is to move wages up. So I guess I'm just wondering what you're looking out for going forward there, what people might be able to expect in wages.
What we're looking for is higher wage outcomes, whatever it is. What the most recent data we have on that is up to the end of the June quarter, and what we can see from that is that people who had had a wage reduction through the pandemic, by and large, that got reversed. Or if you had a wage freeze, then you went back to getting something like a 2 point something or other wage increase. So the predominant wage outcomes for most workers was 2 point something or other, a very high shift. That was the data that we had in June. I suppose what we're looking at is to see how that evolves as the labour market picks up again as we come out of the pandemic. We are aware, including very personally, from an institution point of view, we are losing a higher number of our staff as to people offering them a lot higher wages, particularly in the IT and payment space, as well as the audit, places like audit and risk. So there are pockets of heightened wage pressure, and the question is just what we're looking for is, how widespread are they? Is this a level shift in wages? And then we go back to sort of the rates of growth that we've seen over the past 5 years. They're really the open questions, Senator, that we're going to be keeping a close eye on and very much continue to utilise our business liaison program and getting a good handle on that, which has been invaluable over the last 18 months or so.
Thank you very much. Thank you, Chair.
Thank you, Senator Walsh. Senator McKim, thank you for your patience. I'll go to you now.
Thank you, Chair. Dr. DeBell, capital city house prices increased by 17% in the 12 months to June this year. In the same period, wages grew by 1.7%, so literally a tenfold difference in those two measures. What has the impact of such a grossly overheated housing market? What's the impact of that been on the economic prosperity and welfare of the people of Australia, and in particular on renters and on people who are trying to enter the housing market for the first time, which is mostly young people?
So, well, to your question, Senator, there are different impacts on different people, but most of the people who own houses in Australia are also people of Australia. So those who own homes are obviously benefiting from the rise in house prices. Those who don't own homes aren't, and that is absolutely the case. The rental market is, I think, a slightly more nuanced story. There was information on this in the inflation data which came out yesterday. So rents were actually still falling up until very recently in Melbourne and Sydney, particularly in the inner city area. So that story is a little more diffuse across the country. There are other parts of the country where that's not the case, including places like Perth. So the rental story is different. But there are definitely different impacts of the outcomes and house prices on different parts of the Australian population. That is true.
Okay, thank you. Does the RBA accept any responsibility for such a grossly overheated housing market in Australia?
I mean, Senator, we've had this conversation a few times lately, but I suppose we are setting policy to achieve overall objectives. I think the policy settings we've put in place have supported Australians having jobs. That's an outcome which I think has proven to be a lot better than we anticipated. House prices have risen. That is certainly the case. Interest rates have contributed to that rise in house prices. I would not say they are the only contributing factor to that. I believe Mr. Falinsky is running an inquiry at the moment looking into some of the other factors that may be contributing to that. Interested to see what comes out of that, but low interest rates have contributed to the rise in house prices. I'll certainly acknowledge that.
What about the $400 billion that the RBA has printed over the last couple of years? Do you accept that that's had an impact on house prices?
Well, our monetary policy settings, of which that is a manifestation, have had an impact on house prices. I would also note they have had an impact on employment outcomes.
Yep, absolutely accept that. So your governor recently effectively said that the RBA is caught between a rock and a hard place in terms of house prices versus unemployment. He actually, to quote him, he said it's a poor trade-off. Jawboning's an acknowledged tactic for central banks to use to achieve their aims. Why isn't the RBA more clearly and consistently jawboning for policy reform so that some of the actions that you are taking around interest rates and printing cheap money doesn't fuel such unsustainable house price growth?
We have talked about this at various times in the past. I would note that a number of the potential things which could be addressed here rest in the hands of the Parliament.
Well, does the RBA support, for example, a reduction in the capital gains tax discount or limits on or the abolition of negative gearing?
So we've provided another submission again just recently to Mr. Falinsky's inquiry where we laid out our views on that. We've provided those similar views a number of times over the years to the number of inquiries that this Parliament has run on the issue. So I'd direct you to that.
All right, thank you. So you've printed, as I said, about $400 billion in the last 18 months, and I absolutely accept that there's been, benefits there. It's avoided a steeper economic decline and had a positive impact on unemployment, but it has also played its role, as I think you've acknowledged, of increasing house prices, and as we've agreed, by 17% in capital cities over the last 12 months. And it's also massively enriching bank executives and shareholders. You've got wages growth still declining in real terms. Doesn't the RBA need to start explicitly directing monetary policy, and I'm particularly talking here about your fiscal policy, so that the money you print actually goes into productive parts of the economy rather than acting as this massive stimulus to an already grossly overheated housing market in Australia?
I suppose I'll just note, that's not the way we have, you can have that view, Senator, but I suppose we set the conditions for the economy as a whole. How the economy reacts to those conditions in terms of the way it distributes those conditions is mostly up to it, and I suppose in other policy settings.
Does the RBA have the capacity under its Act to be able to direct money that it is printing to productive ends of the economy? And if you don't have that capacity under existing legislation, will you ask the government to change the Act so that you do have the capacity to explicitly direct monetary policy to productive parts of the economy rather than an already grossly overheated housing market?
We are not intending at the moment to direct the government to change our Act. No.
Senator McKim, it's just the chair here. I'm just anxious that to give you an opportunity to finish your line of questioning. How much longer do you think you need?
Oh, just one question, Chair, if that's all right.
Perfect timing.
Thank you. And Dr DeBell, thanks for your responses. And I'm certainly not suggesting you have the capacity to direct the government to change legislation. That's ultimately a matter for the Parliament. But I again want to put to you that it is in large part the actions of the RBA that are responsible for what is basically a cooked housing market in this country that is just pricing so many Australians out of the Australian dream of being able to afford their own home and significantly impacting on large numbers of renters. And would you at least commit to going away and having a think about whether you would look at requesting that the government, if it's necessary, requesting that the government change the Act so that you can ensure that when you engage in printing hundreds of billions of dollars worth of money in the future, if you ever do, that you can direct it into productive parts of the economy?
I'm happy to think about that question, Senator.
All right, thank you.
Thank you, Senator McKim. I'll give the call now to Senator Bragg.
Thanks, Chair. I just wanted to ask about some broader issues. So, I mean, the central bank has independence, I think, principally for monetary policy purposes. There's been extensive debate about payments policy. Do you think it's a reasonable position for a country like Australia to leave payments policy in the preserve of the central bank away from the elected government and the elected parliament?
Well, I mean, I'll hand this one to Michelle in a minute, Senator. But I note that the government just had a review on pretty much this question.
Correct.
And the government, I believe that review is, the Farrell review is obviously being published, and the government have to have the response to that.
Well, I think in that review it flagged a much broader role for the Treasury and the Treasurer.
Yep.
Okay.
Yep. We're comfortable with the outcome of the Farrell review, I would say. We've got a quick answer, but I'll let Michelle answer.
Yeah. Could I just add a couple of other points, Senator?
Yeah.
First is that having responsibility for payments and payments policy within a central bank is not an odd thing. It's actually around the world. It's not uncommon.
Yeah.
The second thing I would just note is that this has already been mentioned with respect to the Farrell review, is it's entirely within the remit of the government, but that is not the system we have at the moment, of course, because at the moment we have a payment system board.
Yeah, okay. Well, look, the other thing I wanted to ask you about is buy now, pay later. So my understanding is that the bank doesn't have the regulatory power to insert itself in this space. Is that right?
It's uncertain, is my understanding.
Yeah. Okay, so okay. So if you are uncertain about your regulatory jurisdiction, then why would you make statements about buy now, pay later and future directions on that, given there's already been uncertainty about your regulatory position? I'd say that it's unlikely that you have jurisdiction. Secondly, the government's just released a payments review flagging structural changes. So I'm just wondering, I'm curious about why you've made these public statements about buy now, pay later, given you know that it's a sensitive issue.
I would say that the problem here is that increasingly what's happened is that the buy now, pay later is bleeding into areas now which are meaning that there is competitive neutrality is challenged. We've got competing products, some of which are regulated, some of which aren't. If you take a broad view of what you think a payment system is, and if you ask a person in the street what they think a payment system is, they would list all these sorts of things, buy now, pay later. It's all about paying and getting money moving. The legislation, by its legal nature, is quite narrow. So all we're saying here is that if we are going to think about the payment system as a whole, as an ecosystem, I think is the term that Scott Farrell uses, then we need to think about where there are areas of competitive, where there's areas that is not competitively neutral. And what we're seeing in this space now is that there is not competitive neutrality. That's the point I'm making.
Okay, last question. Okay, so, but I mean, on that basis, I mean, you've flagged, you've made public statements about your view on buy now, pay later and surcharging and whatnot in quite a lot of detail, which I think, as I say, is curious given the regulatory uncertainty. So I guess the market will assume that given the power is not assured, that there'll be no action taken.
What we've said, Senator, is that we've put our views on the principle of no surcharge rules, which we think apply in the payments ecosystem, but it's up to the government and Treasury to decide how they want to deal with this.
Look, and I think it's all good. There's obviously a lot of interest in what you have to say about these things. So again, I'd say it's an interesting position to have, but thank you for clarifying that. I think that's been very useful.
Thank you, Senator Bragg. Senator Chisholm, do you have any more questions? No. Senator McDonald, did you have any questions? Senator Cox, did you have any questions? No. Senator Roberts is packing up. Okay, so we'll. I didn't mean anything by that. So we will now conclude. The committee will conclude its hearing for its consideration of the Treasury portfolio. Can I thank all the representatives from the Reserve Bank of Australia for joining us today for a very wide-ranging discussion. It's greatly appreciated. I thank Minister Birmingham and Minister Hume and officers from the Treasury portfolio who provided evidence today. The committee's consideration of the 2021-22 supplementary budget estimates will resume after lunch at 1:15 p.m. with the Industry, Science, Energy and Resources portfolio. Thanks very much. Of the chief scientist. So thank you very much for your patience. It's greatly appreciated. I guess I should ask, do you have an opening statement?
No, not tonight, Senator.
Okay. Thank you. Thank you very much. Senator Walsh has some questions, so I'll pass Senator Walsh. Thank you.
I do. Thank you. Thank you, Chair. Thank you so much for Thank you so much, Dr. Foley, and I echo the comments of the Chair. Thank you so much for your patience.
Can I just say, just before we start,
Sure.
I've just been advised that we can release Anne Stowe. So because you have no questions, I've got no questions, and I've just confirmed with some of the crossbench they don't have any questions. So just before we start, your questions to the Office of the Chief Scientist, if I can just say to Anne Stowe, you're free to go. You're relieved from duty. Thank you. So Senator Walsh, you have the call.
Thank you. Thank you again, Chair. Thank you again, Dr. Foley. I wanted to ask you a few questions about the importance of mRNA in the broader context of Australia's capacity to commercialise science. Is that appropriate for you?
Well, let's ask the questions and see what I can and can't answer.
Okay, thank you. So the pandemic obviously threw the mRNA technology into the global spotlight, and although the technology's been around for a while, the breakthrough with the COVID vaccine has been very significant. I'm wondering what your thoughts are about the importance of the mRNA technology into the future, and your thoughts on how important it is for Australia to secure capacity to manufacture mRNA vaccines.
Okay, so look, thanks, Senator. I'm really glad you're interested in this because it really is a brand new therapeutic. You're probably aware that the COVID vaccines, the two that are currently available, made by Moderna and by Pfizer, are the first vaccine or the first human use of mRNA vaccine for therapeutics. Basically, it's a technology that can potentially be used for a whole range of different areas, such as improved flu vaccines, cancer therapies, ability to reduce size of tumours. And Australia has quite a significant amount of research being undertaken currently across the different universities and medical institutes, as well as some private sector as well. So it is seen as sort of the next generation of potential therapeutics that can be developed quickly and shifted to a particular need at any one time. And we were very lucky. I think the stars aligned for us at the time when the pandemic hit, that the development of mRNA was being considered for coronaviruses of a broad sort, because they are, colds and things are coronaviruses. So that they were able to shift their focus to the particular pandemic. And as a consequence, we were able to see a very rapid development of a vaccine, which we've all benefiting from today. From Australia's perspective of being manufactured, of a possible manufacturing pathway, currently we actually don't have any IP that we can manufacture, which we have access to, but there's a lot in the pipeline. So the cadence of going through the process, which is being considered of setting up mRNA vaccine of therapeutic manufacture in Australia is a good one. It's you can see that we've got a lot of research and development in health and medical research. So building up that industry with that investment, I think, is a very wise one.
Thank you. And you mentioned in your answer there the applications beyond vaccines as well. And so just thinking more broadly, how important do you think it is that we develop the capacity to manufacture mRNA pharmaceuticals into the future?
I think there's a great opportunity there. You might have heard, I think it was last week or the week before, that the New South Wales government has identified a plan to set up a consortium of universities and the state government manufacture mRNA. So that's already been announced. We know that the Commonwealth government has gone through, is in the process, and you mentioned you've had some questions earlier with the Department of Industry, Science, Energy and Resources, who've also been going through that, and I've been part of that working group, helping them and assisting them on that process. So we're on track to be able to towards having mRNA manufacture, and it's going to be something which I think will have a big impact on human health.
Great, thank you. We are having a little trouble with your line, but we can generally hear you. So, Chair, I think we'll keep going.
We'll persevere.
All right, I feel like I'll put some earphones on and see if that helps.
Okay, thank you.
Is that better?
I'll just ask the next question and then we'll see how we go.
Okay.
So you mentioned before the sort of consortiums of universities and medical research centres. I think you referenced New South Wales, and we also have a similar sort of ecosystem in Victoria. How important is that ecosystem to of higher education, of medical research institutes, to support the commercialisation of this kind of technology and build manufacturing capacity for it?
Well, I think you hit the nail on the head there, Senator, is it's all about an ecosystem of having that whole throughput from discovery, having the skills and capability to invest and take new thinking and new ways of doing things through to creating products, which then have to go through clinical trials. Then you have to be able to translate that to creating a manufactured outcome, and then have all the marketing, the ability to, and logistics, because therapeutics usually require careful management so that we are able to transport them without them losing their efficacy. So it's all about setting up those ecosystems, which is at the moment an appetite I know in Victoria that's well placed. They've got all the Parkville area, which has got the, and also in the Clayton area, there's sort of those two dual health and medical research centres, and then particularly in the Clayton area, the desire to build up the manufacture in those areas. But I think around Parkville too, you've got CSL, who've also got their manufacturing plant nearby. So it's that thing, and it's on multiple levels too. It's creating the IP. It's also creating the workforce and having clear career pathways. So it's not just people going in and thinking they're going to be doing the research that leads to the outcomes. There's also really important career pathways into the manufacture, the aspects of commercial side of things with sales, which also requires a high level of skills. So having that ecosystem is sort of the design, which I know the state governments are all working towards in their different variations depending on what their focus is. And in health and medical research, it's the same thing.
Yeah, thank you. And I can confirm that the headphones are much better, so thank you very much for that. So just thinking more broadly, what is your sort of assessment of the situation in Australia of our ability to commercialise science? I mean, we've been talking about the med tech area and pharmaceuticals, but and you also mentioned there the work of state governments to build those sorts of ecosystems. I'm wondering what you think the sort of the challenges are that federal governments need to look at to help bring science to market and bridge the sort of the gap between the research and the commercialisation.
So that's a really highly relevant area and a great interest of mine, having come out of CSIRO. Look, I think what we've seen since around about 2015 onwards, quite a significant shift in the research sector and its desire to see its work not just end up as research publications, which Australia does brilliantly with, but to see this actually go beyond that. And you would have seen things such as the number of startups coming out of the university sector, as well as publicly funded agencies, seeing the growth in IP development, the number of patents being applied for increasing. If you look at some of the data that was only just come out, I should point out, since July and August this year through the Knowledge Commercialisation Australia group, which have published a report called Scopus that stands for, I'll have to look up what that stands for, and also they have an international program as well, that they're showing that there's a real lift up at the moment. Many of the statistics that we see coming through are quite dated particularly the OECD numbers are often coming from 2015, 2016 at the latest. And this data showing 2019 information is showing that we're got a real lift up, and it depends on how you measure it. So whether you're looking at revenue from research contracts with industry, whether it's spin-out activity, whether it's amount of IP or licensing activity, but if you can measure the impact and the translation of research in different ways. And at the moment, what I'm seeing in the data that's come out of the reports from the Knowledge Commercialisation Australia is quite a significant, encouraging shift. We've got a way to go. I'm not going to pretend we're where we want to be. But what we're also seeing is an appetite from the research community to want to be a founder of a new startup company. We've seen the Main Sequence Ventures being a major contributor there, and other venture capital companies coming in and investing in some of these startups. And then what we're also seeing is these innovation hubs, a bit of a culture of improvement in understanding what it means to make something commercial. And so in many ways, what we're seeing is a shifting culture in the research community. We're seeing different states, territories, and the Commonwealth providing different incentives or programs which are supporting that. And I think I'm keen to see how we start seeing some of those classic metrics, which we always look at with a very sad feeling because they're never where we want them to be, start to lift up.
Okay, thank you. And you've mentioned there sort of a range of incentives and programs and the way in which we're starting to see some measures of commercialisation perhaps improve in different pockets in Australia. I mean, without sort of commenting necessarily on current federal government policy, I'm just wondering if you could sort of let us know what you think, you know, any future government of any persuasion should be looking at in terms of building sort of long-term certainty, long-term infrastructure in government to support the sort of commercialisation of science that you're talking about.
That's probably one of the areas where there's great opportunity for us, and that is looking at, for example, the NCRIS program, which has all the research infrastructure, has allowed us to have world-class research facilities, which are then openly used by across the nation and also internationally in some cases. And this is something which a lot of countries look at with envy, the way we've organised ourselves there, and that's been an ongoing program for some time now. What that does, though, is end pretty much at the lower technology readiness levels, when at that discovery level. And there's great opportunity for us to start seeing how we can have scale-up labs. There's a little bit of that in some publicly funded agencies like CSIRO and ANSTO, where you're able to take, say, a product and commercialize or sort of scale it up to the point where you can get investment to build your own factory. And a nice example of that was what happened with V2 Foods. And then we're also seeing, for example, with some of the state governments, like South Australia has got their Tonsley Park, New South Wales has got a range of different precincts, and as does pretty much every state and territory, where ACT as well as Victoria and Western Australia, where they're identifying where their focus area is and their opportunities, because what we must remember is that there's not a homogenous approach across all the states and territories as to how what they're interested in, what they're investing in creating those sort of hubs and central places. And so I think, and when you're saying what do future governments need to do, is make sure that we're investing in the areas that allow that translation, and also create the incentives. At the moment, the incentives for a researcher are still quite classic, number of papers published, prizes won, citations, and that just defines whether you're good or not, whether you're successful with getting grants and being able to stay in the research sector. What I'd like to see is us to have a broader range of metrics which would support women as well as a movement between someone coming in a career where they might be in university for a while, spin out a company, work with that. I'll work with a company in general, work in government or public funded agency, and feel that they can move around, and the work that they've done, it has some way of being accredited and seen as being able to be competitive when they move from one sector to another. So there's sort of some of the things that I think would make a very big difference, and I know it's something that's being talked about and I raise regularly.
You mentioned the issue of women there, and it was occurring to me as you were speaking that the Victorian lead scientist who is leading
Amanda Caples.
Yes, Dr. Caples, who's leading the mRNA bid, or involved in that, and has a long interest in commercialisation and the growth of the pharmaceuticals industry in Victoria. The two of you are very impressive women in your field, and I'm wondering what the situation for women in this area of trying to commercialise science and build advanced manufacturing in Australia is, and what sorts of initiatives we need to be thinking about to encourage more women into this space.
So there's a couple of programs that are in existence at the moment which have been very successful and heavily subscribed. So that's, for example, the Women Entrepreneurs Program. I think they got some very surprising number. I don't have the figures on me, but it was hundreds of applications, and that's showing there's a real appetite. If you just look at the numbers, and this is not just in Australia but globally, venture capital often is not choosing women as founders as a place to invest their money, and this is always a challenge. The other is also looking at in other areas, not in STEM-related areas, but in other areas, you see that a lot of companies that are founded by women are very successful and have really good track records. So I think one of the things is a real, well, as I said, we're still only at that early stage of seeing more researchers looking to commercialise their work through spinning out companies and starting their own businesses. And I know that I think in the last budget, there was also the announcement of some scholarships for women to do PhDs through industry. So there's, desire to see if we can open up those pathways down that way. And I think the work of the STEM Ambassador for Women, Professor Lisa Harvey-Smith, is another example of getting in there, looking at what's working, measuring, and setting up ways to measure initiatives to make sure that we pick and focus on the ones that are successful, because at the moment we've got a whole range of different initiatives and we need to make sure we know which ones work and then focus on the ones that do.
Senator Walsh, just an indication in terms of how you're going in terms of time.
Yeah, just one or two questions on a different topic, so just a few minutes.
Thank you.
So thank you, Dr. Foley, for all of that insight, and I just wanted to ask you about reports that there's an increase in concerns amongst scientists about their safety in certain areas. So a survey published in Nature found 1 in 5 scientists who were working in the medical field during the pandemic reported receiving death threats. And I was wondering if, as chief scientist, you've sort of had similar intelligence about that sort of trend and what you think the causes of those sorts of reactions towards scientists might be.
Yeah, unfortunately, I do know too much about this, and I'm appalled to see scientists, particularly those who've been fighting and on the front line of dealing with the pandemic, have faced this sort of kind of abuse. Some of them have had death threats, they've had online abuse, they've had emails to them directly, and it's not okay, basically, that scientists should be treated like that. Every person should be able to go to their workplace, and I think it should be a common human right to be able to do your work without being harassed and threatened. So this is something where I think is a consequence, and one of the, as we know, the sad outcomes from social media, and it's something which we really have to stand up to and say that it's not okay. I know that science has really shown, particularly during the pandemic, its value and how we can provide information that really can change the course of human prosperity, well-being, and opportunity. And the fact that we're seeing some people feeling that this, for some reason, they may not agree with it, but they feel that they have a right to threaten people is beyond my understanding and comprehension. All I can say is that, for example, there was a movement from the research community writing a letter of support for researchers, particularly in the Australian government. Some of our health professionals who've been dealing with the pandemic have had some pretty serious abuse. And I think it's fantastic to have seen the research community coming together and really standing up, saying that they're supported and that this is not okay.
And thank you. And just finally, do you think that there's a role for leaders, community leaders, political leaders as well, to sort of change the national discourse on science and try to reverse the trend that you've just described?
Overall, I'd say the trend is that there's a very positive view on science, especially since the pandemic really, I think, brought it home, where in a 2-week period you would see that turnaround from advice being given and being adopted, and then the consequences of that advice being seen. So that was almost like a sort of a reality TV show science experiment in real time. I think on average, the community does support research and science. It's something which I think, from my perspective, is really pleasing to see. If you look at some of the research that's been done looking at who are these trolls and how many they are, quite often they're very effective at getting this. If one person can look like they're a huge body of people with a particular perspective, and therefore amplify what is really one or two, or a small group of people's perspective and attitude and voice. So I think we need to be careful that we aren't saying that science is being questioned in a major sense, but there is elements.
Yeah, I understand the clarification that you've just made there, especially given the overwhelming support for scientific advice during COVID. But just on that question of the sort of the more marginal groups there that are engaging in the sort of hostile activities that we've just been describing, the question is, do you think that community and political leaders have a role to play in the national discourse on science in a way that might help limit or neutralise that fringe, I guess, of negativity that we've just been talking about?
I have belief that our elected officials really have that role to play of being leaders and taking on board the evidence that is provided. That's why we elect people into leadership roles in government, is to be able to show that leadership. And I think the community does look to our elected officials to be able to show that leadership.
Great. Thank you very much, Dr. Foley. Thanks very much for answering all of those questions. And I think I'm going back to you, Chair. Or I could keep going all night here.
Thank you, Chair. I'm sure you could, Senator Walsh, and I'm sure you could, but I appreciate that you're not. Can I give the call then to Senator Rennick?
I'm fine.
You're fine?
Yeah.
Okay.
Sorry,
all right. Well, thank you very much, Dr. Foley. That was very much appreciated, and we do thank you for your patience. Thank you very much.
Oh, my pleasure. Thank you for the time tonight.
Thank you. Now, I don't think we've got any questions for Geoscience Australia. No. Okay, so, and we can change ministers now, Minister Seselja.
Wow.
So it's,
That's right.
This week? That was the same week, wasn't it? That was this week.
The only rule of Fight Club is,
I just broke it. I didn't choose to be in it though.
Is there something in particular I need to say before this section? Oh, no, that's the end. That's right. No.
So we're up to
You've done that? So we just kick off. Okay, all right.
I do apologise for not having it updated.
Oh, don't worry. Okay. Welcome, Minister Mackenzie. It's wonderful to have you. We were just looking for someone with your vigour and stature to get us through
On a Thursday night of estimates.
Thursday night of estimates. So it's all come together very well. So I might pass the call to Senator Watt.
Thanks,
If I could.
Chair. We have some questions, probably to the department, about the resources sector in general, and then we will have some for NOPSEMA as well. NOPSEMA appear in this section too, don't they?
They do. They do.
Yeah. Cool. So, obviously there's some pretty interesting things happening with the iron ore price at the moment. What does the department consider has led to the halving of the iron ore price since July?
Yeah, Russ, do you know? Sorry, we just need to change it.
Sure.
I do.
Hello, Jawanta Karunaratne.
I think you can take, if you feel comfortable. And if you, just your name and title, please.
Thanks. Jawanta Karunaratne, General Manager of the Resources and Energy Insights Branch. I apologise, I left my name tag back in the other room. So we obviously monitor the iron ore price quite a lot. We produce our Resources and Energy Quarterly, where we cover what is going on in terms of the iron ore price and iron ore demand. What's been happening lately in China is there's been a withdrawal of additional fiscal stimulus, and China's also been implementing its 3 red line policy, which is effectively prudential regulations to tighten up borrowing. And there's been renewed outbreaks of the pandemic. On top of that, thank you very much. On top of that, there's been energy shortages. So all of that meant that all of that contributed to a contraction in demand, and that's seen the iron ore price come off its highs, which we always did forecast would happen, but it has come a bit faster than we expected.
Right. And what's the expectation going forward about the price?
So I do have some figures with me.
If these are in published documents, just feel free to refer me to them.
Well, yeah, they're published in our Resources and Energy Quarterly document. But it is to stabilise and decline and stabilise at, I think, around about the $100 mark.
Okay. Has the department assessed the impact of the price fall to the viability of Australian iron ore projects and the potential impact on jobs in the resources sector?
So we don't do that through our forecasting. The iron ore prices are still they're still higher than what the big large projects need to cover their costs. But we have been told anecdotally by industry that some of the new players that were attracted by the really high price, that they would struggle because the price that they needed was higher.
So are we expecting any loss of jobs in particularly the iron ore sector as a result of this price fall?
I haven't got an expectation, but I'm not sure whether my colleagues do. No.
What are you hearing from mining companies?
None. Actually, the other way around from mining companies is that they're facing staffing shortfalls.
Yeah, that's a huge issue.
Yeah.
And I'll come to that in a little bit. And there's obviously been a fair bit of talk and media coverage of the issues around the Chinese property developer Evergrande. What's the expectation around the impact on iron ore prices relating to Evergrande?
So it's really uncertain. It is a risk point for the price. There's a couple of factors. Is that one is, how systemic are the issues that Evergrande faces compared to the rest of the property sector? Is it isolated? I've heard some commentary that it's relatively isolated to Evergrande itself. Others have a different opinion. And then there's a question of, well, what intervention would the Chinese government, make in order to keep Evergrande operating? And the signals that we've been seeing suggest that they are quite willing.
They are quite
willing to intervene.
Right. Okay. So at this stage, we're not overly concerned about that.
It's a risk point. It's very hard to quantify the risk.
So, of course, this crash in the iron ore price will have also had an impact on the tax revenue that the Commonwealth receives. Do you know how much less tax revenue the Commonwealth will be receiving as a result of the iron ore price fall?
I think that would be a question for Treasury. However, I do note that Treasury, in their assumptions about the future iron ore price, was quite a bit more conservative than what we're even currently forecasting now, and it's still more conservative than the consensus economics forecast range.
Right.
I think it was the assumption in the budget was US $55
That's right.
by the end of the March quarter.
That's right.
Okie doke. And has the department been doing any work, perhaps with other departments as well as companies, to develop new markets for iron ore exports?
I think the department has, in terms of global resource strategy.
Sorry, Senator, if I can just answer that question. Paul Chopman, Head of Resources Division. So we've been doing a lot of work as part of the Global Resources Strategy, which was announced by the government as part of the 2021 budget. We've been doing a lot of analysis work in terms of seeking diversification of markets. Iron ore is a central part of this, along with coal, and also other commodities, including nickel, copper, and also gold. And what we're looking at specifically is whether there's opportunities to open up new markets, especially in the ASEAN countries in Southeast Asia, and then also focusing on countries like India, and whether there'll be growing opportunities in those markets.
Okay. Just moving on to coal exports to China. We've talked about this before, been a big issue for a while now. Can you give us an update on how much Australian coal remains stranded on bonded warehouses in China?
So I think the latest update I received, Senator, is that roughly there's 2 ships that are waiting to unload their cargoes, and that's a reduction roughly, I think, in the last 6 months down from about 70 odd ships. But I can come back to you on those.
Only 2 now?
Only 2 now, yeah.
Does that mean that the others have all unloaded, or have they gone to other destinations?
I think the majority would have unloaded, and then there would be some that would have gone to other destinations as well. But the majority definitely would have unloaded. In
China?
Yes.
Okay. And sorry if you've covered this already, but does that include ships carrying Australian coal that remain stranded at sea and unable to enter Chinese ports?
Yes, I think so, Senator. That's
Okay.
what the figures we're talking about is the total figure, which is there are only 2 remaining Australian coal ships.
Okay, that's the ships. I think my previous question was more about coal that remains stranded in warehouses, so it might have been unloaded, but it's not really being used.
I'm not actually particularly across that issue. My understanding, talking to the industry, is that the coal has managed to find equilibrium and that most companies have found alternative markets. So there's not really an issue in terms of any stockpile either on the water or in warehouses as far as I'm aware.
Okay.
My understanding through the International Energy Agency is that part of this has been driven by China's at very low levels with respect to their own stockpiling. And so whether that's flowed through in terms of ships to stockpiling or being left isolated, Mr Trotman's dead right in terms of there only being 2 ships left offshore, outside of port, down from in the 70s.
Right. Has the Australian government received any official information about coal import quotas that China will apply to Australian coal this year?
Look, I think that question is probably better addressed to the Foreign Affairs Defence Committee, but as far as my knowledge is aware, it's only informal, so I'm not aware of any formal.
What's the informal intel telling us?
Just what's been happening over the last 12 months. It's quite well known and widespread that there appears to be an informal ban on Australian coal.
Mm-hmm. So that hasn't changed in an informal sense?
No.
There's obviously been many reports that some of the Australian coal that had been waiting for clearance in China has been on-sold to Vietnam and India. Is that correct?
Again, Senator, I don't have that information in front of me, but that sounds like it would be correct. As I said, that the coal market is in the coal market is in a very good state at the moment, and companies are not finding it difficult to find other destinations for their coal.
Yep. And of course, a range of factors, including the shortage of coal in China, has led to heightened coal prices. Do you think that Australian coal producers with stranded coal stockpiles in China will see any windfall gain from this price rise?
I think it's probably best put that I think some of the traders who deal in coal, not necessarily Australian companies, because they've already sold off the coal, would probably find benefit from any windfall gain. So the traders who would be Chinese based. Okay, and the shortage of coal in China and therefore the demand for it in China, has the department analysed medium and long-term impacts of those factors on Australia's coal mining communities? Look, we do regular reporting and analysis to Minister Pitt in terms of the impacts on regional communities. If there are potential coal mines that may go out of business, but we're not finding at this point in time that any particular region is under any particular pressure.
It's in part just a similar answer to the iron ore question you asked before, Senator, which is some mines are very price dependent, and so as the price has dropped on iron ore, some mines have gone back into care and maintenance. They can be restarted when with respect to price. It's the same thing with coal.
Yep. You mentioned Minister Pitt in passing. He's had a pretty good week, obviously, on a personal level. Minister, can you just remind me?
Sorry.
That's okay. I didn't want to spring this on you. Minister, can you just remind me, Minister Pitt is now back in Cabinet as the Resources Minister?
That is correct.
Right. When was he sworn in? Or is there a swearing-in ceremony to be moved from the outer ministry into the Cabinet? I've never had the good fortune to have that happen to me.
I think that's at the discretion of the Prime Minister.
Right, so it's not a separate swearing-in process or anything like that. It's just a movement from one to the other.
I think swearing in is a portfolio.
Yep.
Minister Pitt's portfolio
Hasn't changed.
Yep. But he started getting paid the higher salary, presumably, as the
I haven't seen his pay slip.
cabinet minister. Has he gained any more staff as a cabinet minister?
I'd have to take that on notice.
And I know that this is really a question for SMOS, allocation of staffing. Has the department noticed any increased allocation of staff to Minister Pitt in the last couple of days?
I'd have to take that on notice.
Yeah, but you haven't noticed anything?
I personally haven't noticed anything, but that's not to say. So I'd rather take that on notice.
Yeah. Has there been any difference in the resources section of the department's interaction with Minister Pitt since he became a cabinet minister? Is it just continue just as you were, except he gets a bit more pay?
Senator, in terms of his resources portfolio,
is he swaggering a bit more?
And his allocation of responsibilities, that hasn't changed for the resources area of the department.
No.
Since he came into the job. So regardless of stature within the government, we've continued to provide Minister Pitt, hopefully, with the same level of service.
So he's doing exactly what he was doing. He's had no real change except he's just taking home a bit more money.
Well, Senator, what matters to a department is what the minister's portfolio is, and as Mr Sullivan says, we've continued to service him as strongly as we ever have.
No, in all seriousness, we obviously criticised the government when resources was kicked out of cabinet, so I think it is
where's the press release celebrating it?
Oh, I've said a lot about Minister Pitt over the last couple of days.
Senator, it is great to have the resources and the water portfolio back in cabinet.
Yeah, I don't think they should have ever been removed. Did you?
It's not a question for me.
So just on jobs in the coal industry, I've got some questions about net zero and what that means for the resources sector in a little bit, but while we're talking about coal, Minister, there's been a lot of commentary this week about what net zero means for coal miners and coal mining communities and the coal industry. What would you like to say to coal miners about their future now that the government has apparently signed up to net zero by 2050?
Well, I think the plan that's been adopted by the government absolutely backs the strong demand that we see over coming decades for coal, and by using technologies such as carbon capture and storage, that demand will be able to met in a lower emissions environment over time. So the National Party in particular within the government absolutely supports our coal miners and indeed our entire resources industry. And you will have been very concerned, Senator, to hear the Greens wanting to shut down the gas industry, not just the coal industry, but the gas industry. I'm interested to see what you and your Resources Minister, Shadow, have to say about backing miners in this country, because other than Joel Fitzgibbon and Meryl Swanston, I don't see much.
Well,
what do you say?
I refer you to my many transcripts and press releases where I've said that we support the coal mining and gas industry. I mean, I'm happy to get you to subscribe to my press releases if you'd like to do so.
Yeah, I must get onto that.
Yeah, it's good reading.
Yeah, well, so you say.
So when over the last, particularly since the last election, we all know that there were lots of things said about Labor's position around the coal industry at the last election.
Labor was saying a lot of positions, depending on where your leader at the time was in the country. That is actually the reality. So when they're up in central Queensland and, the LNP seat of Capricornia, he was saying very, very different things about the mining industry than he was in my home state and his down in Melbourne and Brunswick. That is the reality. And the Australian people weren't going to be taken for mugs.
Is that kind of like how now we've got Senator Canavan, George Christensen, a number of other national MPs in central Queensland saying that they oppose the government's position on net zero, and how we've got Liberals in the cities saying they support it? Is that kind of like what you're saying Labor did at the last election?
So I've just been advised that the International Energy Agency predicts that even under a net zero proposition there is a bright future for coal, gas and oil. So that's not just the National Party saying that. It is actually the International Energy Agency.
That sounds
Senator?
an awful lot like things that Labor has been saying for quite some time now. Why
You're a
was
bit
it,
late to the party. If
We're
you're
a bit
saying
late to
it
the
now,
party.
if you suddenly
We're a bit
realise
late to the party.
that mining jobs matter in this country, the people, men and women who wear blue singlets to work actually matter.
They don't wear blue
No,
singlets
I'm
in
sorry.
mines.
I'm sorry. Michael O'Connor
Have
got
you-
it right. He did.
That's forestry?
Yes, I understand that.
If you've been to a
And
coal
I
mine,
wish-
you know they don't wear blue singlets. That's actually highly unsafe.
Well, Senator Wash, I am very proud to be part of a political party that backs the working men and women in this country. Doesn't matter whether they're in forestry, whether they're in agriculture, whether they're in mining. And our government will continue to do so.
In that case, why have you done nothing for 8 years around the labour hire and casualisation crisis in the coal mining industry?
I think the
in the Hunter
employment,
Valley and the central Queensland?
I think the employment Senate estimates is being chaired by
But you've
Senator
said
Canavan
that you care
at the
about
moment.
them, so you might want to take the opportunity to say why you haven't done anything about labour hire and casualisation for 8 years.
What's your plan? What's your plan?
Well,
You come in talking a big game, swinging it around, suggesting that, you guys have a plan and back mining workers
it
in this
seems that you're
country,
kind of
but
starting to
our
copy
government
us.
has actually put a plan on the table that delivers a positive future as well as lowering emissions.
Is that the
And the
slideshow?
reality is that the Australian people have rejected your climate policies for the last 3 elections. For the last 3 elections. So are you saying that they don't get it?
No, I suppose I'm just
Well,
wondering why...
What are you saying?
So you say that Labor's late to the party on this, and you're
You're late to
just
backing
been...
miners.
You've been texted...
Because they knew you didn't back them last time.
You've been texted
or the time
by
before,
someone that the
or the time
International
before that.
Energy Agency says that miners have a bright future regardless of net zero 2050. You do know that's exactly what Labor has been saying for a long time, but we're the ones who are late to the party?
Well, Senator, it would seem that the miners in this country didn't believe you.
Why would that be? Would that be anything to do
You'll
with
have
the
to
lies
ask
that they
them.
were told at the last election, do you think?
You'll have to ask them. Well, I think it had something to do with them being hearing one message in one electorate and hearing the complete counter message in another electorate.
Well, thanks for
and you know
raising
what?
that
Thanks
again,
to
'cause we sort of got-
technology, they worked it out.
Yeah.
They worked it out.
No, I appreciate you
Tons.
bringing us back to that point because we were there 5 minutes ago. So how's that any different to Senator Canavan, Mr Christensen, your candidate in Flynn, a whole range of other people, National Party MPs in central Queensland right now saying that they oppose and will campaign against the government's position, and then you've got Liberals in the cities saying that it's great and they'll support it. Isn't that exactly what you're saying Labor did last time?
Well, as a government, we won't have our leaders running around saying one thing in one electorate and another thing in another electorate. The fact is, the National Party and the Liberal Party have put forward a plan that actually protects regional Australians and secures future opportunities for them under a plan that's driven by technology for net zero 2050. That's the facts.
But the bottom line is that you now, like Labor, what we've been saying for some time, you agree that...
The big difference is we have a plan. The
So-
big difference between the government and the Labor Party is we have a plan.
That's the
and
slideshow,
you
you
don't.
mean, is it?
You don't.
Is that the slideshow?
So, Senator,
But-
I would love to see your plan for
Well, what-
2030,
But what's
for
changed?
2040,
I suppose I
for
don't understand what's
2050.
changed because the slideshow that you keep calling a plan is based on your government's existing policies. So why was it that under these policies, say a month ago, net zero by 2050 wasn't possible, but now exactly the same policies will deliver net zero by 2050? How does that work?
Well,
It's
because-
it says under the government's existing policies.
I'm glad you've read it, Senator. There might
Well,
be
there's
some
only
good
about-
ideas you can put in your
There's
plan.
only about 11 pages in the plan. It's pretty easy
where
to read.
where does Shadow Minister Miles, your Deputy Leader, sit on the bright future for coal? Does
You'd
he
have to-
agree with the International Energy Agency or not?
Sorry, point of order. Senator Patrick, point of order.
I think Senator Watt's quite comfortable. I don't think he needs you to run interference for him, Senator Patrick. I know you are. You're very good, Senator, protecting the Labor Party.
Because, I mean, I'm just a bit baffled about...
Now it's going to be 3 ways.
I'm just a bit baffled about this slideshow and what you say is the plan, because...
Why don't you, have you tabled it yet? So everyone can...
Oh, I'm
get a
happy to
copy?
table it.
Yeah.
You haven't read it?
I know it's in the plan.
When did you first see it?
Oh, that's all public knowledge.
Because we've heard a lot about how the National Party was going to fight for changes, secure the region's futures, and then when the slideshow is actually presented to the Australian public, it's all about the government's existing policies. So what have you achieved apart from a pay rise for Keith Peart?
Well, Senator, the Australian might not be the first read that you do every morning, but there was some commentary today about
In fact, I read that late last night.
methane emissions and agricultural safeguards. There's a whole raft of measures, which is why I think this department itself made commentary. You might not have been in the room, and Secretary, you might like to advise the Senator of having to reprint documents post a cabinet meeting on Monday night.
You know that Liberal MPs have spent the day telling the media that the government had well and truly established that they weren't going to agree to changes around methane laws. So that's actually not a win for the National Party. That's what Liberal Party MPs have been saying.
So you're accepting Liberal Party MPs' background in media?
I would marginally believe them ahead of National Party MPs. I'd marginally believe them ahead of it. So
I'm not interested.
There's been no change around methane policies.
According to who?
But the plan's based on the existing policies. This was presented on Tuesday. So the plan was based on the government's existing policies. So actually the National Party didn't achieve anything except for a pay rise for Keith Peart. That's
Do
the
you
one thing
really
you can
need
point
Green
to.
Party preferences this much, Senator Watt?
No, we're going to win it on primary votes.
You're going to win it on private, so you can guarantee...
That's my plan.
That's your plan.
I've got a slideshow. I can show you my slideshow.
Have you told Adam Band? Have you told Adam?
I've got a slideshow.
Yeah.
It's probably as credible as yours.
I think that is a great concern to the people in rural and regional Australia, an Albo-Adam coalition government after the next election. And they know exactly what you will do to the mining industry, to the agriculture industry, to the forestry industry. Might get the forestry division of the CFMMU fighting for us.
Do you support
the way you're going?
Do you support labour hire and casual coal miners in Queensland and the Hunter Valley being paid the same job as same wages
Senator,
as permanent miners?
It seems that this is your only point of differentiation.
Yeah, it's a pretty big
what
one.
I think you should actually do, if you care so much about a low emissions future, so much for the planet, put your money and your words where your mouth is and tell us what your plan is. We've shown you ours. Show us yours.
Well, it didn't take very long to read it.
I'm glad you have, though. I'm buoyed. I'm buoyed that you've read it.
It took me about 10 minutes this afternoon.
Senator Watt, I've been very patient, as you would have
I'm happy
noticed.
if you want to I've got others, but I'm happy if you want to rotate the call a bit.
Yeah, if I could, and I might
he needs
just
new material.
I might just direct some questions, if I could, to the Deputy Secretary, and I'm doing so as someone who comes from the mining industry, and one of the points I note is that some of the great Japanese and Korean companies, industrial giants, who assisted the building of the mining industry in Queensland, such as Mitsui, Mitsubishi, POSCO, Itochu, they're entering into the hydrogen space in a big way. They're absolutely committed to entering into the hydrogen industry. And I'm just wondering if you can provide some comments with respect to how important are those relationships for the industry moving forward, those long-standing commercial relationships with some of those industrial giants from Japan, Taiwan and Korea.
Thanks for the question, Senator. Obviously, they're critically important. It's no secret that North Asia, and in particular Korea and Japan, have set their own targets around not only emissions reduction but also with respect to hydrogen. Japan has set itself to be a major user of hydrogen going forward, both in terms of their electricity and manufacturing, but also in transport as well. And I think the bilateral relations that you talk about are long-standing, both at officials level and at ministerial level. They have... And
also, sorry to interrupt, but also at a commercial level.
And at the commercial level as well. But that's the conduit into that in terms of my role being co-chair of both the Korean and the Japan bilateral resources groups that talks about hydrogen and how we make that transition to hydrogen. Those relationships in terms of the past are really important for the future, and those relationships are being developed as a major pathway going forward. There are also obviously on-ground hydrogen partnerships working in Australia as well, and Mr. Trotman may talk about.
Senator, back to your question around the great relationships that we have with Japanese companies, obviously with the hydrogen energy supply chain project that's being jointly funded by the Australian government and the Japan government, as well as the Victorian government. It builds on existing relationships with Kawasaki Heavy Industries, for instance. The project will place Victoria and Australia at the forefront of the global energy transition to lower emissions through clean hydrogen. And the important thing about the project, it will be the first demonstration of a hydrogen supply chain from fuel source producing country through to the user country. And Victoria's Latrobe Valley, as you would be aware, contains one of the world's largest deposits of brown coal. And so when we use with carbon capture and storage to produce low emissions hydrogen, it really has the potential to be a significant clean energy supplier, not only to Australia and Japan, but other countries.
So it's really important, is it not, that we take advantage of this present opportunity to build on those relationships and move as quickly as we can to make sure that we become the supplier of choice in the future for those great North Asian economies, Japan, Taiwan and Korea. Is that correct?
Absolutely, Senator. And for the record, the industries in terms of that consortium out of Latrobe is Kawasaki Heavy Industries, J-Power Electric Power Development, Sumitomo, Iwatani, and the Japanese government itself. So it is and that interest level amongst major North Asian corporations is significant in terms of Australia. And for our perspective, that's part of the opportunities around the energy transition with respect to new technologies and hydrogen being at the forefront of that.
I saw recently that another great North Asian company called POSCO has made a takeover offer for a great Queensland oil and gas company called Senex. Are you aware of that recent occurrence?
We have received some reports. My general manager, who's in charge of the onshore energy and minerals branch, was only telling me earlier today about that piece of work that Senex is doing.
Yep.
So again, it provides a real opportunity to get behind the government's gas-fired recovery agenda. Senex is a company that has had many successes in recent years, and we are very hopeful that along with other companies in Queensland, especially in the Bowen Basin, but also in the Galilee Basin, that they will provide that potential to provide the gas to the southeast market for the next 10 to 20 years. I guess Senex is a little bit different from the Galilee and Bowen Basins. It's more centred around Surat, but they've done some wonderful work.
They have indeed, and I really do compliment them. They're a great Queensland success story. And in relation to that transaction, one of the things that interested me was that POSCO is actually a player in the hydrogen industry space, but at the same time as being involved heavily in the hydrogen industry space, it's made a takeover offer for a mid-tier oil and gas company in Australia, which from my perspective shows the positive future for Australia's oil and gas industry. It's almost as if it's a vote of confidence in the future of the oil and gas industry in Australia. Is that a fair comment?
Oh, definitely, Senator. And I guess also when I talk about the gas-fired recovery measures, we also can talk about the government's hydrogen strategy when it comes to hydrogen hubs. There's obviously a lot of potential in regions around Gladstone in terms of providing that opportunity to create an export hub, and companies like Senex and others dealing in the coal seam gas industry have the potential to provide a future for many towns and many cities up and down the Queensland coast.
Yep.
Chair, it's a really important point in terms of net zero is often mistaken for no fossil fuels, and so the 30-year transition towards net zero it is a difficult pathway, but it's also one where there's still opportunities. And the Minister spoke about the IEA with respect to that. Without carbon capture and storage, it's very difficult for the IEA to make any pathway to net zero work. Whether that be in Europe, which has got nuclear power at its disposal, or talking about Southeast Asian economies where a transition from coal-fired power to renewables is very unlikely to happen in the short term just because of the lack of renewable resources, land availability, solar and wind availability. So that transition is going to be really hard, and so it's going to be not only important to think about that through the lens of different for each country and subject to regional and sovereign circumstances, but a lot of it's driven by the resources that are available for those countries. And Australia is recognised by the IEA as having some of the best hydrogen resources in the world. And so that's where our market advantage is, and we should be aiming towards that, and that's why we are aiming towards that in terms of an export industry as well as a domestic use industry. But that sense of net zero is really important. But in terms of the underpinning for net zero in Australia is about getting the cost curves down, not only in renewables, but also getting the cost curves down on carbon capture and storage, getting the cost curves down on other key technological components.
And just my final question before I pass the call to Senator Patrick. In terms of carbon capture and storage, could you provide some commentary around the opportunity for Australia in particular in terms of our geology, in terms of available basins which had previously been the subject of oil and gas extraction, and the opportunity that provides in a real practical sense for someone to develop a carbon capture and storage project in Australia as opposed to developing such a project in another jurisdiction?
Look, you're right. And Australia has got some key opportunities with respect to both onshore and offshore storage of carbon dioxide, and that's again part of our comparative advantage when we look at net zero. I think in terms of where we're going, Mr. Trotman will have more information about Australia's position in terms of what are the opportunities for us. But noting that while there's sometimes undue criticism of the Gorgon proposal in terms of carbon capture and storage, that's now up to 5 million tonnes, I think. And so these, it's not about the unproven technology. It's really about taking the research and development and then putting that to scale. And Gorgon is really an important part of that. But we're going to need a lot more of that to actually start reducing that cost and to hit those stretch goals to get that CCUS price down. But Mr. Trotman, you'll have more about it.
Thank you. Senator, look, we're really excited about the prospects in carbon capture and storage, especially around the government investing over $300 million in carbon capture and storage over the next 10 years with CCUS projects and hubs. This includes the $50 million that has already been allocated as part of the CCUS Development Fund, which was launched in March 2021, and also through the $263.7 million that's been allocated as a part of the CCUS Hubs and Technology Program. So I just, for people who are listening to the committee, the CCS Hubs and Technologies Program opened to applicants back on the 11th of October. and they'll be delivered through 2 streams. Applications close for that particular program over the next 2 weeks, so we'd be very interested if people are listening in to tonight's hearing that are operating in the carbon capture and storage space to make them or avail themselves of this particular program.
Excellent. Thank you very much. I'll give the call to Senator Patrick.
Just want to go back to some questions we dealt with on Monday, which you took on notice or said you'd answer for today. Firstly, there was a timeline for the reservation policy that had been announced by Angus Taylor, Minister Taylor, and I think Minister Canavan back in 2019.
October 2019. I did go back and check the record of the media release, Senator, and you were right. There was a timeline of around February 2021 that the government was aiming towards.
So that has passed.
So as I said in answer to your questions on Monday, so the government is still considering its options around the prospective gas reservation scheme. And it's yet to decide whether a national gas reservation scheme will be implemented. So the announcement back on the 6th of August was based on options to establish a prospective gas reservation scheme and examining whether such a scheme could succeed and to be applied at a national level. So as I said on Monday, we held consultations last year over the period of October and November. Those consultations closed back in December. I have a team working to me that's been working up options for the government, and we've been working closely with Minister Pitt in terms of developing those options, but it will still be a matter for government how that proceeds forward.
Sure, but if we go back to October 2019 and it takes a year to get a consultation up and running, did no one sort of take on the task after the announcement?
No. We got straight into work on it. Obviously, there's a number of complex issues that we need to address. As part of the consultation process, we work closely with other government bodies, both national bodies, industry associations, state and territory governments. We received over 40 submissions as part of the consultation process. We held 20 meetings across the country. We had to do this virtually in many cases because of COVID-19. And as I said, that we've been working very closely with Minister Pitt on moving forward on this consultation piece, but also on developing options. But yeah, we have been putting a lot of work into this, Senator, I must say.
Recollections of conversations I had with government were that if you got to this sort of point and you hadn't got agreement of the states on board, then you might exercise export powers in respect of a plan moving forward. Have you got the states on board? I mean, clearly Queensland's got their own, WA's got their own, clearly successful. And look, I don't have to see the submissions from industry. They'll say, no, we don't want to do it. But it's in the interest of the Australian public that we go forward with this, demonstrated by, again, Western Australia.
So
have we got the states on board?
So as part of the announcement back in August 2019, it was also announced that the government would work towards establishing energy and emissions reduction deals, or state deals as they're commonly known. And so the government has been working with Northern Territory government, with the New South Wales government, South Australian government, and also the Queensland government on state deals. It also forms part of the gas-fired recovery agenda, and as I mentioned on Monday, at the same time it was announced that the government would look into options around the Australian Domestic Gas Security Mechanism. As I said on Monday, that's still in place until 1st of January 2023.
And I note that there has been an adjustment to take into account the netback price, but just focusing, I just want to focus on the commitment made on the reservation policy, not the announcement made on the reservation policy. Have we got the states on board?
So, going back to the commitment was for consideration of options. So, Western Australia, likes their own scheme. Queensland, as you point out, Queensland have got their own scheme. New South Wales has a commitment with respect to New South Wales gas reserves should benefit New South Wales gas consumers. Victoria has a similar stance with respect to new gas production to be offered on reasonable terms to Australian users first.
But don't get swindled by everyone. Just read the ACCC reports about Australian consumers getting ripped off for gas prices by a cartel that you guys seem to be in bed with. You know, the reservation policy works. It clearly works in WA, and you're tinkering at the edges whilst industry suffers.
And I think it goes to what I said, though, Senator, that the government is still considering its options around the national gas reservation policy. It just hasn't settled on where to go forward on this particular policy. It's still looking through the options. It hasn't been.
What's the expected timeline to get to some government decision?
So absolutely, it will be a decision for government.
No, I know it's a decision for government, but you people work for the Australian taxpayers. If you're not
I just
working,
request that Senator Patrick treat these officials with respect and not say you people.
Sorry. I'll just say a few words.
Our officials work very hard.
Senator Patrick, I understand you're very passionate about this issue and have been for some time. And as you know, the policy decisions are not controlled by the officials.
I wasn't asking about the policy decisions, respectfully, Chair. I was asking about the timeline. And if departments aren't working to timelines, I'm sorry, Senator McKenzie, that's a huge failure, because simple project management tells you that when you set a task for people to do, you set a timeline. And I'm just asking what that timeline is. And if there isn't a timeline, there's incompetence here.
So let's just give Minister McKenzie an opportunity to respond to your question as to whether or not there is a timeline.
I thought the officials were answering that in a very appropriate way, and I didn't think that they should be. Maybe I'm wrong, Senator Patrick. Maybe when you say, "What are you people doing?" in that tone, you weren't being denigrating. It just sounded that way to me, and I was just stepping in to say, "Can we treat people with respect?"
Stepping back, a timeline involves dates. Can we talk about dates, please? What are the dates that have been set by the government in terms of trying to achieve this objective that they
I'll
have?
hand to the Secretary.
So, Senator, I am just simply going to reassert what Minister Trotman said. And you know, Senator, we as officials can't sit here today and describe for you what the government's timeline is. It's not.
You can.
We cannot.
Why can't you?
Because at the end of the day, that is a matter for government. When we say those words, Senator, like we mean them, like they're serious words to us, because at the end of the day, we are public servants that respond to government. And at the moment in this space, the best we as officials can say to you is that timeline will be a matter for government.
Okay, so the government set a timeline of February 21. It's clear that timelines are being set. Surely when that was handed over to you, you broke down the task into manageable chunks, assigning resources with a schedule. Tell me you did that, please.
So, Senator, Mr Trotman has described to you the volume of work that's been done on this, and he's explained the interactions with the states, he's explained the interactions with the market, he's explained the policy work that we then go away and do. So that he's given you evidence that all that activity has occurred. At the end of the day, yes, it hasn't manifested in a government decision yet.
Sure.
But that doesn't mean work hasn't been done and in a very dedicated fashion. At the end of the day, though, we as a public service can only sit here and say to you, ultimately, when the government decides and what it decides to do is a matter for government. But I can tell you we have done the work.
But in terms of management of tasks, you accept that when you set out a project of any type, you set out manageable chunks, deadlines. Some of them are dependent on each other, and it's a continuous process. Sometimes you go, something's blown out in terms of time. You readjust the schedule, but you have a schedule, and I'm just asking for that. You might not end up meeting the current schedule, but I'm just simply asking what it is. And if there's no schedule, it tells me someone's doing something very wrong in the way in which you manage projects. And I'm a project manager.
So, Senator, it's clear.
Are there schedules?
Of course there has been
Okay.
in the past, because now we've described to you the work that has been done. It's been done in a timely fashion. It's been done in a professional, credible fashion. As to what the time frame is into the future, I can't tell you that, because
Why
it
don't
is
you
a
have a
matter for
time frame into
government.
the future? If you set out a schedule, we agree that's the way you do things, and you had a final target date. Are you telling me you don't update those schedules? Just let it run on. Just say, I'll just, you've got to set expectations in terms of time.
Can I tell you, my expectation of my staff is that they continue to work on their projects, and they don't necessarily need an end point, because in the public service we're used to doing work to timelines that we set for ourselves, in the knowledge that that work could get to a point where there is then a government decision that is required, and then is a matter for government.
We've wasted 10 minutes just trying to get a schedule.
You say we.
Sorry? Well, the committee spent 10 minutes trying to get a simple schedule. Basic organisation. You lay out a schedule. It's not supposed to be a hard question.
But Senator, I can't give you that schedule.
Well, that tells me there's incompetence inside your organisation.
That's a
have
matter for
answered your
government.
question.
That tells
as
me there's
best to their-
incompetence inside the organisation if you're not setting out.
I reject that completely.
Setting out schedules.
Senator, I reject.
Sorry, Senator Patrick.
I'm challenging the way in which the business.
I
the government is doing the business.
I understand, but you do need to give the witness an opportunity to provide an answer to your question.
So, Senator, with the greatest respect, I do reject that, because at the end of the day, what you're actually asking for is what the government-determined timeline is for a decision about this project, and that is not in my gift to inform you.
Okay, but you will have broken this task down into chunks. Mr. Trotman will know what the next thing is that he's got to do. Then he's going to know what the next thing he's got to do after that, because he will have made a plan to get to the end somehow, and that will involve a schedule. It has to involve a schedule.
So, Senator, we can go around this circle all night if you like, but I've
I'll
given
do
you
it by way of
evidence.
FOI. I'll FOI all the documents relating to this.
And that's fair enough.
And if we come back and there are documents that deal with schedule, I will take it further. Okay.
Well, let's wait and see.
All right. Let's move on then. Can we go to the matter that's was reported in the Guardian in relation to proceedings between the EDO and the Minister before Justice Griffith? And I don't want to go to the substantive nature of the proceedings, but just the concern I have in the report, and I'm not going to who's right in the argument.
So, Senator, I will be treading very, very carefully here for obvious reasons.
Sure.
So I'll wait to hear your
No,
question.
so I'm not going to go to the substantive dispute.
Yep.
Could I just before you continue, Secretary, do you need a copy of the article? Do you understand?
Well, let's see the question, because
Sure. Okay.
I won't prejudge.
So an issue was raised. It's a procedural issue in which it's reported that the minister made an undertaking through the lawyers to the court that no grants would be, or payments of money would be entered into in respect of a party, and then the minister proceeded to make some grants. So it's not really to do with the court case, it's to do with an undertaking given to a court by a minister that was then not followed through.
Senator, that matter that you've just described has been pleaded by the applicants in their claim, and therefore it is absolutely subject matter of the proceedings that are on next week.
So there's an affidavit that's been required for you guys to file.
Correct.
And so what's Justice Griffiths going to determine in that matter?
So that affidavit, just to be clear, Senator, that affidavit has been filed and has not been read.
Sure.
So therefore it's not...
It's covered by the
my
harm and
gift.
obligation, but that's
Correct.
and I understand that.
Correct. And then, Minister, precisely the issue that you've described is as a result of the construction of the applicant's claim is justiciable next week in the court.
But even just I'm just dealing with the undertaking without...
Correct.
Yes. So I'll try this and just see what you're comfortable with answering. Is it in dispute from your side that the undertaking was made?
So that is a matter that's before the court.
But is it in dispute? But both parties agree it.
I can't say that, Senator. And you've got to give us a little bit of leeway here. I can't say that. I'm very, very conscious of the obligation not to discuss any issues that are sub judice. That issue that you're asking me questions about is sub judice.
So just so you understand, the sub judice conventions of the Senate, there's a Heffernan advice on this.
I've got to. We've discussed it previously.
Yeah, talk about substantial prejudice is the bar that must be met.
Yep.
And also in relation to the Harman obligation, there's a High Court case, Hernan Street, and you might want to go and have a look at what Justice Kirby said, Orbiter, in that particular case about the Harman obligation as it applies to parliamentary proceedings. So, you can't tell me anything more about what appears to be a minister reneging on an undertaking given to a court.
I can't tell you anything more about that matter.
All right, we'll visit at the next estimates then. Yep. We're glad to do that. Okay.
If the legal proceedings have been resolved, Senator.
Okay. I might actually, well, one presumes the proceedings will be. Can we take this on? Can you take this on notice to provide a copy of the affidavit, noting that I think as of next week it will be read into court and publicly available.
So I will take that on notice, and we've done this before.
Sure.
You've asked me previously, and I have taken on notice, and you remember we provided it to you, but that's after we received legal advice.
Sure.
And so, of course, I would want to seek legal advice about that. And yes, it won't be until after the legal proceedings.
No, I understand where you're coming from, so I'm not disputing that. And then just finally, you took on notice on Monday. We were talking about the Bowen and Galilee Strategic Basin Plan, and there was a $10 million grant that was proposed for examining the pipeline between Tennant Creek and Mount Isa. And Queensland are putting in $5 million, the Commonwealth's putting in $5 million. You were going to endeavour to find out who that grant was going to or has gone to.
Thanks, Senator. So, look, we're still continuing work with the Queensland Government in relation to the $10 million pre-feasibility study. We haven't expended any money as part of our the federal government's
committed?
$5 million. Sorry?
Or committed?
We've committed, but we haven't expended any of the $5 million as part of the pre-feasibility study. Now, there are a number of routes, and not just the route that you mentioned. There are about 4 or 5 different routes that both the Queensland Government and the federal government are looking at. Okay. And there's been a body of work that's already been completed by the Queensland Government, and the $10 million pre-feasibility study will build on that work that's already been done.
So that I presume is in the public domain in Queensland, through the Queensland Government, the different options?
The work that's been commissioned by the Queensland Government, I don't think is in the public domain. It'd be something that the Queensland Government would need to decide whether they would want to release or not at any particular stage.
So my question about committed versus expended has a contract been signed?
Not at this point in time, Senator.
So that's a commitment to the $10 million, $5 million each.
I understand. It was an accounting commitment.
And we're working with Queensland to actually then determine what's the best use of that public money with respect. And it's likely that we will end up, once we've completed the work with Queensland, to go into tender processes with respect to a range of consultancies.
Sure. Okay, thank you. And just still in that strategic plan, there was further commitment. I think it's about $370 million to for infrastructure. Can you tell me a little bit about that? Is that Commonwealth funds? Who will be the likely beneficiary of that fund? Will it be the government itself? Will it be the gas pipeline company? Will it be someone else?
So I think, Senator, you're talking about the Beetaloo Strategic Basin Plan now, and it's the $173 million that was committed as part of infrastructure upgrades.
So there was none for. I thought there was in the Bowen and Galilee plan as well.
Oh, right. Okay. Sorry, Senator.
That's all right.
I've just been...
There's more chance of me being wrong than you, but...
No, I've just been advised that as part of the North Bowen Galilee Basin Plan announcement that the plan is building on an existing $370 million commitment in infrastructure upgrades.
Okay, so that existing commitment that's occurred, is that where Commonwealth money has been expended, has been committed?
I'd have to take that on notice. I'm not sure how much money's been expended at this point in time.
All right. Can you give me a little bit of on notice, perhaps just an outline of what money has been spent, what's likely to be spent, and on what and to whom, please?
Yeah, we'll do our very best.
And that's
Thank you.
specifically with respect to North Bowen Galilee?
Yes, please.
Okay.
And that's it. Thank you very much, Chair.
Thank you, Senator Patrick. Senator Walsh.
Thank you, Chair. A couple of questions for NOPTA in relation to PEP 11.
NOPTA. Yep.
I hope you can see and hear me.
Yes.
Well, we're still under...
Thank you very much.
NOPTA.
Would you mind just stating your name for us?
Yeah. Yes, good evening. My name is Graham Waters. I'm the National Offshore Petroleum Titles Administrator and General Manager of the NOPTA branch within the Resources Division.
Thank you very much, Mr. Waters. Chair, I just kind of stole your job for a minute and asked Mr. Waters to introduce himself, which he's done. Is that okay?
That's fine.
You're doing such a good job. In question time last week, last Thursday, the Minister for Resources and Water said in answer to a question on PEP 11, I'll be taking advice from the regulator, which is NOPTA. We'll make a decision in due course. Has the Minister received the advice that he needs from NOPTA to make a decision about this project?
Well, yes, Senator. We provided advice to the Joint Authority on an application lodged by the title holders. That advice was provided to the Joint Authority in April 2020.
Right. And is it your understanding that there's any further information that the Minister needs to make a decision on this matter beyond what you've told us that you've given in April?
As things stand right at the moment, I haven't received any request from either members of the Joint Authority for further advice.
Right. So you haven't been asked for advice, for example, on or after last Thursday, October 21, advice for the Minister to assist in his decision in relation to this project?
Yes, that's correct. I have not received any request for further advice.
Right. What was the joint authority that you just described to us in your answer there? Who are the members of that authority?
The joint authority, the responsible joint authority for that jurisdiction is the responsible Commonwealth Minister, the Minister for Resources, and also the relevant minister in New South Wales Government.
Okay, thank you. So, complete advice went to Minister Pitt back in April, along with his New South Wales counterpart.
Yes.
And he hasn't asked for any further advice since April, and certainly not since last week, to assist with a decision-making process in relation to PEP 11.
That's correct. I haven't received any further request from either members of the Joint Authority.
Can I just clarify, Mr Waters, did you say that was April 2020 or 21?
I said 2020. The current applications that the title holders have submitted, the first was made on the 29th of December 2019. We provided that application was for a variation, a suspension and extension of permit year 4. We provided our advice to the Joint Authority on the 29th of April 2020.
And as Senator Walsh has established, there's been no further request for advice since then?
No.
Thank you.
No, that's correct. I should, if I may add, Senator, just for clarity, on the 30th of January 2021, the title holders have lodged another application seeking a further suspension and extension for permit year 4, and we are currently assessing that application.
Right. And have you provided any advice to the Minister about that yet?
No.
And when do you anticipate providing that advice?
There is no set time. We will, in all likelihood, not provide that advice until we have a decision relating to the application of December 2019.
So what? So you need.
So we will await the decision for the first application before we provide advice on the second application.
Right. So okay. So when the Minister tells Parliament in question time that he'll be taking advice from you, he actually needs to make a decision about the matter that you've already provided advice on before you can give advice on the new application. Is that correct?
I'm not sure I fully understand the question you just asked, but the Minister or the Joint Authority Ministers may request further advice from us relating to that application that was lodged in 2019. They haven't done that, but they may well do that.
Yes. Or they may just make a decision based on the advice that you provided.
Indeed.
Yeah. And this second application that you said was made that you have not yet provided advice on, I thought the way you described it, you require or you need some sort of a decision to be made about the first one, the December 2019 one, before you can provide advice on this more recent one. Is that right?
Yeah, that's correct, because our advice would be contingent upon the decision currently before the Joint Authority.
Okay. And what is the advice that you provided the Joint Authority in relation to the December 2019 application?
Senator, with the greatest of respect, that advice that we provide to the Joint Authority Ministers is confidential.
Okay. Thank you. We had some other questions for the department as opposed to NOPTA. The Critical Minerals Facilitation Office. Obviously there's a lot of excitement about critical minerals in the country, lots of big opportunities, which is terrific.
They're critical.
Critical. Lots of big opportunities in Queensland.
Absolutely. Absolutely. The state of opportunity.
More mining jobs to supply minerals needed to achieve net zero emissions. Very exciting.
Many opportunities.
Some of those jobs that the regions will get.
Absolutely.
Yeah, I agree. Regions have got a lot to gain out of this.
Support the Northern Australia agenda.
Glad you've come to that realisation.
We'll be going to the north.
Had to be the right plan, though, Senator.
The one that's built on existing policies.
Well, better than your tax rubbish.
All right, Senator Watt, you have the call.
About a month ago, 28th of September, the Prime Minister, Minister for Trade and Minister for Resources put out a press release in which they announced a $2 billion loan facility for Australian critical minerals projects. There hasn't really been a lot of detail provided about how that's going to work yet. Are loans under this new facility expected to be repaid to the Commonwealth on commercial terms?
Good evening, Senators. Andrew Hutchinson, General Manager of the Critical Minerals Facilitation Office. Senators, detailed questions on that are probably best directed to the Trade and Investment branch of DFAT, but we could make some high-level comments that...
Yep. That's a pretty basic issue, so it's not a trick question. I just want to understand how it's going to work.
Of course, Senator, not trying to be obstructionist at all. In general terms, the facility is supposed to operate in the same terms as the Defence Export Facility, and so I believe that they are intended to be loaned on commercial terms or as close to as possible, but there is some flexibility for government, is my understanding, Senator.
Right.
I'm happy to come back on notice to clarify that if I've misspoken.
Okay, so it's not really intended to provide concessional loans in the same way that certain other Commonwealth loan facilities operate?
I think I'd probably best defer that to DFAT or Export Finance Australia to answer that, Senator.
You're the General Manager of the Critical Minerals Facilitation Office, is that correct?
Yes, Senator.
Okay, so is your office administering this loan facility? It becomes harder to speak when you enter your 60th hour of estimates for the week.
You're doing well, Senator, for this hour of night.
What?
It should get pretty loose by about 10:30.
A short and simple answer, Senator, no, we don't. That's administered by Export Finance Australia, although we work closely with them.
Why isn't it being administered? So it's a loan facility to support the critical minerals industry. A new critical minerals facilitation office has been established. Why wouldn't this loan facility be administered by your office?
Oh, thank you for your question, Senator. For a couple of reasons. First, I guess I'd just take a little step back and say the facilitation office is designed basically to sit at the centre of government and work across a range of agencies and a range of programs to make sure that all of our policy levers are aligned to support the sector. And so, it's not unusual for us to work with Defence, to work with Home Affairs, to work with Foreign Affairs, Austrade, the science agencies, and particularly the 3 government finance agencies to make sure that all of those levers are aligned to support the sector. In the specific example you've given, the critical minerals facility, as you can imagine, the process of considering and doing due diligence on a large loan, or potentially a large loan for a critical minerals project, is very complex and it requires very specialised skills, particularly around finance and investment banking. And so we're more of a policy generalist team that works closely with EFA to provide policy advice and coordination and support and works with the sector. But quite frankly, Senator, it would be a skill set that we don't have. Okay. And sorry, I know you likened it to the Defence Export Facility in terms of its structure. I didn't catch who is actually administering it. Sorry, the agency administering it is Export Finance Australia, and DFAT.
Within the trade, part of DFAT.
Yeah, correct, thank you.
Yep. So it's not anything to do with the fact that Minister Pitt doesn't believe in climate change that's prevented this loan facility being put within his department?
Senator, of course, I can't comment on any of that.
Is that anything to do with it, Minister?
Sorry, could you repeat the question?
I was just reminding you that Minister Pitt doesn't believe in climate change, and I wondered whether that was anything to do with why he's not the responsible minister for this critical minerals loan facility.
I'll have to take that on notice, Senator.
Whether he believes in climate change
I'll
or if
take
that's
it
the
on
reason.
notice. I'll take it on notice.
What exactly are you taking on notice?
I'm taking your question on notice.
And what was that?
Senator,
I'm not providing you your election clips.
Senator Watt, you have the call.
What was the
You'll have to review the Hansard to work out what the question was. And it's not because the resources portfolio was out of cabinet at the time this announcement was made that it hasn't been given the opportunity to administer this program, this loan facility?
Senator, I would note that Export Finance Australia administers the Defence Export Facility as well, as it administers all facilities under the National Interest Account. As I've said, this new facility is modelled off that, and so all of the governance arrangements are the same. And as I said as well, Export Finance Australia has that expertise in financing and project due diligence.
Are they still on downstairs?
I know DFAT is. I don't know what part of DFAT is, but we could
Okay.
potentially
Well,
put
maybe
it
some
asked down there.
questions on notice might get you the answers you're looking for. Senator.
Thanks for your assistance, Minister. So, of course, as I said earlier, Minister Pitt has had an exceptionally good week for himself. He's been promoted back into cabinet, got his $31,000 pay rise. Apparently, he now believes in net zero emissions. Now that all that's happened, do you think he'll get Minister the opportunity to oversee this $2 billion loan facility concerning critical minerals?
Oh, I think Mr Hutchinson's made it very, very clear who is the lead within the public service on this particular facility. I haven't heard of anything changing in that regard, but I can take it on notice if that would assist you.
I mean, what's Mr Pitt got to do to get to administer this loan facility about critical minerals? He's back in cabinet, he's got a pay rise, he's had a road to Damascus conversion about net zero. Surely...
For contempt, so...
Oh, I didn't know that.
Senator Patrick.
What's he got to do to get to administer this?
Well, it's currently being administered. Its administration has been set up by the government, and it's as Mr Hutchinson has made clear to you.
Did the Critical Minerals Facilitation Office help to draft the guidelines or assess applications for this loan facility?
Senator, we provided policy input into the process of developing this policy initiative. In addition, I would say the genesis of this idea was a very whole-of-government one, in the sense that we, alongside Austrade, DFAT, Export Finance Australia, the Clean Energy Finance Corporation and the Northern Australia Infrastructure Facility work very closely to understand the sector, to engage with project proponents and work out what the barriers are and what, if anything, government can do to support that. And so it was through that in detailed sort of industry engagement and consultation that the idea for this was worked up. On any critical minerals proposals across government, the CMFO, my office is consulted as we're the policy lead on that.
Okay. Have any applications been received yet?
Under the particular critical minerals facility?
Yep.
Senator, I'd say two things to that. One, the facility is very new. Second, the process of considering that is something best answered by Export Finance Australia.
Yep.
And just, sorry, I know I'm not trying to overwhelm with minutiae here, but the way Export Finance Australia works with project proponents is there is often
I was going to say be free.
Oh,
feel free,
Mr.
Hutchinson.
There's a long lead of engagement with them. Often there's informal engagement. Export Finance Australia can spend months, if not years, really understanding the project's financials and commercial basis, while particularly critical minerals projects take a number of years to scale up from initiation. So I think it would be premature to have expected proposals at this point.
Mm-hmm. Do you expect that your office will be consulted about the applications and involved in the assessment process?
Senator, as I've said, the Critical Minerals Office works across government and we're consulted on critical minerals policy.
But not necessarily for applications for funding under this facility?
Senator, it would be strange, I would think, if we were not, but I couldn't entirely rule it out.
Has that process not really been settled yet?
Senator, as I said, the process for that is one that's administered by EFA. It will be the same process as under the Defence Export Facility. There's probably a level of splitting hairs here in terms of what is required to be consulted versus will be consulted in the ordinary course of business. So there's probably not a lot more clarity I can provide you on.
It would be surprising though, wouldn't it? If you're the policy experts within government about critical minerals, it would be pretty surprising if you're not involved in the process of determining who gets loans to develop the critical minerals industry.
Senator, we certainly don't decide who gets loans in the critical minerals sector. That's a decision of government. However, we provide policy advice on those considerations.
Sure, sorry. If you weren't involved in providing recommendations to ministers about that, that would be pretty surprising.
I'm not sure.
Are you asking the official for an opinion, Senator?
Again, it's not a trick question.
Were you asking him if something's surprising or not?
Well,
just maybe
surely,
ask it a different way.
Surely this government wouldn't be so cavalier with its spending of public funds that it would not consult the policy experts in government about critical minerals when it's making decisions about who to give loans to in the critical minerals sector.
I think you've heard from the officials that the Export Finance Australia has consulted them as the policy experts in
setting
this
up the
field.
program.
Yeah, absolutely.
But
which is
that's
appropriate.
not my question. My question's about when a company comes along and makes an application for funding for a loan, is this office going to be involved in making recommendations about that.
Sorry, Senator, I could probably, I don't really want to delve into hypotheticals, I think is maybe why I'm looking a little uncomfortable with it.
be
But,
asked to.
for example, with the Defence Export Facility, it's my understanding, and happy to clarify this if I've misled the committee inadvertently, that Defence provides policy advice on particular proposals as a matter of course. Another bit of context I can perhaps provide is that my office speaks to Export Finance Australia probably multiple times a week about different proposals that they are considering for support, whether that's under their commercial account, the national interest account, or now the critical minerals facility. And so while I couldn't say whether government would or would not consult us on a particular proposal, certainly that's why we've been established, is to provide whole of government policy advice on critical minerals.
Has anyone in government measured the anticipated return to the Commonwealth over the life of the critical minerals facility as a result of this $2 billion investment?
I'd probably defer that one to the Trade and Investment Branch of DFAT, Senator, as it's outside of my policy responsibility.
But,
to answer that one.
But I thought you did provide policy advice around the creation of this loan facility.
We did, Senator, but your question goes to specific, I guess, accounting treatment of loans and returns on potential loans under the facility.
Well, I suppose I'm more just wondering, I'm not asking about the operations of the scheme, which is appropriately more a question for DFAT. What I'm asking about is, in advising government around the creation of this loan facility, did your office, or are you aware of anyone in government commissioning or undertaking modelling to determine what the return on investment would be? That's at $2 billion, there's a lot of taxpayers' funds. How do we know there's going to be a positive return to the Commonwealth from that?
Thank you, Senator, for clarifying your question. I'd say a few comments on that. Firstly, I can confirm that my office did not provide any modelling around the returns on loans undertaken, because that would not be within our remit to do so. We don't have the expertise or the policy authority or responsibility to do that. The second comment that I would make is that, as I said, this is a facility modelled on an existing defence export facility under the national interest account. As such, it follows all of the same rules, governance structures and legislative constructs of the national interest account. And so the terms upon which loans are made under that, the potential returns in a general sense are understood within that context. And finally, I would suggest if that's something you're after, I can't really speak for all other agencies, and so we could perhaps take that on notice and consult with DFAT.
Yep, that'd be great.
Come back to you.
Last question I've got here. The government's critical minerals strategy was released in March 2019.
Thereabouts, Senator. I don't have the particular month, but it was in 2019.
And then in November 2019, the government announced a range of measures to back in that strategy. Your office was created in January 2020. Do we know how many new Australian jobs have been created in critical minerals since the release of this strategy back in March 2019?
I don't have a particular figure for that in front of me, Senator. I know of several projects that have been financed since that time, which the Critical Minerals Office was involved in helping secure finance, two in particular through government financing agencies. There have been a number of developments in the lithium space where we've provided project facilitation or policy facilitation or engagement services. Similarly, there have been a range of international investments and offtake agreements struck, of which various agencies across government have played a role, including my office. But I don't have a particular jobs figure in front of me. And Senator, much as I'd love to provide you with one, it might be quite difficult to disentangle the role of our office from those of other agencies or broader market movements.
Thanks.
Chair, is it all right if I ask just a couple of questions?
Absolutely, Senator Walsh.
Thank you very much.
Senator Patrick, do you have some questions?
Yes, I do.
Okay, so to you first, Senator Walsh.
Yes, thank you. So my questions are just an effort to get an update on where we're going at joining the Extractive Industries Transparency Initiative.
Thanks, Senator. Paul Trotman, Head of Resources Division. I think we talked through this particular initiative a couple of estimates back.
I do have a recollection, so I wonder if there's an update.
We're still working across government in terms of other strategies that are in place, including the Tax Transparency Code, which is administered through Treasury. So there's a number of bits of work that are going on in the transparency space. In terms of the multi-stakeholder group and actually holding meetings of the ETI, we haven't held any meetings over the course of the last 18 months, and we are still investigating avenues where we can introduce similar arrangements that would comply with the 2016 ETI commitments through other mechanisms across government, like I said, through the Tax Transparency Code.
Thank you. I'm just trying to remember what it takes to join. Is this a very difficult club to get into? This this transparency initiative. What are the things that we have to do to get in?
So, thanks, Senator. The Australian government has supported ETI over the last 20 years in terms of providing support to less developed economies, improve their transparency arrangements within their resources sector. There are requirements that need to be met in terms of the commitments that are made through the ETI board in Europe, and as part of that, the government committed back in 2016 to join ETI under the arrangements as they were at that time, and roughly around the same time as when the government made the commitment, there are a number of changes to the roles and responsibilities of ETI member countries. And as I mentioned to you in previous estimates hearings, there are issues around beneficial reporting. There are also issues in terms of around environmental reporting that weren't included in the 2016 ETI commitment that the government had originally committed to.
So so this is a sort of a global standard that is about transparency, being open, being accountable, having standards of the kind that you just mentioned. So for your nation's extractive industries. So is the issue that Australia is not sufficiently open and accountable at this point?
No, not at all, Senator. I think it's more that Australia is very open in terms of its major companies, in terms of the transparency arrangements that they have in place, especially around tax that is paid, in terms of shareholder interests. I think the bigger issue in terms of joining the latest commitments around ETI, as I said previously, involve some of the commitments around environment and also other commitments related to social issues that weren't originally intended in the original standard.
So did you say that the group, the ETI group that is trying to progress our ascension to this initiative has not met for 18 months, or that the group that we're trying to join hasn't met for 18 months?
So as part of joining ETI, member countries are required to hold a multi-stakeholder group which have representatives from government, business and civil society. And so as part of our commitments to the 2016 ETI standard and requirements, we assembled a multi-stakeholder group. We had been holding regular meetings of the MSG, but as I said, I don't have the information in front of me, but I don't think the MSG has met over the last 18-month period.
And who's on that group? So is that's companies in extractive industries, is it?
I might ask Mr. Sullivan if you've got that in front of you there.
Looking for the membership list. I don't have it in front of me.
I don't have it in front of me, sorry, Senator. I might have to take that on
They haven't met
notice.
for 18 months, but they still sort of exist as a group with people on the group.
So the member companies are still the same member companies
Yeah.
that were around 18 months, 2 years ago. That hasn't changed. And then similarly, there has been no change, obviously, with state and territory government members and the members of civil society. I think there has been some changes, but essentially Transparency International is one of the civil society members. Publish What You Pay used to be a member of civil society that sat on the MSG. I don't have the list of members in front of me, sorry.
So, Senator,
For some reason, I'm getting a better understanding of it this time than previous times. Yep.
just to add to that, I think the last sort of interaction with multi-stakeholder group was in April this year, when Mr Pitt wrote saying that that it'd be premature for the group to reconvene to consider next steps for Eddie until the government responds to the review of the Tax Transparency Code by the Board of Taxation.
Okay.
And so that, as my understanding, that the government has yet to respond to that. That's obviously not in it's a matter for taxation. For Treasury. But that issue that you also alluded to, that in terms of is this a global measure? I think Mr Trotman, as he pointed out, we've supported countries in actually participating in that, but similar sort of like-minded resource complex countries like Canada and the US are not implementing ETI specifically, and so it's not as though we're out completely isolated on this. What we're trying to do is work through what's the most effective way to increase transparency, and that sequence of events as well has worked against us, to be really honest. So in 2016, when there was a commitment to take the next step with respect to ETI, that was based on a 2013 set of commitments.
Yes.
Then they were updated and that made a different set of
include
challenges. We've been looking at that through the multi-stakeholder group, and then in 2019, Eddie redid it again, and so we've had to basically go back to the start at the same time when there's been parallel processes happening with respect to taxation treatment.
So the last thing that sort of happened of note is that the minister wrote to the group in April and said in April 2021 and said there's no point meeting until the Tax Transparency Code is resolved.
Yep.
And then it would be a process of this group trying to sort of engage with the social and environmental standards that are now part of joining this initiative and trying to get a position about meeting those standards?
Well, that'll be really a decision for the Minister and for Government. So once the Government responds to the Board of Taxation's review on the Tax Transparency Code, I think that will provide the next sort of decision point as to what's the next steps with respect to ETI. So I don't want to prejudge what that hypothetical, in terms of what the next steps are once that consideration is put in place.
Is there any kind of time frame whereby which this membership might be resolved that DISA is sort of attempting to work towards?
Well, as I said, Senator, we've been sort of playing catch up every time with respect to the 2013, 16, 19. We're now waiting for the government response with respect to the Board of Taxation review, and I think in terms of timeframes post that, we'll then advise the government in terms of what's potential next steps once that government response is in place.
So, and it's been 5 years, and your evidence is that the goalposts have been shifted in that time, I guess.
Yeah, and it's not as though we haven't been doing anything. I mean, we've done a KPMG gap analysis from memory back in 2018 on the 2016 standard, and then sort of when we were considering that, and this predates my time in this role, Senator, but when
Yeah.
we were considering that, we then had an update to the 2019 standard. So,
Is it? Sorry, I didn't mean to
No,
go
no,
in there. But
it's
is
fine.
it the type of thing that you sort of imagine might be resolved in a year or in another 5 years, or there's no sort of horizon for it?
look, I think the next, as I said, the next sort of critical point in implementation is once the government's position is handed down in terms of response to the Board of Taxation review on the Tax Transparency Code.
And so just finally, and I think I did ask this question in a previous round, but is it someone's job to progress this, and whose job is it? I don't mean at the senior level. I mean, is there someone who works on this? Is there an allocation of staff to this, or does it just sort of float a bit, or?
Yeah, so I have a team, Senator, who work on social licence issues, and I also have a team that works on tax issues, and so they have been progressing this particular initiative. Probably what I wouldn't mind just putting on the record, and I alluded to this earlier, that the Australian government has committed quite substantially to EDI over the last 20 years, and from 2011 to 2023, the government has committed $5 million to EDI, including a current commitment of $1.2 million over 2020 through to 2023, and in addition to that, Australia has committed a further $27 million from 2015 to 2024 for extractive governance through global and bilateral investments in Australia's development programs. So there are a number of things the government has done in this space, as I said, over the last 20 years, and also moving forward. It's just a matter of just getting the appropriate settings in place, and then the government making a decision as to whether it wants to move forward with the EDI program, or look at some other tax transparency measure that's applied locally and domestically.
Yeah, I mean, would we meet the standards that are required today? I mean, you mentioned environmental, social and tax transparency
I think
standards.
so, Senator, yeah, that's correct.
Right. We would meet the standards of membership, but we just don't sort of finalise that.
Look, there are some elements of the membership where there's the potential for, as Mr. Sullivan said, for the goalposts to change, and I think that's the apprehensive or the apprehension on the part of government in terms of joining up.
All right, that we might meet the standards as they are today, but that more stringent social, environmental or tax transparency measures might subsequently be added that we would have to comply with, and we have a concern about that.
I think the greater concern is the lack of control over what those measures might be, and as Mr. Sullivan said, in 2013 we were ready to go, but then the rules changed. In 2016 we were ready to go, but then the goalposts changed again. So it's very unpredictable in terms of where the EDI standard will go, and so as a consequence of that, the government is more inclined to apply a domestic tax transparency measure instead.
Right, okay. All right, thank you very much.
Thank you.
Thank you, Senator Walsh. I just had some follow-up questions just in relation to the important issues Senator Walsh just raised then. And is it fair to say, Mr. Trotman, that or Mr. Sullivan, that the genesis of EDI was really focused on developing countries and the lack of transparency in the environment where you didn't have civil society developed to the extent that we have here. You didn't have Senator Patrick using FOI Act processes. You didn't have committees such as this. You had issues with bribery and corruption, and minerals and oil and gas were being exploited, and the people on the ground weren't receiving the benefit of those minerals and that oil and gas, and there was a lack of transparency as to who was getting the benefit, and it certainly wasn't the people. So in many respects, the ETI initiative with respect to member countries that have joined has helped lift transparency, especially in relation to those developing countries like the Congo and other places such as that. Is that a fair comment?
Yeah, I think so, Senator. And in terms of just applying the EDI standard in itself, there's a number of different sort of activities that the EDI board and EDI member countries contribute to. And as part of that, Australia, yeah, obviously you mentioned the Congo, but Australia has considerable mining interests in Africa, Latin America and our region, including Indonesia and Papua New Guinea. The support we provide EDI assists developing countries in these regions to develop and strengthen their governance arrangements around their extractive industry. So we're very much supportive of that, and we have been, as I said, over the last 20 years.
And is it fair comment to say that some listed Australian companies, certainly in the mining and oil and gas space, have been at the forefront of lifting standards with respect to sustainability reporting, including with respect to the Global Reporting Initiative, and reporting on all those matters which are of great concern to the general community, which are necessary in order for a company to maintain its social licence, including environmental standards, occupational health and safety, etc. Is that a fair comment?
No, very much so. There are many Australian companies, including BHP and Rio, BP Australia, Newcrest Mining, Woodside. They're all very much involved in those initiatives and moving forward. So with or without EDI, companies are already complying with government's requirements that are generally expected.
Yeah, it's a really good point, because for almost 20 years, Australia's been recognised, particularly in mining companies, as being the forefront of sustainability reporting. And again, I think Rio Tinto was one of the early adopters of significant investment in sustainability reporting, and I think they have become the benchmark for international companies worldwide.
Absolutely. Senator Patrick, do you have some questions?
Yes, I do. I will say, Chair, there's a bit of an irony in Labor pressing for transparency when Senator Watt stood up in the chamber and stated that he wasn't going to support my amendment in relation to transparency on production data, and suggesting safety was one of the reasons. But,
so, Senator Patrick, your questions need to be
no,
directed to your left rather than directly in front of
Senator McKenzie.
He's just worried that he did something that was anti-government and now he's got to do something that's anti-Labor.
I've got to keep an eye on both of you, both parties.
He's got to pretend to be independent.
At the moment, your job's to ask some questions, Senator Patrick. Your job's not to keep eyes on anyone; it's to ask questions.
It's a lead into questions I was going to ask.
All right,
it's a lead.
It's a lead into the questions you're now going to ask. Okay. Senator Patrick, you have the call.
Thank you. Mr. Waters, I'm hoping you're still there.
Ooh.
Yes, I am, Senator.
Good, thank you. So you just heard what we were talking about there, which was monthly production reports. Now, just so that everyone's clear about what sort of data comes from monthly production reports, we're talking about things like well identification, name and number, the summary of the work that's been done on a well, the results of production tests for the well's operational status, goes on total quantities for the following for the month in terms of liquid and gaseous petroleum produced, a whole range of information that comes out on a monthly basis. And I've now got a copy of the ACIL report, and I thank the department for providing me with that. It somehow only arrived late today, but I think it was a muck-up somewhere. But it's clear that this information is not sensitive, is not considered sensitive. So the regulations suggest that it is, or basically places a requirement on the government to keep this data confidential. But, Mr. Waters, notwithstanding what the law is, it's fair to say that much of the production reporting data should be made public. Would you agree with that, based on your read of the ACIL report?
Well, Senator, you're asking for my opinion.
No. You're an expert in this field, and you have read the reports. I'm now asking for your professional opinion, okay, in relation to the report. It's not in relation to government policy, but the Senate is relying on your expert knowledge here to help interpret the data that's in this report.
Senator, the first point, I have not read the ACIL Allen report.
You haven't?
No, the report was not commissioned for or by me. It was done by the department.
All right, well, it should be on the committee's website very soon, but in response to the last estimates. But it's pretty clear that we're keeping information away from the public that is generally available. In South Australia, I presume you're aware that they publish production reports. There's a latency to it, but they publish production reports. Are you aware of that?
Sorry, there are a number of jurisdictions that do publish reports. I wasn't specifically aware of South Australia, but I certainly am happy to take your word for it.
Okay, it just feeds into this whole thing where we've got this information which is being held secret on the basis it's confidential, and the department can weigh in here if they want to, but because that data goes to you, doesn't it?
From the list you just read, I'm not entirely sure that all of it does go to NOPTA. Certainly we do collect production data from companies, and yes, it is held confidentially. Yeah, okay, I think that has answered your question.
Yeah, sure. So, I mean, I'm just making sure I'm directing it at the right person. I don't know if where's the department at with implementing the recommendations of the ACIL report? Ms. Ullman.
Senator Patrick, good evening. Mari Ullman, General Manager of the Offshore Resources Branch. As you'd be aware, and I referred to this at the last appearance at the hearing, we are preparing a policy paper on the review of the regulations, the resource management and administration regulations. The ACIL Allen report is an input to that process. I'm hoping to have a policy paper available for public consultation by the end of this year.
All right, well, I'm hoping Senator Watt is listening to this and will read the report so that next time I move an amendment, you'll support it.
Response. If I can just set us up for the next hour and a quarter, and I just want to give you a bit of a steer if I can. For NOPSEMA, Senator Watt has 5 minutes of questions. I assume you might have some questions as well. Okay, so we'll be looking to break at 10:05 for 10 minutes, which will give us 45 minutes for the last session.
And I have Northern Endeavour Task Force as well, so
okay, so we need to try and get that completed. I think you've got until 10:05 if you could try and cover all those topics and then including NOPSEMA.
By 10:05.
And then Senator Watt will have 5 minutes with NOPSEMA.
And what happens after 10:05?
We have a 10-minute break to 10:15, and then we've got a 45-minute dash to the finish line.
Covering what?
Northern Australia.
Northern Australia. So we've got quite a bit to cover in that 45 minutes. I just want to give you early notice so you could.
Thank you. Senator Chair, just to be clear, the Northern Endeavour Task Force is in the Department of Industry. So.
They always appear here.
Yeah, that's us. So what I'm saying is that the session you're planning for after 10:15.
No. We're proposing to deal with Northern Endeavour, NOPSEMA, and also whatever questions are left here.
Yeah, so we need
Senator Patrick.
Northern Endeavour needs to happen before NOPSEMA.
Right, and so Senator Patrick has till 10:05 to complete his questions in relation to all those areas.
Thank you.
Thank you, Secretary.
Okay, thank you.
Over to you, Senator Patrick.
Okay, thank you. So back to NOPTA. There was an answer provided to the Oil and Gas Reserve inquiry about enhanced oil recovery. And one of the questions was, are there any occurrences in Australia of this being used? Now, you set out what enhanced oil recovery was, but you didn't really answer that third part of the question, which was, are there any occurrences in Australia? Now, that's caused me to go off and do my own research. There's a CO2 CRC that was established in 2003 to investigate and support carbon capture and storage. Are you aware of that CRC? It's now changed. Now it runs off government grants. It's no longer a CRC.
No, I'm not specifically aware of it. I'm aware of a number of carbon capture and storage initiatives.
Okay, so in some sense, and I'm sorry if I get frustrated again, but
no,
this is well, it's not directly you, Mr. Waters. It's that general problem we've got of no one having stewardship over getting value for money, because in effect you assess the tenements, don't you? You assess them for commercial viability, you know, when you're looking at things like retention leases and so forth.
Certainly it is part of the assessment in a retention lease, yes.
So this enhanced oil recovery is part of understanding what the capacity of the reserve is, yet you're not using it. And yet the government spent millions of dollars over 10 years to become expert in understanding some of these technologies. There's a huge disconnect here.
I'm sorry, Senator, obviously I've misinterpreted one of your questions. When we assess field development, retention lease, concepts that companies are proposing, we will take into account that kind of information should it be provided as part of our technical assessment.
Sure, but if a company just gives you the standard operational mode that they are already operating under, without this enhanced oil recovery overlaid, you're going to be misguided in what the value of the tenement is, what its production capacity and lifetime could actually be. And the company might not be interested in getting to the harder stuff.
Companies may not be interested in getting to the harder stuff.
Well, you make money when the process is easy. You might have to invest to do this enhanced oil recovery. It's not about the companies. This is about Australia's resources and making sure we exploit them to the maximum possible extent. And Mr. Trotman, I think, is going to help out.
No, look, if I can assist, Senator, I think in terms of your questioning around enhanced oil recovery, it's more in the onshore space that the CO2 CRC have been doing that work, and they obviously have their testbed facility, which is in the Otway basin, and they've also been doing some work in the Gippsland basin. So when we're talking about enhanced oil recovery, we're talking more about opportunities more in the onshore rather than the offshore.
Well, okay, so the question is, why aren't you talking about offshore? Because this committee heard in its references inquiry that in actual fact it's just as valid for offshore as it is for onshore.
Well, I think obviously there is potential there, but there comes at a cost, and so
it does. But you don't even know what it is. You don't even know what the potential is because you haven't gone down that path. I'm not saying you invest in going down that path, but you should at least have an understanding of it. And it's a huge problem. It's, I'm sure where the reference committee may end up. I think one of the really clear things it's going to say is no one's in charge of the stewardship of making sure the taxpayer gets the best return for their resources. That's my concern here. There's a technology that Mr. Waters hasn't been utilising. You're telling me it's not. It's on for onshore. That's fine because that's the states. For the Commonwealth, the very thing you're responsible for, the committee's heard evidence that it's useful.
Yeah, and it is something that's often used in the context of carbon capture and storage, and so a lot of the tenements in play in the onshore, companies make decisions as to whether there is potential for enhanced oil recovery or injection of CO2 through sequestration, in terms of carbon capture and storage. But it obviously comes down to a cost, and so it depends whether companies wish to pursue that.
So, Mr. Trotman, there's a tension. I think, and I'm just thinking my own experience in the copper gold mining industry, right? You talk about a company high grading an ore body and picking the eyes out of the easiest elements of the ore body. It's the cheapest, but it means you're not exploiting the entire ore body and maximising the value over the long term from the entire ore body. So I think Senator Patrick's referring to this tension between short-term commercial gain, benefit, as opposed to valuing the entire resource, the entire ore body, getting the maximum value for the ultimate owners, the Australian people. Is that, have I summarised it?
That's very good, Chair. Thank you. That's why you're the Chair, I guess.
Well,
that's right, Chair. But Senator, also, I guess, what also comes into play is the quality of the geology as well. And so, again, some of the geology is applicable in terms of carbon capture and storage, and in other instances, companies can utilise enhanced oil recovery. It doesn't work in every piece of geology.
Maybe it doesn't, but on your own evidence, you don't know. And that's the problem, is that I'm sitting here listening to you saying that won't suit the companies. We're here for the Australian public, and we want to make sure that we get that entire ore body and maximise it. And we can set conditions going in about making sure that occurs. I'm sorry, I'm being passionate again, but I do care about this. This is our resource, and the companies are dictating. There's a hole here in what it is the government is doing, and that's problematic.
But again, as I said earlier, Senator, it comes back to the natural geology of the particular tenement.
I agree with you, but again, you don't know. You've not explored that.
So Mr. Trotman, just to tease this out a bit, I'm just trying to assist you.
Thank you.
Patrick,
thank you.
So in some jurisdictions, when tenements are put up to be bid upon by potential companies, potential explorers or producers, they'll need to lodge a mining plan or an operating plan and explain how they're going to exploit the ore body or the reserve to the maximum extent possible, and then the decision maker in determining whether or not to grant a tenement to company A, B or C will consider the different mining plans which have been lodged and make a decision as to who is best maximising the value of that resource for the ultimate owners. That's so I guess the question is whether or not we have processes or procedures in terms of our current operation of NOPTA, which approximates to that sort of process in terms of considering those sorts of issues.
That's right, Chair, but as you said previously, it comes down to that competitive tension as well as to whether there's value for money in pursuing that particular activity in the first instance. So companies are very attuned to this, and they will act in their self-interest in terms of making sure that they get the best value out of the assets that they have. So if there is potential to employ enhanced oil recovery,
but you need to be doing that. You need to be doing that. It's not about the company, it's about the Australian public getting the maximum from the resource. That means you understand what's possible, and that way, as Senator Scarr is saying, when the plan gets put forward, you're in a position to be able to say, you know what, you're not exploiting the whole of this asset, and you need to go and rethink that, because we're about getting the maximum return on our resources, not maximising your profits, and you need to come to some arrangement that gets you to the place where the Australian public are served well.
So, Senator Patrick, I know I'll be serving on that references committee with you
Sure.
now. So I look forward to doing that. And
We've got another hearing coming.
You've got 10 minutes
Sure, okay.
left. Could you move on to
let's go to
Northern Endeavour?
Northern
Is that-
Endeavour Task Force, please.
Thank you.
We're into the last 10 minutes before break.
No. So Senator Patrick's got, I think, 8 minutes for. I'm sorry to put you under time pressure for Northern Endeavour, and then NOPSEMA, and then you'll have 5 minutes for NOPSEMA.
Okay.
Then we have a 10-minute break, and come back at 10:15 to give us 45 minutes.
No problem.
Senator Patrick, you've
Okay,
got
so
the call.
thank you. What is the current status of the legal dispute between, in relation to the Northern Endeavour, between the Commonwealth and their funding, their secured creditor?
The litigation's ongoing, Senator.
I thought there was a report that you'd gone to mediation, court-directed mediation.
So,
Has that
Minister,
occurred?
we can't go into the details of the process. Obviously, the Commonwealth would act to...
Again, I'm not going to this. I'm just going. Where are you at in the process? Have you
Okay.
been ordered to go into mediation?
So, in terms of where we are in the process, Senator, if I can just go to the detail here. So we're currently in the discovery phase, and we're preparing to provide a final tranche of discovery on the 13th of December.
Yep.
The matter's not currently listed for trial. The next direction hearing is scheduled for the 1st of November.
So, I just want to go back to that. So you're doing discovery. Does that mean you've gone into mediation and come out of that?
So, Senator, if we were to go into mediation, we would. I've been advised
Sure.
not to disclose any of that information. We've taken advice on that.
Now, just as a question of fact, have you? Did the court order you to go into mediation at any point?
Can I just take a bit of advice before I
Sure.
answer that one?
Both parties would know this. Both, and the court would know this. It would be public, I would have thought.
So, Senator, the court has ordered us to mediate,
Okay.
and we are currently mediating with CCMA.
Okay, so you haven't come out of that process. That's all I wanted to know at this point in time. So when you say the discovery, is that part of the mediation or part of the...
As a normal process, if the mediation isn't successful, then we fall back to the litigation.
Ms Bergman seems to be itching to give me a legal answer, I think.
If I could just slightly alter that answer, the court hasn't directed mediation.
Okay.
However, we are progressing in parallel settlement discussions.
Okay, so there's two processes going on.
Yes, dual track.
Okay, thank you. That's all I wanted to know. What's the legal cost to date for the Commonwealth?
To date, we have expensed about 2.6 million.
And you're being represented by the AGS?
No, we're being represented by Clayton Woods.
Clayton Woods. That's a panel. That was a panel thing, was it?
Yes.
Okay. Just in, what are the total cost to date of the task force itself now? So just moving away from the proceedings. Thank you, Ms Bergman.
Ms. Bergman.
Oh, you had that too. Thank you.
Yes.
Maybe we introduce ourselves.
Yes, that's probably a good idea.
Sure. Victoria Bergman, General Manager of the Northern Endeavour Task Force.
Okay.
And I'm Shane Gaddis, I'm the head of the Liquid Fuels and Northern Endeavour Division.
Thank you. So, total cost of the program to date since the Commonwealth took responsibility. I don't know. You may not want to agree with that word, but you know what I'm saying.
Since we took possession of the FPSO.
Possession.
Yes. Our administrative expenditure to date is 148.572 million.
Okay, and what does that consist of? It consists of a certain amount of money going to UPS.
That is correct. So the majority of that expenditure has been the ongoing operation and maintenance and the preparatory work for disconnection that Upstream is conducting. That is the expenditure to date is 126.45 million. We have a further 14.678 million that has gone on insurances and important oil spill memberships. There has also been a further 7.619 million in relation to advice for those long-term options, so the Woodside scoping study and due diligence activities.
Okay, and Is the closing down of the operation contingent on the court proceedings concluding?
It's a factor. It's an interdependency, but no, the decommissioning activity will continue.
So you can continue down this pathway whilst the litigation's going, and you could even get to the point where the vessel is disconnected. I thought there was some part of the legal controversy was about disconnecting and what happened on the seafloor.
So Senator, perhaps if we could help you, there's been a bit of an update we can provide, Ms. Berg can provide you about how our expression of interest process has proceeded, which would give you some information about how we have approached those things in tandem with the litigation, so that you don't leave here with the opinion that we're just waiting for the litigation to cease.
And I understood there to be a parallel process going on. I'm just trying to understand how we get to the end here, and have you made a projection on how long that's going to take, and what that's ultimately going to cost the taxpayer?
So decommissioning is anticipated to occur over 3 phases. We're in the process of procuring a service provider for that first stage, which is about the decommissioning and disconnection of the facility. The second phase is about the plugging and abandoning of wells. We have not gone to market for that yet because we need to disconnect first. And then the third phase is about the remediation of the field, but also the removal of subsea infrastructure.
Can you please tell me Woodside's not going to profit from any of those phases? Noting they started the whole thing by effectively selling a stranded asset.
Senator Patrick, I think you've made your...
So Senator,
I'm not sure if you're expecting an answer to that.
The answer to that one is it's a global open tender process, and we are yet to get to the end of that process. So it wouldn't be appropriate for us to comment on who would or wouldn't be the successful.
Well, I'll just let you know I'm going to be loud if Woodside get it, because they got us into this mess. So
it's noted.
So Senator Patrick, is it possible you could put any more questions on Northern Endeavour on notice?
Can I just have a quick check to make sure
Sure.
Sure.
Yep.
Look, I'm happy to forego NOPSEMA.
Oh, are you?
Okay. So this is more important to me.
Okay.
Is that all right?
No, well, that's all right. I can give you just a few more minutes on
Okay.
this.
All right. Thank you. At the last hearing, Mr Fredericks, you advised that the department had received expert advice from Woodside and UPS, which had been peer reviewed. Were Woodside and UPS engaged by the Commonwealth to provide that advice?
I think I have to defer to my colleagues.
So who conducted the peer review?
Gaffney Klein,
Okay.
an expert resources firm who did an independent assurance of both the Woodside scoping study, which was regarding decommissioning activities, and also on the UPS commercial restart option.
Okay. Can you make that peer review report available to the committee? Happy for you to take that on notice.
We have to take that on notice, Senator, because that
Sure.
was something that was taken into Cabinet for the purposes of making the decision around which pathway the government would prefer to go. So we'll have to have a look at that before we come back to you.
Sure. Just so you understand, there's 2 criteria. One is that it's taken to Cabinet. The first criteria was that it was brought into existence for the dominant purpose of going to Cabinet. So you can't start down a particular pathway.
We want to be helpful, Senator. We'll take it on notice, and
Good on you.
we're very familiar with your views on this one.
Okay, thank you. Well, they're not my views. It's actually what the law is. So, and I've got a bit of experience on Cabinet matters. So, I think I might leave that there. I think I've got. Oh, hang on, just check. I think I might have one question for NOPSEMA, but so I'm happy to stop there.
Okay. Well, you can stay here. I'll give the court a sender watch for NOPSEMA. So if thank you very much, the Northern Endeavour team and Secretary. Thank you.
And Mr Waters.
And Mr Waters, thank you very much. And if I could ask NOPSEMA to come forward.
Thank you for your assistance.
Yes.
I know the
love each
point.
other. Yeah. No. Good. Well done. Well done, Mr. Sullivan.
Okay, so Nopsima, if I could just ask everyone to introduce themselves, please, if you could, and thank you for your patience.
You do well.
My name's Stuart Smith. I'm the
Oh,
CEO
actually,
of
can I? Sorry, we'll just check the audio. Okay, start again, please.
Sure, my name's Stuart Smith. I'm the CEO of Nopsima.
Thank you.
I'm Derek O'Keefe, the Head of Division for Safety and Well Integrity.
Thank you.
And Cameron Grebe, Head of Division for Environment and Decommissioning.
Thank you. Thank you for your patience. Senator Watt has the call.
Thank you all. Unfortunately, we have limited time, so I'll put most of my questions on notice. But I did want to deal with something that's become a big issue around the resources sector, unfortunately, in recent times, and that's the increasing reports of sexism, sexual harassment and sexual assault in mining camps. There's been a lot of coverage of that, particularly in Western Australia. There's a Western Australian Parliament committee inquiry underway into these issues. What I'd like to know is whether Nopsima has issued a guidance note or advice to regulated entities in relation to sexism, sexual harassment and sexual violence on regulated sites.
No, Senator, we have not.
You haven't felt it's enough of an issue to do that?
No, Senator, we're not getting the same issues reported to us that have occurred for the mines.
How many incidents of sexual harassment and sexual assault have been reported to Nopsima since the 1st of January this year?
Zero. In fact, Senator, I can think in the 5 years I've been here, I've never seen a single one.
Okay. Well, that's pleasing to hear. Is it? Are you taking any proactive steps to ensure that this sort of behaviour isn't occurring? I mean, obviously, one of the issues in particularly the offshore oil and gas sector is people are a long way away from home. Obviously, yeah.
Senator, so one of the things we do at every single offshore visit we do, we personally visit the health and safety representatives, independent of management. And the reason for that is to get the measure of how they're feeling. So with COVID, that's applied additional pressures. But if there were matters of harassment, bullying, sexual harassment, anything like that, that would be picked up. And our inspectors are actually very good at trying to detect these things. So again, no, we haven't seen anything out, but we do spend a lot of time with the HSRs. And we do have concerns about their overall well-being and mental health in every aspect.
Okay. Does Nopsima have the capacity in its current form to adequately regulate on matters regarding sexual safety on regulated sites?
Senator, we believe so. We already take action in regard to issues like bullying and harassment. We think the provisions are adequate should the need arise. But as indicated, we haven't been receiving complaints. And when we've been talking to HSRs, these issues have not been raised with our inspectors.
So you haven't received any complaints whatsoever about harassment of any kind on regulated sites?
Harassment, yes, but not in regard to sexual harassment.
Right. So more what people would term bullying?
Correct.
Yes.
Right.
Yes, and we've pursued those matters.
Right. And obviously sexual harassment can happen in a variety of ways, but none of those bullying matters involve males bullying women in a form that would amount to sexual harassment?
None that I can think of, Senator, no.
Okay. Maybe if you can take that on notice, just to have a check.
Happy to do so, Senator.
Thanks. I did have some questions on decommissioning costs for, is it the Laminaria Corallina oil fields? But unfortunately, that is the Northern Endeavour. Okay. I'll have to put them on notice due to lack of time, I'm afraid. I'll have to leave it at that.
They're on they actually answered it, so it's on the hand.
Yeah, okay, so it might be we might have covered them off there.
Yeah.
That's as much as
Okay,
I'll be able to
excellent. Thank you, Senator Watt.
I also try to help Labor from time to time.
do.
Okay,
So now you're
excellent.
swinging back our way.
Okay.
Thank you.
So reliable.
surprise.
So reliable.
Actually, I've got two
Yeah.
questions.
Two
Consistency
quick
is
questions
not his
from
middle name.
two quick questions from Senator Patrick, and then we'll have a 5-minute break. Perhaps Senator Watton have the last slot.
So I'm just going to all the. So we've seen the reports that you've provided to us. NOPSEMA, in relation to its concerns about Lloyd's register compliance, issued a report in regard to Northern Endeavour. Just wondering why you didn't do so for other platforms that had been certified by Lloyd's, such as BHP, Woodside, or Gladstone. Sorry. Why was the decision made not to issue reports in relation to their vessels?
Do you mean the Lloyd's report specifically?
Yes. So you issued a warrant against Lloyd's. You found a concern about Lloyd's. We've been through that in previous estimates. One of the
Yes.
actions that resulted from that investigation was that you then issued a report on the Northern Endeavour. So you went to examine Northern Endeavour. I'm wondering why you didn't do some of the other platforms, such as those owned by BHP, Woodside, or Jadestone.
Yes, Senator, so the Lloyd's review was the subject of a report covering 4 facilities. Those facilities were subsequently the subject of inspections where we followed up the issues arising from the Lloyd's report.
So your evidence is that the BHP, Woodside or Jadestone vessels were not covered off by Lloyd's, because you'd identified a systematic problem with Lloyd's, and one would have thought that you would have looked at all of the vessels where they'd given a certification.
That's right, Senator. Yes, we did.
So just to be clear, BHP, Woodside or Jadestone didn't have vessels that were certified by Lloyd's.
So they did have facilities certified by Lloyd's. There were 4 facilities certified, if I understand the ones you're referring to. Those 4 facilities and the certification by Lloyd's were the subject of a review that we undertook into Lloyd's, and the findings from that review were then followed up by us in subsequent inspections with those 4 facilities, which were owned by various parties, including the ones you've mentioned.
Okay, but you only released a report covering the Northern Endeavour, not Montara Venture, Bungara and Pyrenees Venture. Why didn't that occur?
So there's the inspection report for the Northern Endeavour, and there are inspection reports for the other facilities.
So there's 3 other reports.
Perhaps I'll just check with Mr. O'Keefe. Perhaps I'm not understanding your
So,
question
Mr. Smith,
correctly.
I think the question Senator Patrick is asking is the inspection report was released for Northern Endeavour, but it wasn't released with respect to the other 3. I'm not sure if you call them vessels or platforms. Is that correct?
Well, there were inspection reports, and we've provided those to the committee. So that's what I don't understand the question.
I can help here. Our records, Senator, reflect that we provided inspection for Tara Venture, Hura FSO and Pyrenees Venture FSO, which are respective Jadestone, Woodside and BH facilities. That those were transmitted to the committee.
I think you provided file notes to the committee, not reports.
The reports and file notes, Senator, on our record, but we can take on notice to confirm which documents and the document numbers, perhaps.
The second,
very quickly,
the
Senator
second
Patrick.
question is, because this has been raised, there were concerns about oil spills in relation to NOGA for the Northern Endeavour. Is it not the case that NOGA, that you'd assessed that NOGA had, in terms of the oil spill response, gone beyond the APPIA method?
Sorry, Senator, the question is, what are you referring to, Senator? Sorry, the issue of the prohibition notice in relation to...
No, just in terms of general ability to deal with an oil spill, because that has been raised. We're concerned about oil spills and so forth. So
no, Senator,
I understand that might have something to do with the state of the vessel. You're concerned about oil spills. Their plan and ability to deal with that oil spill, I understand, was assessed by you as being above or beyond the APPIA method, which is obviously the industry group's method.
No, Senator, the APPIA method you refer to may be the method for calculating financial assurance and demonstrating financial assurance compliance. The issue with NOGA's capability to respond to an oil spill stems from the fact that their environment plan, when they took on the facility from Woodside, relied on the resources of Woodside via a technical services agreement, and that there were no arrangements to replace any of the oil spill response services that were part of that technical services agreement. That was after Woodside transferred off the title. And so there were no arrangements in place to replace the services that were reflected in the environment plan, because Woodside was going to cease being technical service provider to NOGA.
All right, thank you.
Excellent. Thank you, Senator Patrick. So we will have a break until 10:25 p.m. Senator Watton, you'll have the call as soon as we come back at 10:25 p.m. in relation to the Department of Infrastructure, Transport, Regional Development, Territories and Portfolio Entities Program 3.1 Regional Development Northern Australia only. So thank you to those members of the department who now have the opportunity to leave. Thank you. We'll be back at 10:25.
Of Water Infrastructure and Office of Northern Australia. We do also have some people dialing in. We've got the NAIF and the Office of Northern Australia dialing in.
Okay.
So, good evening. Amanda Copping, the Acting Chief Executive Officer of the NAIF.
Thank you. Who else do we have with us by video conference, please?
Hi, it's Linda Lee, General Manager of the Office of Northern Australia in Darwin.
Thank you.
I'm Vicky Middleton, First Assistant Secretary, National Water Grid Authority and Office of Northern Australia.
Excellent. Thank you, Ms Middleton. So, Senator Watt, you have the call.
Thank you, Chair. I understand this is probably best put to Ms Copping, I suppose. You're the acting CEO?
Yes, that is correct, Senator.
When did you become the acting CEO?
Yesterday, Mr Wade resigned from the position of CEO of NAIF, and I was appointed as acting CEO.
What time yesterday did he resign?
I can't comment on what time he resigned. I'm not aware of that. I can say that an all-staff NAIF email from the chair was sent at 5 o'clock yesterday afternoon, Senator.
And why did Mr Wade resign?
Mr Wade's decision to resign is a matter for Mr Wade, Senator.
What did the email say?
I don't have a copy of it in front of me, Senator, but it announced that Mr Wade had decided to resign from NAIF effective 27th of October, and the board thanked Mr Wade for his contribution to NAIF and advised that I had been appointed as the acting executive.
You just cut out when it said, you said the date that it was effective?
Yes. Yes, effective. Sorry, Senator, effective the 27th of October 2021.
Being yesterday.
That's correct. Yes, Senator.
So
the email.
He resigned.
Sorry, Senator.
He announced his resignation and left immediately.
the board announced his resignation, and yes, he finished up yesterday.
So it was the board who sent the email to staff, not Mr. Wade?
That's correct, Senator.
Right. Did Mr. Wade address staff before he left?
No, he didn't, Senator.
So there was no communication directly from Mr. Wade to staff before he left the building?
He may have spoken to staff where he was located, but there was no NAIF-wide communication from Mr. Wade, Senator.
He was located in Brisbane, wasn't he?
Yesterday, he was in Brisbane for the day.
And I think your annual report says that there was only one employee in Brisbane, which I presume was Mr. Wade, so he probably wouldn't have been able to talk to anyone before he left.
Senator, we do have one employee in Brisbane, and it was not Mr. Wade. It was a member of the investment team.
Right. So there was no reason given, no reason has been provided to staff for why Mr. Wade resigned?
That is correct, Senator.
Had there been discussion amongst NAIF employees about the possibility of Mr. Wade resigning?
I'm not aware of any discussion.
So it came as a complete shock to you?
The first we're aware of it was the email from the Chair.
I mean, this is an extremely highly paid role. Mr. Wade had only been in the role since January last year. Does it not strike you as a little strange that staff get an email from the board saying the CEO has resigned and no reason is given and no one ever sees him again?
I think Mr. Wade's decision to resign is a matter for Mr. Wade.
Could you please table the email that was sent to staff by the board, please?
Sure. Yes.
Thank you. So that was signed by the chair of the NAIF on behalf of the board?
Yes, Senator, that it came from the Chair.
Right. It seems like a very strange coincidence that Mr. Wade resigned about 24 hours before he was due to appear at estimates. Is that just completely coincidental?
I'm not aware of the decision of Mr. Wade's reasons for his decision to resign, Senator.
Was Mr. Wade asked to resign by the board or by the chair?
Senator, I'm not aware of the reasons for his resignation.
Ms. Purvis-Smith, were you or any other member of the department, when did you become aware that Mr. Wade had resigned?
I think after I was informed that it had happened. I think the employment relationship is between Mr. Wade and the chair.
Yep.
So those discussions would have happened between Mr. Wade and the chair.
Sure, but the NAIF sits within this department. So you became aware, after the staff received the email?
I would have to check. I'm not quite sure when the staff received the email. I don't know when I received the information versus when the email was sent to staff.
So when did you receive it?
I haven't actually received. I didn't receive.
Or when did you hear about it?
I think after it had happened.
After it had happened.
I had heard that it had happened.
Right. Had you or anyone else in the department had any forewarning that Mr. Wade might be resigning?
I can take that on notice. As you mentioned, we have policy responsibility for NAIF issues, but the workings of the NAIF and the chair's relationship with the CEO of the NAIF is the responsibility of the chair and between the board and the NAIF and the CEO of the NAIF. So that's their employment relationship rather than ours.
Minister, when was the Minister informed of Mr. Wade's resignation?
I'll have to take that on notice.
You don't know?
No, I don't have that information.
when was the board chair informed of Mr Wade's resignation?
I'll have to take that on notice.
Is anyone else here able to assist with that answer, with an answer to that? When the board chair became aware or was informed?
I think we would have to take that on notice, Senator. As I mentioned, the relationship is between the chair and the CEO.
Did the minister, sorry, this is for you, Minister, did Minister Littleproud seek Mr Wade's resignation?
I'm not aware of that. It's a personal matter for the former CEO, his resignation.
So he's resigned for personal reasons?
Well, it's a matter for him.
Sure, but did the minister seek Mr Wade's resignation?
I don't think so. I'm not aware of that.
Could you take that on notice for us, please?
Sure.
So I suppose to be more specific, did the minister speak to the NAIF chair or the CEO about resigning prior to Mr Wade tendering his resignation?
I'll take that on notice.
Thanks. And equally, did the chair speak to Mr Wade about resigning prior to Mr Wade tendering his resignation?
I'll take that on notice.
And Minister, could you also take on notice why Mr Wade resigned?
I'll take that on notice.
So Mr Wade, Ms Copping, have you been briefed about Mr Wade's resignation, the circumstances relating to it, anything at all prior to appearing here?
No, Senator, I haven't. I received a phone call from the chair, advised me just before the email went out, advising me that Mr Wade had resigned and asking me to accept the position as acting Chief Executive Officer.
Was anything else said in that conversation apart from what you just told us?
No, Senator, other than to say, obviously, that we look forward to working with you and to continue to progress opportunities for the NAIF going forward.
Has anyone from the department or the NAIF board spoken to you before your appearance here today to talk to you about how you should answer questions about Mr Wade's resignation?
No, Senator.
Right.
From the board or from the department, no, Senator.
Thank you. Anyone else?
No, Senator.
Have you had any contact with Mr Wade since he tendered his resignation?
5 minutes after the all-staff email went out, I phoned Mr Wade to wish him the best, and he offered me congratulations on my appointment. Now, in that call, he did not communicate to me his reasons for his resignation.
Right. Did he give you any reason for why he had left the NAIF immediately?
No, Senator, he did not.
Could you and the Minister please take on notice whether Mr Wade was asked, whether by the board, chair or anyone else, to resign immediately? Yes. Please?
Yes, I'll take that on notice.
Yes, Senator.
And also whether Mr Wade offered to serve out a notice period of any kind?
Yep, I'll take that
I mean,
on notice.
it's a pretty unusual situation to have a CEO, a highly paid CEO of a government authority, have an email sent by the board to staff announcing his immediate resignation a day before he's due to appear at estimates and no reasons are given. That is a pretty unusual situation, which I think is why we're entitled to seek some answers about what's going on here.
Yeah, Senator, I've said I'll take it on notice.
Yeah. Ms Copping, how would you describe Mr Wade's relationship with other management and employees at the NAIF?
I'd say that NAIF has had a strong year and working, and as part of that relationship, we have made investment decisions, we've reached contractual close, and we've achieved $427.6 million of drawdown with Mr Wade working with the team at NAIF.
And, okay, with respect, that doesn't answer my question. How would you describe Mr Wade's relationship with management and staff at the NAIF?
Senator, I describe it as professional and productive.
At previous estimates, I've asked Mr Wade about allegations of bullying that have been made towards senior management at the NAIF. Are you aware of any such allegations against Mr Wade?
No, Senator, I'm not aware of any allegations.
Right. Are you aware of any other allegations of any other form of misconduct against Mr Wade?
No, Senator, I'm not aware of any other allegations.
Okay. So you're not aware... Could you take on notice for us whether there was any form of investigation into Mr Wade prior to his resignation?
Yes, Senator, I can take that on notice.
Thanks. And if there was, what the nature of that was and what the outcome of that was, please?
Yes. Yes, Senator.
So you're now the acting CEO. It's obviously very sudden. Has there been any discussion at all about the appointment of a replacement CEO, when that might happen, how that might happen?
Senator, I can talk about the communication that's been made to me, and then perhaps a response from the department might be more appropriate. But I've been advised will be commencing an international search for the future CEO.
Who's advised people of that?
The chair advised me that that's what would be happening.
Right.
But beyond that, it's a question for the board and the department.
Okay, so the chair's advised you that there will be an international search for a new CEO. Presumably that'll involve the engagement of a recruitment consultant?
I couldn't speculate on,
okay.
on hypothetical, Senator.
Okay. So what sort of turnover of staff has there been at the NAIF since Mr Wade's appointment in January last year?
Senator, I'd have to take that on notice in terms of number of departures. What I can say is that the staff numbers have gone up as at 30 September this year versus the same time last year. But I will take on notice your query around the number of departures.
And I'd also be interested to get a figure on recruitment costs that have been incurred by the NAIF since Mr Wade's appointment, by which I mean engagement of recruitment consultants, advertising processes, the whole lot when it comes to recruiting staff.
Understand.
Minister, I'm just thinking this is not the first time I've encountered a really sudden departure of a chief executive of an organisation under Minister Littleproud's oversight. I'm thinking of the really sudden departure and secret, in the sense of lack of communication, by Andrew Colvin when he was the head of the Bushfire Recovery Agency. Another, I think, well-respected person who departed just overnight with little communication. Is there some issue that Minister Littleproud has with CEOs of his organisations, that this has happened again?
Oh, Senator, I don't think you can make that assumption at all. As I said, the CEO's resignation is a matter for him. Got Amanda in place. The Our board has made it clear that with assistance from the department, they'll be conducting a global search for an appropriate replacement, which will then be obviously subject to the full cabinet process. So
Okay.
hopefully we'll get someone highly qualified for Northern Australia as soon as possible.
I mean, doesn't this show, Minister, this is just another example of turmoil within a deeply troubled organisation? I mean, we'll get to how little money the NAIF has released, and maybe people would like to start preparing some answers about that. It's had a CEO, it's had two CEOs in a very short amount of time. It's had one who's left barely 18 months after he started without any explanation, without any notice. What is going on in the NAIF, Minister?
Well, Senator, as you know, we've got departmental officials here. We've got Ms Copping here to answer your questions about what the NAIF's doing, how it's delivering, and how it's forward posturing. And I suggest you direct your questions to them because they have a much more intimate knowledge of the NAIF and what it's delivering than I do.
I'm also a little confused about who the current board membership of the NAIF is, because according to the annual report, it says that Ms Hayes is the chair, Mr. I think it's Margetic, I have met him and I've just forgotten how to pronounce his surname, and Ms George are members of the board, and Justin Manalini and Vicky Middleton are also members of the board according to the annual report, but Mr Manalini and Ms Middleton aren't listed on the website. So who are the current members of the board?
I'll throw to officials. Thank you, Senator.
I can take you through that, Senator. So the chair is Ms Tracy Hayes. We've got other members being Mr Stephen Margetic, I think that's how you pronounce it, Ms Kate George, and there's an ex officio departmental member, which is the secretary, and the secretary is able to nominate an alternate ex officio member, which is Ms Middleton.
Right. So Mr Manalini is no longer a member of the board?
No, my understanding is that Mr Manalini is no longer a member of the board. Just bear with me and I'll see if I can get you some information on that. My understanding is that Mr Manalini resigned from the board on the 29th of September.
And what was his reason for resigning?
I would have to double check that. There are a range of reasons for board members to resign,
Sure.
including clashes with other duties and board positions that they have. So it can take a range of issues into account.
I think I'm interested in Mr Manalini because I think he's been a member of the board for the entirety of the NAIF, so that's a pretty significant departure. He was the acting chair, I think, as well at one point. So, yeah, if you could take on notice why he resigned and whether he was asked to resign by the minister, please.
I can take that. I can
Thanks.
take that on notice.
Ms Middleton, did you have something you wanted to contribute there?
No, Ms Middleton, my colleague Ms Middleton might have some additional information on Mr Manalini's resignation.
Yeah. So Mr Manalini basically wrote and resigned on the basis that it was incompatible with his full-time workload now as a lawyer. And he was very pleased with the time that he had spent serving the NAIF and wished the board very well. And so there was no concerns about the timing. It was just quite simply his workload had increased with his full-time workload as a lawyer.
Minister, why is there currently no Queenslander on the NAIF board? Is Queensland not part of Northern Australia?
I'll have to take that on notice.
Don't you accept that North Queensland deserves representation on the NAIF board?
Well, Senator, as you know, I'm representing the Minister and the NAIF board has been, there's people being appointed and over time people choosing to do other things with their time, and I'm sure the Minister will consider all the regions of Northern Australia in any potential appointments that come forward. But that's not the only, I guess, reason for appointing someone to NAIF board. You also need a certain set of skills.
There's no skills in North Queensland?
No, I'm not saying that at all. I know, as you do, as Senator Scarr knows, as Senator McDonald, we talk about skill sets from Northern Australia. Hello.
An embarrassment of riches, Minister.
In that case,
I know.
An embarrassment
it is actually,
of riches.
Yes.
in that case, why is there not one North Queenslander on the NAIF board?
Well, I'll take that on notice.
Have any government members, such as government senators from Queensland, made representations to have Queenslanders appointed to the NAIF board?
I'm not aware, Senator. I can take that on notice.
If you could, please. And Minister, if you as well, on behalf of the Minister.
Of course.
How many vacancies are there currently on the NAIF board?
I think there are... The board can be up to 7.
Mm-hmm.
So there are vacancies on the board, and that is a government process.
There are
for
3
board
vacancies on the
appointments.
board then, or up to 3 vacancies?
Up to 3.
And how long have those positions been vacant?
Well, it depends on the positions itself. So there are 4 currently. There are 3 vacant, and the government is going through it. The board appointments are a matter for government going through those processes.
But some of those, I respect the fact you haven't been involved in the NAIF too long, but I know for a fact that a number of, maybe 1 or 2 of those positions have been vacant for several months now. There was quite a bit of turnover of board membership, I think, around the middle of the year. And so, again, why is it taking so long to find someone from North Queensland who could be on this board?
I think all board appointments are a matter for government, Senator.
Minister, some of these positions have been vacant for months. Is there a reason it's so hard to find a Queenslander to go on this board for months?
I'm sure there's not. I'm sure the Minister's working through a process.
Who's been leading the recruitment process for the board membership? Is that something the department's doing or the Minister's doing on his own? Or
The department supports the Minister with board appointments.
See, last time I was asking some questions about the appointment of the chair, and what transpired was that no recruitment consultant had been engaged, and that was the decision of the then Minister, Mr Pitt, to appoint a chair being paid, I think, about $150,000 a year to a several billion-dollar body of government. And what we learned at estimates last time was that the Minister was actually the one consulting people, effectively coming up with a shortlist. Is that what's happening now as well?
The department supports the Minister and can provide candidates, and those candidates can come from a range of sources, including the company board directors, women on boards, and then...
So what's happened here, though? Has the department, independently of the Minister, or at the request of the Minister, provided a list of possible nominees to the Minister?
I can check that for you. I'll check if my colleague has any further detail for you.
Thanks.
And just whilst that's occurring, Senator Watt, just to give you a gentle nudge, so we're getting towards 11.
Am I the only one who's going to have questions?
You have the time.
Yeah.
Okay, thanks. I'm conscious we're coming up against time. So how did you go?
So we've supported the Minister by providing some names of candidates and coming from a range of sources, including the women on boards candidates and company directors, and then those processes, their cabinet processes for appointments that are taking place.
Okay, so the department's provided a list of names and it's now with the Minister, essentially. Okay. The new chair, Ms Hayes, it's a matter of public record that she ran as a candidate for the Country Liberal Party in the Northern Territory election most recently. Ms Copping, has Ms Hayes brought any change of approach to the operations of the NAIF since she started as the chair?
Senator, the way that we assess investments hasn't changed. We continue to progress them for consideration through investment committee and up to board, and that has not changed since Ms Hayes started in the role as chair.
So would you say there's been any change at all in terms of how staff have been asked to approach investment decisions, how advice is provided, or is it just exactly the same as it's always been?
We have the same process that it's been, Senator.
Right. Just in the remaining few minutes I've got, I might ask the questions that I usually ask and that I suspect you've got some answers for about how we're going with distributing funding. Some of these I'll have to put on notice due to lack of time, but can you give us the most recent, prior to today, I think the most recent figures we had from the NAIF were from a question on notice, number 4074, which said that as at the 31st of August 2021, the total cumulative disbursements for the NAIF were $398 million. Can you give me the current, most up-to-date figure for that, please?
Sure, Senator, and disbursement meant drawdown. So as at the 30th September 2021, there was $427.6 million drawn down.
427.6 million.
Yes, Senator.
Okay. So that's been about 30 million in that month. Are you able to break that down by state for me?
I would have to take that one on notice, Senator, to provide more detail.
Okay. You don't have a figure, say, just for Queensland or just for WA or just for the Northern Territory?
Senator, I would have to take that on notice.
Okay. Could you also take on notice, basically, if you could give me an updated list of projects that have drawn down funds, updated since that question on notice, please?
Yes, Senator.
And in terms of staffing of the NAIF, as I said earlier, according to the annual report, as at the 30th of June 2021, the NAIF had 30 employees. Does that include management?
Yes, Senator.
It does. Okay. And 15 of those employees of the Northern Australia Infrastructure Facility are based in Sydney. Is that where you're based as well, Ms Copping?
So yes, 50, as at June 21, 15 of the employees were based in Sydney, yes.
Okay, and that's where you're based?
Yes, that is correct, Senator.
Okay. And Minister, again, probably best put to you, what the annual report tells us is that there are actually more staff of the Northern Australia Infrastructure Facility based in Sydney than there are in the entirety of Northern Australia. Do you think that's a problem?
Senator, I always like to see staff out in the communities that they're serving, but organisations, for a variety of reasons, make decisions about who they employ and where those employees are located. And that would be a matter, given the independence of the NAIF organisation, a matter for the NAIF board and their CEO.
But you have a lot to say about how your government's doing such a great job of regionalising public service jobs. Doesn't it seem a little ironic that half the staff of the Northern Australia Infrastructure Facility are based in Sydney and more are in Sydney than across all of Northern Australia?
Well, I have answered the question, but the NAIF's actual mandate is to support the growth of jobs in local communities around supporting a variety of innovative projects right across Northern Australia. So it's not just the jobs within the NAIF that we're looking at, but I think it's important that we look at the work of the NAIF in actually growing employment opportunities, in rewarding sustainable careers across Northern Australia over this period and beyond.
Ms Copping, I know you've taken on notice the state-by-state breakdown. Ordinarily, if Mr Wade was appearing here, he would normally have an opening statement which has that detail in it. Obviously, he isn't here, and you probably weren't expecting to be appearing at estimates a day or two ago, but you definitely haven't got access to those figures for a state-by-state breakdown now?
I would like to take that on notice. I'll check Senator, but I'd take that on notice.
Okie doke. I think I've got about 1 or 2 minutes left. Okay. So there are, as at the 30th of June 2021, there were 50 employees of the NAIF. Would that include vacant positions?
I'll have to take that on notice, Senator.
Okay. Could you please provide the number of current vacancies at the NAIF and a list of what those vacancies are? Again, on notice.
Yes, sir.
And actually, this is, I think, a worthwhile question to end the night. There obviously were some pretty significant amendments made to the NAIF legislation not that long ago with the opposition's support. And in fact, a number of them were things that we had been calling for some time. Are you able to sort of describe what impact those changes have had?
Sure, Senator. Give an example of 3 main changes. So firstly, the ability to provide equity. We have received and continue to assess a number of opportunities to invest equity, and we have one deal that is in the due diligence phase, having passed strategic assessment. The next area is financing partnerships, and the ability to on-lend finance to partners who are able to provide small loans to smaller projects, a key part of the reforms. It is public that NAIF is working with the Northern Territory Government through the Northern Territory Jobs Fund to explore the ability to provide small loans in that jurisdiction. We are also in discussions with parties in both Western Australia and Queensland to roll out financing partnerships there. And finally, direct financing. We have made investment decisions for deals that will have direct financing, including Alliance Aviation Services.
Thanks. I just noticed that Ms Lee has been patiently waiting, so I might just put one on notice for her, because we're now at time. Sorry, Ms Lee, I only just noticed you there on the screen. Would you, probably the most useful thing I could ask for from you, if you could just on notice provide us with a bit of an update on what progress has been made with the various budget announcements that the government made in the most recent budget, the new 5-year plan. Just interested in how that's all going and what's actually happened. And can I also just thank Ms Copping for appearing tonight, given that was probably not what she expected to be doing a couple of days ago. I appreciate you doing that.
Thank you. I'm glad you made that comment, generous comments and whatnot. I'd just like to echo that, Ms Copping. I read your little CV on the NAIF website whilst we were here, and I do wish you all the best in the acting role. You're eminently qualified, and your commitment to the organisation shone brightly through your testimony this evening in front of Estimate. So all the best to you.
Thank you.
There being no further questions at this time, the committee's consideration of the 2021-22 budget estimates will conclude. I thank Minister Mackenzie and officers of the Industry, Science, Energy and Resources portfolio who have given evidence to the committee today. Thank you also to Hansard Broadcasting and the committee secretariat. I declare the hearing adjourned.
Bravo.